Good morning, everyone, and welcome to another beautiful day here in Manatee County. We love the cold weather. I'm sure some do, some don't. I do, but but it's a nice day, another nice day. And thank you for being here for the Board of County Commissioners Thursday, December 12th, 2024 land use meeting. As we do at every one of our meetings, we start them off by praying to our Lord and pledging to our great nation. And this morning we have the opportunity to have Pastor Wendy Thompson of Glory Cloud Ministries to do our invocation. Thank you, ma'am. And Commissioner Tal Sadiq will do our pledge this morning. So if everyone could please rise for the invocation and the pledge.
Good morning. What a beautiful day in the Lord. And Father, I just want to thank you for all the miracles you did and all the miracles you're about to do. And Lord, I thank you for your presence. I thank you, Lord, for the Holy Ghost being here and touching hearts and touching minds and bringing in unity. And I ask you, Lord, to bring in solution to problems, guide them and lead them and direct them, Father, in your wisdom, in your direction. I thank you, Father, as your word says, if we seek ye first the kingdom of God, and all these other things and his righteousness will come to pass. And I thank you, Lord, that there'll be great peace. I thank you, Father, for restoring the hope to people that have lost things. I thank you, Lord, that your love and your peace and your joy will be so strong in this meeting and in their lives from this day forward, Father. And we give you all the glory and honor and praise in Jesus' name. Amen.
Amen.
Hallelujah.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, Pastor, for your prayer this morning, and we appreciate you being here. Thank you, Commissioner Sadiq, for leading us in the pledge. Ms. Knapp, is there any updates to the agenda?
Good morning, Commissioners. Yes, there has. Updates were published yesterday afternoon, and this morning there are 3 additional public comments regarding item number 16, which is the Kraton rezone, and they're being entered into the record at this time. And that concludes your changes.
Thank you, ma'am. Appreciate it. Next part of the conversation or the meeting is the citizens' comment on considered on future agenda items. We do have a 30-minute time limit for this item, and if there is anyone who'd like to come forward and give citizen comment, I will pull up their names right now on the board. And we have 2 speakers. The first is Dalton Nelson. Sir, please state your name, county residence, and you have 3 minutes, sir.
Good morning, Dalton Nelson, Manatee County resident. I would like to take a moment to thank Commissioner Bearden for his motions last Tuesday. I think that's a big step in the right direction. To start correcting the failures of the past, a past riddled with eggshells that we've walked around, treading ever so lightly as to not risk litigation over supposed action to be done in good faith of Manatee County's residents. To promote healthy county growth, I understand that the county is going to continue to grow through the dismay of some of us as to how fast and the steps taken to obtain such growth. I ask at what cost? This new development at the end of 675 Palmetto Bluff is going to be a nightmare. The Pope Ranch development is going to devastate at least 30 homes in the close surrounding area. But because, as of no fault of this board or the last board, whatever the case may be, it is legal to do so, and it's inevitably going to pass. So with that being said, it's going to come at the cost and expense of thousands of dollars to the private taxpayers of this county that have worked their entire lives to build everything that they have, and it has been long overdue for this board to start making decisions and lobbying on behalf of the citizens and not the developers of this county. I'm not an environmental activist by any means, but the amount of tributaries being impacted on, the wetlands and floodplains being built on and choked up, the drainage ditches and creeks and canals not being maintained, and the county not adequately being equipped to do so is wrong. The cause of all this flooding that we experienced on Monday, August 5th, 2024 is due to these reasons. Why is there still no answers for the blaring discrepancies between 2003 and 2024? It was the same incident, the exact same details, the exact same facts, and we still have no answers as to those questions. Why were they handled 180 degrees from each other? Why were the decisions made? We need to have more information before we approve these projects in District 1. Thank you.
Thank you, sir. Next up is Mr. Glenn Gibolina. Good morning, sir. State your name, county residence, and you have 3 minutes, sir.
Good morning, Glenn Gibolina. For the record, I agree with the gentleman before me wholeheartedly. So I wanted to bring up that, we are growing exponentially out of control. I wrote everybody this letter last night. You should have a copy of it. But I wanted to go over what quasi-judicial means, because maybe a lot of folks don't need it. This is an application. And by the way, that's a law firm out of Lakewood Ranch, so they know what they're talking about. And you have to respect the general public in all of things that you consider. You're the judge and the jury. We're the jury. You have to give us equal time and rate us as the participants. And we don't have to be experts. If I tell you there's a traffic problem, I don't need to come with a traffic study. You have to take my word at it. Let's talk about moratoriums, right? I'm talking about this. It's done all over the state. You just have to have the vision to move forward to do it. This was last week. Edgewater moves forward for a building moratorium. It's not of the taking. It's a pause on development. And that's the direction we should be going, right? If you want to understand it, it's just, public safety is number one. If you got a single road and you're putting 10,000 cars on it, you're putting the rest of the citizens in danger. You can't do that. If there's a flooding problem, you have to put a pause on development. If there's less green spaces and more asphalt, and there's no green spaces, you have to put a pause on it. If the infrastructure's not there, you have a right to put a pause on development for up to 180 days without the Bert Harris. That will not kick in, despite what the developers say, despite what even your own council may say. That is simply not true. You can pause development today, right now, before you go forward. That's what a moratorium does. And quite frankly, if you want to, I would even help in this direction. So Mr. Meehan and I have decided if you need a Doge here in Manatee County, we're your guys. We'll look out for you. But overdevelopment, it's out of control. You need to put a pause on it, and you need to respect. We are the jury. You're the judge, but we are the jury. Thank you.
Thank you, sir. All right, is there anyone else in the audience like to come forward and give public comment this morning? Yes, sir. Please state your name, county of residence, and you have 3 minutes, sir.
Keith Green, Manatee County. Initially, I wasn't going to speak, but I wanted to kind of just state something for the record. I do not honestly agree with the previous speaker's notion of a development moratorium, because I believe that if something like that were to happen, what that could potentially cause is an immediate situation to where that would hurt our local economy. Though I understand the concerns of traffic, but as someone who is originally from Northern Virginia, who has witnessed what traffic can do, I'd say, any day is a good day above ground, in my opinion. So I take it for the good and for the bad. But what a moratorium would basically cause would hurt our local economy and put a lot of people out of jobs. So that is the situation that would cause, and long term, that would cause a lot of our first responders and others who are not able to afford to live here leave. So as someone who lives in an area that's still under development, and speaking from experience of this, I just feel that a moratorium of sorts would be a bad idea. Thank you.
Thank you, sir. All right, is anyone else in the audience like to come forward and give public comment? See, now I'll go to the phones. Is there anyone on the phone that would like to give public comment this morning?
We have one caller at this time ending in 069.
Caller 069. Please state your name, county of residence, and you have 3 minutes. Caller 069. Going once. Caller 069, going twice. Caller 069.
Yes, good morning.
Yes,
Good
sir.
morning.
Please state your
My
name.
is
Please state your name and
Mark
county of
Mandarin,
residence.
Manatee County.
Okay.
And, yeah, I want to further agree with the comments from Nelson and Gibellina. And I disagree with the comments from Mr. Green, in that a moratorium, if properly structured and executed, would not in fact have an immediate negative impact on the local economy. In fact, it would have a short near-term beneficial effect on the economy, I believe. And I think there's a way to go about it properly to where it would benefit, the benefits would far outweigh any negative aspects. And again, you know, moratorium is not a forever thing. It's a time to take a step back and assess what's been done, assess the developments that have already been approved for development, assess the rezoning that's already been approved. And, you know, some of those developments will continue under construction. But I would say that certainly no more rezoning should occur until a overall assessment is done, especially with regards to stormwater control and the flooding that we've seen in this past rainy season and hurricane season. All my neighbors have been affected out on Waterline Road out in East County, negatively affected in a bad and in a very severe way. And it can only be attributed to the large extent on the overdevelopment and clear cutting that's been occurring. Thank you very much.
Thank you, sir. Are there any other callers on the line?
None, Mr. Chair.
All right, thank you very much. Seeing that, I'll go ahead and close public comment, and we'll move on to citizen comment on consent agenda items only. Is there anyone like to come forward and give a public comment on consent items only? Huh? We have one item on consent, believe it or not, and that's the clerk. Is there any public comment on consent? Is there anyone on the phone that would like to give public comment on consent? We've had
No hands raised, Mr. Chair.
All right, thank you. I'll close public comment on consent. Now we'll move to the consent agenda. We have asked, Commissioner McCann has asked for items 2 and 5 to be pulled, correct? 2 and 6. 2 and 6, sorry, 2 and 6, all right. So I'd ask, we'll pull those, and I'd like to ask for a motion to approve the consent agenda.
So moved.
Second?
Comfortable with that one item?
That one item, we got to approve it.
Except there's two items. One item. Oh,
There's one item, it's approval of the clerk's consent agenda dated December 12, 2024. All right. Motion was moved by Commissioner Sadiq, seconded by Commissioner Ballard. Everyone cast their votes at this time. And the motion carries 7-0. I think that's the shortest consent agenda I've ever seen. Now we're going to move to items that have been removed from the consent agenda for presentation. I'm going to ask Madam Clerk if she will swear in anyone that is going to speak to any item today that is a quasi-item. You need to be sworn in. So if you please stand, and the clerk will swear you in.
Factual statements and representations you will present to the board are truthful and accurate.
All right, thank you very much, Madam Clerk. Also, with regards to quasi, there is no call-in comments on quasi, only on legislative. So then we will not be going to the phones. All right, the first item up is item number 3, approval final plat North River Ranch. Ms. Knapp, will you please read the item into the record?
Item number 3 is approval of final plat North River Ranch Phases 4E and 4F.
All right, thank you, ma'am. All right, has there been any ex parte regarding item number 3? All right, seeing none. Applicant? You're up.
Good morning, Mr. Chairman. My name is Ed Vogler. I have been sworn. I'm a Manatee County resident. I'm here with John Neal, and John and his partners are the landowners of this parcel that is subject to a plat. I must say it's the first time I've had a chance to address the board on a matter of platting, and I'm glad to do so. Platting is largely managed by state law, and it is largely a surveyor discipline. The case law that relates to platting identifies it as a ministerial act that is administered by local government. And so in this case, you've had a highly reviewed document. The platting process in Manatee County is rigorous. It takes weeks and months. It is reviewed by surveyors employed by the county as well as engineers. And so the demonstration for staff support of a plat requires that you confirm consistency with the final site plan for any given project. Now, all of this is placed upon the shoulders of a comprehensive set of approvals for the development of land. North River Ranch was approved initially in 2014. We have zoning approval, a general development plan approved, authorizing in excess of 5,000 residential units. We have entered into a local development agreement with Manatee County. You have, along with us, formed a community development district, which has now been merged into a stewardship district created by the Florida legislature. So all of this precedes the plat that we're here for today. And this is one of, I think, 16 plats that have been previously approved for this very successful project. And we're very proud of this enterprise. We appreciate the opportunity to work with your staff. We think this is administrative and ministerial, and while the board has the final say, there is not a lot of discretion on these matters, and we ask that you act on it today. Thank you.
Thank you, sir. Are there any questions of the applicant? Commissioner Felch, you're on the board. Do you want to ask a question of the applicant? Oh, yeah, okay. All right, thank you very much. Staff presentation. Who's here for staff? Okay.
All right. Good morning. My name is Greg Krause. Lots of new faces up here. Probably a new face to you as well.
Can you state whether you're sworn or not?
You've been sworn.
Yes, I was sworn in.
Thank you.
Okay, so for this is a final plat for North River Ranch, Phase 4E and 4F. The final plat consists of 239 single-family residential lots in District 1. The general location is west of US 301, south of Buckeye Road, and north of Moccasin Wallow Road. On April 5th, 2019, the Board of County Commissioners approved ordinance PDMU 1726ZG, formerly known as Havel Farms. This ordinance approved entitlements for 3,842 single-family detached and attached units. On January 6, 2024, a final site plan was approved under FSP 2339 for those 239 units of the ordinance's already approved 3,842 units. The future land use category is Urban Fringe 3. The zoning district is planned development mixed use, and the parcel is approximately 101 acres. That is all I have for you. Any questions?
Thanks, sir. Are there any questions of staff regarding this item? All right, thank you very much. Seeing no one's on the board, thank you. Thank you, staff. We do open for public comment. I have one speaker, Mr. G. Molina. Please state your name, county residence. You have 3 minutes. I don't think I have to tell you that every time, do I?
Glenn Gilbina for the record, and I have been sworn. Another 500 cars. Where are they going to go? It just blows me away that we have a project that has issued a certificate level of service. Mass transit? Is there mass transit out there? Although it's been approved. How does that work? Please, someone tell me how mass transit works out there, along with the school facilities and the parks. You got to put a pause on this stuff. And despite what the attorney said, it's an application, okay? They're here for an application. I pointed that out in this quasi-judicial handout that I sent you all. So don't mistake that they're entitled to it. They're here for an application approval. That's all they are. 500 more cars, right, on top of the 5,000 they're already building. It's just too much. It is absolutely too much. And really, they don't tell us where the park's at. They don't tell, is that another lift station we got to put in there for what, $1 million? It's just crazy. The roads aren't ready. The infrastructures aren't ready. Nothing's ready except 500 more cars. Thank you.
Thank you, sir. All right, on the board I have Commissioner Cruz. Commissioner Phelps, you took yourself down? Did you take yourself down? You said you didn't want to speak. Oh, you want to speak now? Okay. All right, Commissioner Phelps.
I did have this item removed from the consent agenda for several reasons, and I will continue to do so for any land use items that are quasi-judicial. I've instructed staff. Regardless of what the item is, I can basically tell you that there was no consent from this current commissioner. In fact, this was probably a situation that I could see we would have a problem in the future. So you will see items that are of land use will not be in District 1, will not be on the consent agenda, and will require a presentation. I also do not find it conducive to transparency and accountability for us to have quasi-judicial items on a consent agenda. When I have found out what the criteria for putting certain things on consent agenda I was not too happy with that, because this is an opportunity for us to have a trial, so to speak, to hear both sides of things. And my job is to represent all the current residents of District 1. And many of us are here right now because of the decisions that were made in the past. We have spoke very much about the issues with our infrastructure not being ready to support these items. And in the process, and I agree, this has gone through a process, it has had all kinds of inspections and things like that, but we have to react to what the current conditions are. We have not completed Moccasin Wallow Road. We have schools that are overcrowded. We have other items also on the agenda, and this is a quasi-judicial situation to make a decision on that our public has not even had the opportunity, because we haven't been very transparent or conducive to that in the past. I know what my citizens in District 1 want. I know what my citizens in District 1 need. They are here speaking right now. I am not anti-development. I want to make that clear. It is a wonderful opportunity that we have for people to make a living, for people to build houses. But the responsibility is on the commissioners to make this a quality of life and home for these people, long-term homes for these people. We have to have safe streets. We have to have adequate schools. We have to have our policemen, our firemen, our school teachers, our nurses, our doctors. We have to have those things to make the houses that you're building homes and homes where people stay and feel safe and want to be part of the community. Right now, we have not completed Moccasin Wallow Road. As a matter of fact, it's behind schedule. We have problems with it. We don't have the schools already built, so this site plan that may have gone through all the motions probably would need to be revisited based on our current needs, our current traffic studies, and things that have changed. An economic impact, we had 3 hurricanes. Don't you think there's enough work out there to get things done? I personally cannot get a roofer to come out to my house. And this is another reason why we have to have some sort of measurement of these economic factors. Maybe some of those roofs from Ian have not been able to get repaired because we can't get roofers to come out to do a single-family home because they're making more money building 5,000 new houses out there. We've streamlined so much of things, as I've said. You know, what's the saying? You want it cheap, fast, or good. Don't we all want it good? And sometimes you have to look at the current circumstances. We're going to have jobs out there. There are roads to build. There's rebuilding on our islands. And what we want to do is provide you with a community where the homes that you built are homes. And I think if you'll work with us on that and realize that this is a new commission. We did not consent to many of the things in the past, and that's why I'm here. So I think we have an opportunity to work together to make sure that we are providing you with places to build these homes in which the people who move in have a quality of life. And our obligation at this point right now is to answer to the people who elected us, the people that are paying our salaries right now. And I look at a map of these places, and if I don't see anything built, there's nobody living there right now. Right now. And that's who we have to answer to. So my vote will probably be a no. And let's come up with a better idea. Let's work together. I have no problem with working with any of our developers. But this is for your benefit too. We want your communities to have good schools. We want your communities to have good roads. We don't want people moving here and getting killed on our highways. That's not fair. That's not quality of life. Thank you.
Thank you, ma'am. Commissioner Cruz.
Yeah, I mean, I love the enthusiasm, and I agree how the campaigns went. And I wish this board was here 12 months ago, and we were working on wetlands and things way, way, way out east where they shouldn't have been. But when you run for any office, when you take any job, you still have to conform with what happened before you. Sometimes that's unfortunate. Sometimes you disagree with it, and that's what led you to look for that job or run for that office. But you still legally have to adhere to and respect what happened before you, even if you disagree with it. This is a final plat. Now, I know this is looked upon as an opportunity to correct what you feel is an error in the past, but it's not. We have a lot of opportunity in the future. Look, this agenda is freaking massive. You have lots of opportunity to correct errors in the way this board's been thinking for future projects, but this project's approved. I wasn't here. None of us were here when this project was approved, but it was approved. And the ingresses and egresses were approved, and the open spaces were approved. This is just letting everybody know this is where I'm going to put the stuff you already told me I can put. Declining a final plat is the equivalent of if I went to build a house in a subdivision and I went to the HOA to approve what color I'm going to paint the house, they said, I'm not going to approve any color for your house because that's going to keep you from building your house. That's not a right they have. And in state statute, they already have a preliminary plat. This is the final plat. In state statute, they can start building now without your approval. We could all vote no. This could be a 7-0 no vote. They're allowed to start pulling permits on, was it 50% or 75%? Or because we have open range in terms of how many spec homes you build. They may not be able to sell those homes, but they can build them. They can pave over stuff. They can put roads in there today without this approval. A 7-0 no vote is going to create over 100 potential homes in there. They may not be able to sell them. And there's people that's probably under contract ready to buy them for their families. But again, I'm with you. I think we need to have a meaningful discussion, on January 7th, which is a strategy session, to let each other know and to let the public know and let the future applicants know our mindset on how we're going to take each land use application going forward. And it's going to be different than how it's been in the past. I agree with that. I 100% agree with that. But there's a time and place for taking a stand, and a final plat just isn't one. There's a reason it's on consent. This is administrative. It's not really, we're being asked to approve it simply because the state's like, well, just have somebody check a box. This ship has sailed. This isn't the hill we're dying on because you can't. So I agree with your excitement, but I disagree with how you're going about doing it, because it's not going to be successful at the end of the day. A 7-0 vote is still going to get 200 and something homes built on this property at some point in time. It just is. So I don't think plats are where you want to start the fight, but I'm with you on the fight you're trying to have going forward when somebody comes to us with another piece of land that isn't platted yet and isn't approved for anything, but not at the plat level. I just disagree with this being the avenue to take to start fighting your battle.
Thank you, sir. Commissioner Feltz.
I appreciate Commissioner Cruz doing this. And the point of what I was saying is exactly to elicit that, okay? I didn't set you up, but I appreciate that. Because this is what my constituents wanted me to say up here. And that is the other side of the coin that was very well executed. And I want my citizens to listen to that. Because there isn't a magic wand here. There are things that we can and we cannot do. So I answered to my citizens. I said what they wanted me to say. And I appreciate Commissioner Cruz explaining to us all that there are some things that we can't do. And I understand that. But I did it anyway. And that was a very reasonable explanation as to why some things can't be done. But we're going to go through that explanation so that we have a fair and equal ground for people to understand how things work, because they don't. I appreciate that, Commissioner Cruz. My point has been made, and so is yours. Thank you.
Thank you, ma'am. Commissioner Bearden.
Thank you, Mr. Chair. I appreciate comments from both sides, Commissioner Cruz and Commissioner Feltz. But I think I'm going to agree with Commissioner Feltz on this one. There's going to have to be a time in regards to taking a stand. And guess what? Look, people are going to vote the way they're going to vote, okay? If there's 3 that are willing to take a stand, or 4 that are willing to take a stand, or 5 willing to take a stand, or 2 or 1, just like with Commissioner Cruz on some issues, he was willing to take a stand. He was a lone vote on particular issues, okay? He took that stand, all right? But as we get more to take the stand, guess what? A point is going to come across in a way that we want our roads built first. See, if this was before 2011, I probably wouldn't have an issue with this. Because guess what? My roads would have been built, my parts would have been in place, my schools would have been built, and guess what? Everything would have been awesome. Because we would have built our infrastructure first before we did the development. So, I think now people who maybe once were ignorant about certain situations because people were not educating them on the reasons why things were happening the way that they were, are now becoming educated. And so, okay, if we make the point that if we did vote this down today, that 50 to 60% of the homes might only be built, and then also they might be able to build the roads today. I like how you said that, Commissioner Cruz, that they could still build the roads, even though, this was, possibly voted down today. So again, it's time to reverse the curse of sitting in traffic day in, day out, And it's time to take a stand and be bold. Our constituents who voted us in office today, we all voted, we need smarter growth, we need better infrastructure. We stood up and campaigned on that issue. Every one of us up here. So, my question to you is, are you going to take a stand today? And are you going to continue to take a stand? Or we might be just operating with a 4-person board or a 3-person board or a 5-person board, whoever decides to take this stand for the constituents. Because I promise you right now, I'll vote no on every project for the next 24 months while I'm in office, even if I'm not in office again, just to prove a point. So who's going to be with me? I will do that. I promise you, I don't care. You talk about die on a hill, well, I'm going to die on this one. You talk about, I'm the wrong person to talk about dying on a hill because I will die on that hill. I'll stand there until the last breath is taken. So, let's be real, and let's do what the constituents want. That's all I ask for this board. Thank you, Mr. Chair.
Yes, sir. Commissioner Sadiq.
Great enthusiasm. I haven't had my coffee yet, so we're going to get wired up today. But I think of all the commissioners on this board, I don't think anyone on this board really has the same level of experience on the other side as George and I. I'll speak for us. You, George, but you're welcome to cut me off too if you'd like. Because the developers spent a lot of money against us. They made it very personal. They dragged my wife into things. They dragged my family into things. Dragged George and his family into some very uncomfortable issues and things that, frankly, they didn't belong into. And a lot of those guys are sitting in this room today. So if you want to go to war with developers, I'm certainly on board with you. There's a great item on this agenda you probably want to have some input on. But final plats are not that area. And this board, in my perspective on things, considering I've taken a significant amount of hits in a very short amount of time over a very lengthy campaign, and I'm not going to make this about campaigning, is that we're going to have a new chairman, we're going to have a new day come January 1st, 2025, to really reevaluate our approach and how we want to see development happen. As a commissioner for the 3rd District, where frankly a lot of the development and the impact is felt in the increase in traffic and roads that frankly have not been invested in for a long time, not to mention the fact that we have everything between myself, 4 and 2 as well, all the businesses, all the hospitals, schools, all the amenities, we have all that. So we feel that pain very acutely as well. But I do believe that this isn't the time for holding up good business. I also don't think this is the right item to do it. I also think it's also incumbent upon us to educate the public on what exactly plats are and where exactly they can have input on the process. I do appreciate and commend Commissioner Cruz on putting up the Citizens Academy, which does just that. I had that opportunity with Leadership Manatee, and I'm certainly going to be pushing that for many of our youth in the community as well, so they can get involved the right way. But I don't think final plats are the place you do it, so I'd like to make a motion to approve this item.
I'll second it.
Okay. Commissioner Bearden was on the board prior to it, so Commissioner Bearden.
Thank you, Mr. Chair. Well, we're looking at 3,842 units in this particular development that was voted on in 2019. It had nothing to do with this particular board at all. However, we have an opportunity to take a stand, ladies and gentlemen. And I would appreciate that you guys would take that stand and know that you have the opportunity because it is a vote today. It's a vote today. And so, you know, if this thing gets approved, then you can sleep at night and say, you know what, I just added another 3,000 cars on the road on Moccasin Wallow. How many head-on collisions are we going to have on that road before people wake up? How many? How many more deaths are going to happen on that road before we wake up as a commission? And I am passionate. The reason why I'm passionate, because I don't want to see another death on that road, and everybody knows in this room. Come on. We all know the traffic that's been happening, and the deaths and the wrecks that have been happening on that road. We hear it every day. And we hear it from our constituents every single day. And it has nothing to do with the builders. I mean, heck, there was a lot of money that was thrown against me to get me defeated in office as well. I think there was probably $250,000 that was spent to beat me. And so it ain't got nothing to do with developers. It's got everything to do with the safety and welfare and the constitutional rights of the people, to protect them. That's my job, is to protect our citizens. And I have to sit here today and protect my citizens by voting no on every project that comes across this board to make a point. Even if I agree with it or not, I will. And we can sit here in silence and let us contemplate on really what's going on. So maybe that will sink in so we can think of doing what's right and not what's popular.
Commissioner Ron,
Yes, ma'am.
I've been trying to
I'm
get
on the floor. Ma'am, I'm on the floor.
I've been
I
trying
have
to get on the
floor.
board.
I have the floor. Please. Please. I'm not finished yet. You can put yourself on the board.
I can't put myself on the board. That's what I'm saying.
Okay,
Just wait a second.
please.
Our board's not reacting, so people, I can't stop, I can't even recognize people on the board. So I don't know what's going on with it. I click on somebody, or I click to stop someone, it doesn't do anything. You got it? Okay. Commissioner Beer, we're just trying to fix the board.
Got it. Thank you, Mr. Chair.
Go ahead, sir.
I'm more concerned about the safety and welfare of my constituents than putting homes in areas where roads need to be built. They're inadequate, and I'm tired of it. So, if we can come up with a solution on how to develop my roads first, you could probably start seeing yes votes from me. Thank you, Mr. Chair.
Hey, David, it's still not doing it today. I can't click on her because I can't get you off the board.
Well, I think Amanda was also on the board.
Are you off the board, Commissioner Phelps?
I think you were on the board first.
You
I
may
just
go first.
wasn't able
If
to
you'd like to go
click it.
first, I've already spoke. Would
Thank
like
you,
to go
Commissioner.
first?
So I will agree with Commissioners Cruz and Sadiq regarding the time and place to move forward with taking a stand on issues relating to development. When I came on the board, there was a policy that was put in place by a prior board called 2.1.2.8, which allowed for development east of the FDAB. I did not agree with that policy. I still don't agree with that policy. I would not have voted for that policy. At the time, there was not the votes to overturn that policy, and so it had created entitlements that didn't exist. And I think that already existed prior to my election. I think that this is a similar situation. Those entitlements were created before any of us were ever sitting on this board. This is not the time, this is not the place. I'm happy to rethink as we go forward, the pace of development, all of those things, but a final plat is not the way to do it. Commissioner Bearden, I would ask that you please be respectful, be civil. If people disagree with you, it's not personal.
And that's all I have to say for now. Thank you.
I'm up next anyway, you could wait.
Commissioner Feltz.
Okay, let's hope. we're
Commissioner
on
Feltz,
there.
you are up.
Thank you. I totally understand that we're saying this is not the hill to die on, but this is my district. It's my district. I have lived in Manatee County probably longer than anybody else on this board. I own land, and this is my district. And we are sending a message that we are going to stand up for things. We may be getting voted out. I appreciate Commissioner Bearden's passion, but you could bring it down a notch. And, well, be nice. But this is something, you know, I mean, some of us have built a career and a campaign for lack of a second. I find that admirable, and I'll be consistent. I cannot go back to my constituents and say, I didn't vote no on this, because that is what they asked me to do. I have my marching orders, and it may not be the right time or the right place, but it definitely, as I said, it evoked the discussion. Commissioner Cruz did a very good job of explaining, well, you go to 77,000 people in District 1 and explain that, but there are cases where you stand on principle, and that's where I'm going right now. My District 1 voters have instructed me to just say no. Just say no. And this is my district, and when the time comes, and I could recall when we go back to the 2.1.2.8, or we go back to moving the FDAB, do you know what we were told then? It's just a transmittal. Yeah, it's just a site plan. These are not just things. These are people's quality of life, their livelihood. We have to look at everything as, is this for the overall benefit of the public right now? Not 2 years ago when we brought it through, but right now we have to look at things. We went through 3 hurricanes. We have an economic rebuild to do all over our county. We're approving a site plan. Why are we approving a site plan when we have schools with portables? Is the school already built that is going to bring these children into a quality education according to this site plan? Are we going to have roads? Are we going to have our first responders? That today, I'll make a statement. I may get outvoted. Some of us are okay with going on with the lack of a second. But this is my district. We have not had representation in my district. My district has been the subject of way too much rezoning, way too much incomplete capital improvement projects, way too many deaths on our highways, way too many people who are saying, please stop and let's rethink this and let's do it right. So if it's a statement, it's a statement, but it's my district, and it's what my constituents are saying that they want in my district, and that's for Carol Feltz to sit up here and say no.
Thank you, ma'am. Mr. Bearden.
Thank you, Mr. Chair. And, you know, I'm actually very passionate, and I actually believe in what I say, and that was proven when I first got elected when Taylor Ranch, that I didn't vote for Taylor Ranch, but, you know, you did. So, I mean, let's just be real here. It's time. It's time. And, you know, if we're going to be, if we're going to sit here and talk about doing the right thing, let's just do the right thing. And I don't, you know, and if that's, we need to put our roads in first, that's doing the right thing, putting our roads in first, okay? So, you know, I'm just very passionate. I actually believe in what I say. I'm not, yeah, I guess you wouldn't say I'm a polished politician. And you know, quite frankly, I don't want to be a polished politician. So, thank you, Mr. Chair.
Thank you. All right. There was a motion made.
Mr. Chairman, I'm sorry.
It's
I think,
yes, I'm sorry.
I think I need to have a rebuttal,
Yes,
right?
yes, sir. Applicant?
Oh.
Yes, sir.
Then I will do that. Ed Vogler, I've been sworn. These comments are made for the record because the records are important. One of the things about quasi-judicial decisions is they need to, by law, be made on a case-by-case basis. And that's an important consideration for the board because you look at the record, you look at the facts of each matter. And the broad statements of policy goals and orientations are wise. That's what boards do. And I just want you to know, commissioners, and these comments that have been made, that at least for myself and my clients, we want to collaborate with you. It is a collaborative effort. Every project is a collaboration. There's goal settings and there's markets to consider, and it is collaboration. And just if you'll excuse me for a second, I've been doing this for 42 years in Manatee County. There's a lot of people on the wall back there that have served as chairman, have sat here, and with a lot of different boards and a lot of different influences, and we understand. We understand. And when there are elections and there are policy goals that are articulated by the citizenry, we respect that too. But we're asking you today to respect the process that we've been engaged in, consistent with state law and your ordinances for an extended period of time. And I don't think you can ignore that. And I suggest maybe you ask the county attorney what her thoughts are on that. But in terms of the record for this project, our roads are built. Our roads are built. Moccasin Wallow Road is a fully funded project from I-75 to US 301. It is fully funded, and the final leg of it is out for bid right now and is going to be constructed. We have what is called in the land use world a vested project. We have a local development agreement where we have a certificate of level of service compliance, and that demonstrates the existence of infrastructure in place at the time. We have deeded a 40-acre site to the school district in this project, right next to this land, deeded. The school district and board is not allowed to commence the building a new school until the demand in the neighborhood exists. They're doing that, and that's why we deeded the land to them. So there isn't in this matter any record evidence that would support a denial vote. And so we respectfully ask that you observe the record, you observe the rules of quasi-judicial proceedings, and vote in favor of this matter today.
Thank you, sir. Commissioner Bearden's back on the board.
Mr. Vogler?
Yes.
Can you come on? So, to get a yes out of me, would you allow Moccasin Wallow to be fully built out before, in that area, before we issue out a CO? Before you issue out, your client issues out a CO?
Well, we can't do that.
Okay.
Because we, you know, even if I supported that policy goal, you know, I couldn't do that, all right? Because
Well,
where
I would
it
have
is-
to, I would disagree with you on that, because we just had a client that, or I'm sorry, an applicant that came up a couple weeks ago, and we made that deal here on the dais in regards to him not, issuing out a CO until the road was built.
I'll bet it wasn't a Plat. I don't know,
Yeah.
but it wasn't a Plat. So, I understand.
I appreciate you, Mr.
No,
Bowler.
I do. I understand. It is a collaboration.
Madam Attorney, would you like to comment?
Yes, Mr. Chair. Today,
Turn your microphone, can you turn your microphone on? Thank you.
Today, the newer commissioners have been briefed on the planning process and the process of scheduling briefings, all 7, to review that. And I appreciate the comments being made. you have the most latitude, as was pointed out by Commissioner Cruz, when you do your comprehensive planning map, where you want to have residential, the density of residential, the road plan. That's where you have your legislative hat on, and the public purpose served by your actions is legally defensible. The further down you get into the land use review process, the more constrained the review is. And at the final planning stage, you know, we're looking at compliance with the state statute, Chapter 177, with the local subdivision codes in Chapter 3, Part 4, our Land Development Code, consistently with state law and the technical requirements for development approvals for subdivisions in the LDC, as reviewed by your county staff, and information submitted by the applicant. And this is really the process for getting easements, surety bonds, and ensure improvements are constructed timely and properly. So I'm not in a position to judge whether you should vote for approval or not. I am telling you, in quasi-judicial world, if any development approval is denied, the matter is continued for the county attorney's office to work with staff to come up with findings for denial. And we don't have testimony today under oath. Commissioner testimony can't be considered for sworn testimony, because you're all sitting here like your judge hat on. So you would have to probably continue the matter if you wanted testimony from staff or the applicant or consultants on basis for denial. So I'm just general comments at this point.
Thank you, Madam Attorney. Any other questions of the applicant in a rebuttal? I recognize you, but I appreciate if you go on the board. So the clerk knows that you're going on the board. That's the reason you're going on the board.
I got it now. It came on.
I see. David, are we having problems again?
Do I have the-
Okay, Commissioner. I hope so. I mean, I didn't buy this system. Commissioner Feltz.
Hi. First, I'd like to appreciate the rebuttal produced. Again, my point here is to make this also an educational process. Again, I appreciate comments made explaining the situation from our county attorney, from Commissioner Cruz, and from the applicant's legal stance. This is educational for us. It's not going to change my vote because I'm making a point, okay? But we're talking about a quasi-judicial situation where we're asked to be a judge, and we're only hearing one side of the story, okay? This is not a fair court of law, so to speak, because there's nobody here on the other side, which is why I have to just take a stance out of principle, not personal, but in order to, this is a process that needs to be transparent. And we are sitting here in a quasi-judicial courtroom with no evidence, no representation from another side. All we are hearing is one side of things, and it's only by our own innate consciousness or knowledge that we know that there's another side of things. So I'm still going to stay where I'm at. It's not personal, it's principle. And this is the dialogue that people need to hear from both sides, but they're not here. And why are there not, is there not anybody here? Public hearings, little yellow signs, call-in comments, but we haven't really, now think about that. This is something that has come about from a system, from an unbalanced board, and you have to be consistent with a few things to make a point. So I think it opens up great dialogue. I do believe this is the time because I am speaking for District 1. Whether any other commissioner that does not live in my district, that was not voted in to speak for the constituents of my district, wants to bring about something that doesn't even affect them or their district, that's not fair. I'm telling you what I know. I'm telling you what people want. I'm trying to be fair with this, but again, it was just a transmittal. It was just a this, just a that. We've got to be able to educate our citizens. So when I go back and I say, well, I voted for that, but let me explain why. I appreciate that dialogue, and I think that's what's bringing it out. I appreciate having the rebuttal, but where are our citizens giving the opportunity to do that as well? The way things go so quickly, so fast, nobody knows. And we've just got to slow that down. And if this one no vote, or two, or three, or maybe four, slows that down a little bit, then we are doing what is in the best interest of our citizens as a whole. It may not be for the best interest of 50 more people that are going to come down to a brand new built house, but their kids don't have a school to go to yet. It's wonderful that there's a school. When we maybe have to change some of those items of concurrency, which I think we've already discussed this week. If we have a problem, then, and it's not our problem or your problem, but it's somebody's problem, then we need to maybe address that and say, you know, build that school. Maybe we need that first. There's portables in parish schools that we just built, portables. And maybe our site plan includes a school, but we need to change that tide of building it later. And if there's a law, if there's something we have to change to make common sense, that you build the school first and build it and they will come. I've been in the public school system in the state of Florida all my life. I have never been in a school that was not overcrowded before the period ended. So aren't we supposed to be working on something like that? Then for somebody who's my age to say, you know, I've never been to a public school that wasn't overcrowded before they even opened the doors. We need to change those kind of things. This is a small no, a small step to do it. Whether or not it's the right time according to anybody else, I don't answer to anybody else. I answer to my constituents in District 1. Thank you.
Thank you, Commissioner Felts, for your comments. And we used to do it right with school concurrency, but that kind of went away. So I agree with the fact it is about principle, and sometimes that's not popular with a few folks, but, and that's in general. That's not talking about a specific group. That's just in general. But standing on principle is what I'm going to be doing from this point forward. Thank you, Mr. Chair.
We have rebuttal from the applicant. Is there any staff closing comments? Staff? No. If you're good, just wait. Okay, thank you very much. All right. We have a motion on the board by Commissioner Sadiq, seconded by Commissioner Cruz. Is everyone please cast their votes at this time? And the motion carries 4-3. Thank you very much. All right, item number 4. Ms. Knapp, could you please read item number 4 into the record, please?
Item number 4 is approval of a final plat for Oakfield Trails, phases 2A and 2D. And your staff presenter is Natalie Chapucio, if you need one.
Applicant, good morning, sir.
Morning, Mr. Chair, Commissioners. Kyle Grimes, attorney with Grimes Galvano, and I have been sworn. Here today on behalf of the applicant, Homes by West Bay, who's the developer of this portion of the project. Again, here we have the request for approval of a final plat. We've gone through a lot of this extensively in last meeting. I do agree wholeheartedly with the comments made by Mr. Vogler. This is the plat process. It is through the statutes and case law very clear that it is to look at compliance with the statute, with the local regulations regarding subdivision of land, and the prior approvals. But I can certainly appreciate and understand wanting to look at these fully and understand what's being approved and having that transparency. So I'm happy to go through a little background of this project. This particular project now is a relatively small portion of a greater plan development project known as Oakfield Trail, formerly Eisenhower McClure property. It was originally approved back in 2022 with a zoning ordinance and a general development plan. And since that time, it's gone through the long process of acquiring that final site plan that we talked about having to do for these projects before platting. In addition to that final site plan, this project has been granted a certificate level of service, and it has gone through and entered into an agreement with the county on certain roadway improvements. And I'll get into that in just a second. So this final plat is to codify in the official records those lot lines and those items identified on that approved final site plan, and that's exactly what we have here today. I do listen to and appreciate some of the comments raised in the last meeting, last hearing, particularly about transportation improvements. And we do have a unique one here in that, and if I could have the overhead screen. What we have here, just for visual sake, is the approved general development plan. Again, this is the McClure Eisenhower property that's located. This is Maximala on the southern portion and Buckeye Road on the top. And going through it is a thoroughfare road known as Sawgrass Road. And what would normally have to occur for development through here is that they would have to construct at least 2 lanes of that 4-lane roadway as they're needed for access. And they entered into an agreement with the county where they would agree to go ahead and build that as a 4-lane built out going forward, ahead of the time that the traffic study deemed it necessary. And that under that agreement, they were to build it in phases as development came along. But the master developer agreed to go ahead. They are building that ahead of schedule. Although the area in Plat is in this here, they've already constructed it and paved it up to Buckeye Road as the full 4-lane ahead of what would normally be required by the county. The connection to Buckeye Road is the last item that's under permitting right now. So when we're talking about building roads ahead of time, this is one project where we can say they have been building and exceeding what they need for the roadway network ahead of schedule of this development. So again, I just want to reiterate, we are at the final plat process. We have gone through extensive review with your staff to ensure that it meets the requirements of Florida statutes and applicable case law, that it meets the requirements of the statute, it fully complies with your land use regulations, and it is consistent in compliance with all previous approvals related to this property. And so I know we've gone through a lot more detail on the last hearing, so I'm happy to answer any other questions that you may have. Thank you.
Hang on for Mr. Grimes. There's been no ex parte, correct?
No.
All right, thank you. Are there any questions for Mr. Grimes? Commissioner Siddiq, you're on the board.
It's one.
Is this for him or for the applicant or?
No question for the applicant.
Okay. Commissioner Beard?
Thank you, Mr. Chair. So I see the connecting up to Buckeye Road, which is a D-level road.
I don't have that in front of me right now.
Okay. Well, I got some issues with that. So, like I said, I'm just going to take a stand on this. I'm not going to beat down a dead horse. I'm just going to keep moving forward and just vote no. So, thank you, Mr. Chair.
All right, sir. Commissioner Siddiq?
Thank you, Mr. Chair. I'd like to make a motion to approve the plat. And we can discuss, of
Madam
course.
Attorney?
We have to finish the hearing.
Let- let-
Oh, okay.
Ask for public comment.
I appreciate your enthusiasm, but let's go through, I got to finish the judicial process, and then we'll appreciate your coming back to it. Commissioner Feltz. Commissioner Feltz?
There we go. Okay, I don't want to waste any more time. I think we've made the statements. We have a lot more to discuss with this. We've made our point. I think you're going to see some consistency here. I'm looking at a map, and that's what I see. So, 146 homes. Again, schools, roads. Buckeye Road is not prepared to handle this yet. We welcome you to come back once we have schools, once we have roads, once the county can contribute to the quality of life to the citizens that you are going to have built there. I do not care what anybody else approved in the past. I do not care that this is a site plan and it's just a transmittal and it's just a. We got to say no somewhere, and we've got to stand on principle somewhere, and you got to get used to it. And we've got to make it a point. I don't want to go on with it, but this is where we're standing. And it may just be three of us, but again, I shall say this one more time. This is my district. I travel those roads. The people who vote for me are tired of us saying yes. I have a directive, and that is to say no. And I'm going to stay with that directive, but I do want this very much to be a learning experience for our citizens. None are who are here right now in a quasi-judicial process to be cross-examined or see more than people are starting to pay attention now. And I'm sorry if we've made mistakes in the past and we didn't have public participation in the past. We had apathy, we had complacency, but we've got to do this to educate the public, to let them understand what we can and cannot do. So my principle of this is that I'm saying no, but my purpose of this is so that we can have this dialogue and discussion so that we understand where everything is going in District 1, which again, understand something. District 1 is not like the other districts in this area for many reasons. Number one, we haven't had a representative for our district in how many months? And in the meantime, everybody was voting on stuff, and I appreciate the help of our commissioners at large, but they don't live there either. But they did try and help. So I have a district that is larger than the rest of the county combined. I have a district that has various types of communities, rural, urban, suburban, industrial. So I have some challenges there that none of you that live in the other districts can understand, that we have been assaulted in the last 8 years because of a lack of representation, because of a lack of, we have new people there. They're more concerned with what's going on in their HOA. They don't even understand how Manatee County works, or how, as we'll say it, a cow pasture becomes a condominium. We have to bring these things up. We have to educate people so that you guys get a fair shot too. This is all about being fair to both sides of this equation and this process. Now, I'm going to ask my fellow no voters from the previous we've made our point. Let's not beat a dead horse. I love that expression. And we've made our point. Let's allow this to come to a vote. And if we have other things to say, that's fine. But I think we know where we stand, and I think you know where the commissioner for District 1 stands. Thank you.
Thank you, madam. I'd like to make a comment. Ma'am, if you'd like to, I mean, you keep saying educate the public, educate the public. I believe you could have a town hall. You could do a Development Services 101. Sure. That would be well represented. Also, you said for the last 8 years you've had no representation in District 1. I beg to differ with you. You had Commissioner Trace was there, Commissioner Satcher was there. You had two fine at-larges that stepped in when Commissioner Satcher went to be SOE. So I disagree with you on saying you didn't have representation in your district. But these votes were made prior to even Commissioner Cruz being here on these type of projects, these type of growth. But I disagree with some of your comments about your representation in your district. All right, staff comments.
I believe Mr. Grimes covered it. Natalie Chapuzio with staff. Do you all need a staff presentation?
No, just, I mean, if you want to do a quick presentation, anyone, any presentation from staff? Thank you very much. All right. Open up for public comment.
For the record, Glenn Gibolina, Manatee County, I have been sworn. So here's the analogy. Let's go back to the transmissional letter, right? So we got Wallace and Waco, we got Buckeye Road, single lane roads, by the way. Back in the time, oh, hey, listen, no, but there's no traffic there. Let's make the speed limit 70 miles an hour, and we'll get to work. It worked back then, right? Now we're today. We're, 70 miles an hour, people are getting killed, running off the road because of the traffic and the hazards. What do? You change the speed limit. That's the analogy the public's going to have. Change the speed limit to a reasonable speed so no one gets hurt. So now you have this developer that has 4 lanes. Hey, listen, I got 4 lanes going out to single lane road. So let's hurry up and get to Moccasin Wallow and Buckeye and wait in traffic with the other 700 cars you guys just approved, right? That is unsafe. Unsafe. You are supposed to protect the public. And as far as the constituency, oh, we've got an agreement with the county to build that road, the funds are there. We've had 3 hurricanes. Don't you think Governor DeSantis might say, hey, we better slow up on those road projects and maybe repair those bridges or those other roads that got washed out before we go expanding to other counties? So what's going to happen? Buckeye's already been delayed. We don't know when it's going to be finished, but this developer is going to put in all these houses and say, not our problem. You said you're going to have the road done. It's not done. We got the houses sold, and we're just going to keep going on that 1-lane highway, and it ain't our problem anymore. We'll just get you to that road, and it ain't our problem that the road isn't done because the contractor went out to fix the bridge or other delays. That's what I see. It has to be together, right? No CO until the roads are there. If there's a problem with the roads, you need to slow up or you are going to endanger the rest of the community. I don't hear any of that. I really don't. And that's the focus this board should be on. Safety for the public. And you're not doing it. You're trying to do it, but you're not doing it. So that's where I'm at. And also, when you vote, you say 4-3. I think the public would like to know who voted what and why. I don't see any of that up there on the board. So please, tell us who voted for it and who didn't vote for it. Just don't say 4-3, for the record.
I think the votes are posted. All right, thank you. Is there anyone else who will give public comment on this item? Please state your name, county residence, and you have been sworn. You have 3 minutes.
Good morning, Dalton Nelson, and I have been sworn Manatee County resident. I think a lot of the arguments, especially with the last one, were good arguments. But there's another thing that I want to kind of tell you guys about is that a lot of these, and yes, maybe the final plat is not the correct forum to take a stand and to beat a dead horse, but in this particular area, if you actually go out there and you look at some of these projects that are already underway, there's a lot of issues, and your county employees, in speaking to them, do not get a lot of the information that they need to adequately inspect these final plots once they are completed for accuracy on the as-bills. There's a lot of variables there that are room to move, and that creates some of the inconsistencies that I've emailed you guys pictures and I've showed you guys examples that have led to this unfortunate flooding problem. And I hate to keep beating the dead horse on that, but Buckeye Road and its correlation to all of the rest of the properties in District 1 is a profound problem when you introduce all of these paved surfaces. All of these paved surfaces are sheet flow. The water does not go into the ground like it's supposed to. When you put houses on top of this land, there's nowhere for it to go other than into a retention pond. The ground is so hard packed, it is impenetrable. I think the study is 5%. It goes from roughly 50% to 5%. So I can't say to vote one way or the other, but there's a lot more factors that you guys are not asking questions about that need to be looked into before these developments are final approved to be done. There's a lot of things that your county employees have acknowledged that it's not up to me. It is up to the Board of County Commissioners to make these decisions for us to make informed decisions. They don't have the correct information. It's just point blank period. So, thank you.
Thank you, sir. Is there any other public comment on this item? Seeing none. Staff closing. You have anything, staff? You good? Thank you. Applicant rebuttal?
Thank you, Mr. Chair, Commissioners. I think it's all been established. I just, again, for the record, just, where we are in the process on this final plat, and the comments about, well, where's the other side? The other side would be if this was not consistent with the state statutes, the local regulations, and the prior approvals, and staff has gone through that very detailed with the applicant to ensure that this plat does meet all of those requirements of the state statutes and the local regulations, as well as all prior approvals for this project. So with that, I hope that you approve this project. Thank you.
All right, thank you, sir. All right. There is a motion up on the board. Looking for, motion's been moved by Commissioner Cruz, seconded by Commissioner Sadiq. All those in favor, you cast your votes at this time. And the motion carries 4-3. Ms. Knapp, can you read item number 5? Before we read item number 5, and once we get done with number 5, we'll take a break. Okay.
We still have number 2 plat as well, if you just want to.
Yeah, I'm gonna do those after we get through number 30. Yeah. So when we get through with number 30, I'll go to 2 and 6. All right.
5 and 6.
I mean
2 and 6.
2 and 6.
2 and 6 are pulled.
So we're gonna go 5, and then we'll just because those were moved after. So Ms. Knapp, can you read number 5 into the record, please?
Agenda item number 5 is approval of a final plat, River Preserve Estates.
Is there any ex parte regarding item number 5?
Oh, sorry.
All right, thank you. No ex parte has been noted.
See an attorney.
Applicant, you are up.
Okay. Good morning, Commissioners. For the record, I'm Scott Rudisill. I'm an attorney with the Blaylock Walters Law Firm, and I'm here. Actually, I'm not here on behalf of this applicant today. I will get up here and speak. I just happened to be in the audience and saw that this was pulled, and it happens to be my client. So I'm not going to belabor the discussion about the legal framework for the plat, but this is a plat that meets all the requirements of your code. This is another older project. It is for Cross Creek. I think it was originally approved in 2007. It was a project that failed. This developer has resurrected it, and this is a plat for a portion of the project. So if there are any questions, I will try to answer them the best I can. But otherwise, I think the staff materials suggest that it does meet all the requirements of your code, and we'd ask that it be approved.
All right, thank you. Thank you, sir. Are there any questions of the applicant? All right. Staff.
Would the board like a presentation by staff?
Thank you, ma'am. Does anyone want a presentation from staff?
Sure.
Okay.
And my name is
Full
Natalie.
presentation or just a partial presentation?
My name is Natalie Chapuzio. I'm a staff planner, and I have been sworn. So this request today is to record 161 single-family detached lots. The subdivision is located on the east side of Fort Hammer Road and north of Mulholland Road in District 1. So the board did approve the ordinance and GDP for PDMU 1113 GR2 by the name of Cross Creek back in December of 2022. That approval was for 1,426 residential dwelling units, and the final site plan was approved June 10th of this year for the 161 lots that you have today. Do you have any questions?
Are there any questions, staff?
All right. The applicant just mentioned this is held up or at some point paused before. I just wanted to get some clarity on that.
So they did have, it looks like a revision back in 2022, so that was the second revision to the original ordinance. And then they came in with this site plan back in, I wouldn't say, at the beginning of this year, and that was approved in June.
Mr. Cruz?
I just want to clarify, because what Scott had said was that the overall project, meaning Cross Creek, was held up, and this applicant resurrected. That was 2007. All real estate was held up. There was a massive crash. All he was implying was the current applicant wasn't the original developer for this, that he acquired it post-development and has moved it forward. I believe that's what you were referring to. I don't want to speak out of turn, but, okay.
Thank you, sir. Appreciate that clarity. All right.
Thank you. That's all I had.
Any questions, staff, anymore? All right, thank you. Public comment. Does anyone like to give public comment on this, on item 5? All right, seeing none, we'll move to staff closing comments. Applicant rebuttal. All right, thank you. The motion's been moved by Commissioner Sadiq, seconded by Commissioner Cruz. Everyone cast their votes at this time. And the motion carries 4-3. What we're going to do right now is we don't normally stop at 10:30 for a break for staff and everyone. We're going to go ahead and please be back at 10:40. Thank you very much. We stand in recess. And we're back from our brief recess. We're going to start again where we left off. Ms. Knapp, can you read item number 30 into the record, please?
Item number 30 is North River Ranch Improvement Stewardship District. It's amending the boundaries. And for the record, there was an error on the agenda. It states that Rachel Layton is the staff presenter. Rachel is not the staff presenter, it's Denise Greer. And for the record, Rachel Layton will not be and has not been performed any part of the required review and/or future analysis on this project.
Okay. All right, thank you very much. Is there any ex parte regarding item 30? Yeah. Yep. So no ex parte, thank you very much. Any ex parte from anybody on the board? No, all right. I thought you said you wanted to go quasi on this.
We're in the Stewardship District, right? That's not quasi-judicial, it's legislative.
Okay, it's legislative,
Sorry,
okay.
I meant to say that.
All right, so great, okay, so it's legislative. All right, applicant.
Good morning. My name is Jer Earlywine. I'm with the law firm of QTAC Rock. Appreciate the opportunity to speak with you all this morning. I'm obviously here on behalf of the North River Ranch Independent Stewardship District. My firm represents about over a third of the 1,000 or so CDDs in Florida, and I think virtually all of the stewardship districts. Two of our founding members in my office actually worked on some of the first CDDs in Florida, and so we got a lot of background and experience in that area. And glad to talk with you today about stewardship districts and other types of districts. This particular district was established back in 2020 by the Florida legislature, and it's one of the 17 that are in Florida. There's several actually in Manatee County, like Lakewood Ranch, Welland Park, North Lake Stewardship District with the Faulkner family. Those are all stewardship districts that have been in Manatee and operated successfully for many years. One of the differences between a stewardship district and a community development district is they're very similar. It's just the stewardship district is a little bit more efficient when you have a large development project like North River Ranch. The idea is that rather than having individual community development districts to manage parts of the overall development, you've got a single stewardship district. Saves costs because you only have one administrative budget, one manager, one set of insurance policies, that kind of thing. And so it really does help lower the cost for residents and things like that. What we are here today asking you for is a no objection letter. We'll take that letter to the legislature and ask them to amend the law that created the stewardship district and expand our boundaries to include that Jones Farm project to the north. To be clear, we're not asking for a development approval or entitlements or anything like that for the property. That's a whole separate process. All that we're talking about is a stewardship district as a way to more efficiently finance and operate and maintain the infrastructure for the project. So the development entitlements and things, that's a separate discussion. In fact, those entitlements are already in place for this project. And all that we're asking to do is issue the no objection letter and allow us to move forward with our legislative process in terms of amending the boundaries. This particular district's boundaries has been amended twice before, once in 2022 and once in 2024. And so we see this as a pretty ministerial thing, and we certainly appreciate your support. And we're here and available to answer any questions you may have.
All right, thank you very much. Are there any, Commissioner Siddique's on the board.
I had about 4 different things to cover on this one, so got my coffee, let's strap in. So the first thing is about the material of the matter here. As I understand it, the future land use category is already Res 6, so you're, or Res 3, I forget the exact, the specific category. So this parcel has already been identified as, it's legally it will be, it has the potential to be developed, so that's not anything new. There's no additional entitlements you're asking for. So the only other thing that I had to comment on is that my understanding of the statutes is you don't necessarily need the letter for the state legislature to then go ahead and add this and, legislatively add this to the stewardship district. So again, this is ceremonial, it's a nice to have. That's my understanding. Is anything I said incorrect there?
Everything you've said is 100% accurate.
Okay, got it. And I'd like to thank staff for the late night call that clarified a lot of that. But the second issue is about that. For me, the timing was a little bit inappropriate. Just in general, I think it was a little bit too fast. Given the material issues I did discuss, the fact that probably like at 5, 6 p.m. we had a late night issue come up before the board that we have to agree as a board to sign on to. get into staff schedule, interrupting whatever you're doing, to really put this ahead of other issues, to me, it just felt a little bit inappropriate. And I think, in previous boards, we've had that issue of development reaching out to staff prioritizing this somehow, and then it gets on the agenda, and then I need to start talking to Nicole or our deputy DCAs and then figure out why is this on the agenda. So for me, I think that's the big concern I have is on your end, because it seems like the future land use map it's fine, I don't have an issue with that, but why this late? Is it because session's coming up? I'm just curious.
Yeah, go ahead.
Sure. Hi, Ivory Matthews, and I've been sworn. The reason we had to do this so quickly is because the delegation meeting was set for January 9th, and we wanted to get this to the delegation. We thought that we would be able to bring this to a January meeting, but when that 9th date was set, that was actually a meeting that you guys had that had to be moved. So we can do this now. Your staff was so helpful. We were able to work with staff, and I sent emails to every commissioner and also made phone calls. It's really a sad situation that we had to do it this quickly, but it's just because of that delegation date.
Okay, I appreciate you answering that.
And Mr. Chair, I don't want to interrupt his time frame, but to follow up on Mr. Siddique's comments, we do have a post motion to modify that will address the issue of having additional information submitted later, because it was last minute.
Sure.
Because the statute does say they need no objection from the county. So the statement is important for them to follow the statute.
But they don't need it before they go to the legislature to add this to their stewardship district.
Well,
Or is it
I
a hard
defer to them. They're
requirement?
the experts. They know how to work Tallahassee, get bills passed. I mean,
It's a legislative act, so the legislature takes each of them up anew, if that makes sense. I don't think there's any parameter on it. For example, if there's a law in place that said you had to, well, the legislature can change that law at the same time if they want to,
Sure.
But I'm not aware of any requirement for that at this point. Go ahead.
And we've worked it out with staff. I think when staff comes up to present and talk about it, they're going to talk about some of those issues.
Okay, got it. Now, I think the last point is just about the resource allocation on our end, but we can have a discussion on that later. It seems to me that we need to, one of the challenges that we have is we are a growing county, and it's not lost my attention that whether it's permitting, whether it's matters like this, that perhaps we just need to have as a board and just discuss with our administration, just have a conversation about how much we're really putting on our staff in terms of reviewing these applications. From what I understand, we've had significant turnover in government the last 4 to 8 years. Not to mention, in some departments, we just haven't really augmented them with additional staff. To me, I just want to make sure we're doing things right, that when we get something as a board, that we can trust staff have not had to cancel dinners, cancel Christmas parties, vacations, and do this for us, and drop everything at a hat and just jump on this because someone in the community directly put this on the agenda and asked us to do it. So that's a separate conversation I'd like this board to just be aware of, that there are a lot of disruptions that can, that staff have to deal with, and I'm empathetic to that. And I get calls all the time about people that are being cost tens of thousands of dollars a year in just permits just sitting around because staff have had to prioritize other things. Not that this has done that necessarily, but I just want to raise that point to my board members. So that's all I had to say about that. Thank you.
Thanks, sir. Commissioner Cruz.
This isn't a question. I know what you're asking for. And I just want to, because, I mean, this is an early land use meeting, and I think it's great we're seeing a collection of things, whether it be plats or stewardship districts, so we can discuss what they are and make sure we're all moving forward as a board in the right direction going forward. Last meeting, I believe it was, I think maybe it was Commissioner Bearden or somebody, commented about how great the infrastructure is in Lakewood Ranch. And why can't we do that every place? Well, the reason Lakewood Ranch infrastructure is so great is because they're a stewardship district. Stewardship districts allow developers with developer money to build infrastructure themselves, so we do not have to, so infrastructure can go in any time. It's one of the few opportunities we have to not have broken infrastructure without taxpayer money. All a stewardship district is asking of us is to allow a developer on their own, at their own risk, to take out bonds to build their infrastructure and parks and curbs and get everything ready to go without us having to spend our taxpayer money doing it. When they expand a stewardship district, they're just saying, hey, we'd also like to build additional infrastructure someplace else in Manatee County for you. They're not asking for this letter. Representative Robinson and the delegation's asking for this letter. Representative Robinson and Senator Boyd and all them are going to go up to Tallahassee in a few weeks, and they are going to pass this bill whether we vote on this or not. And it's going to pass. The difference is, do we send our delegation up there saying that the local county commission doesn't support the bill that they're going to run, or do we get behind our delegation? Because if you read this letter, it doesn't say that we love this project. It doesn't say we want to move into this project or that we would have voted for this project. This letter says that we as the Board of County Commissioners are implying that this is consistent with the approved local government comprehensive plan. And it 100% is consistent with the approved local government comprehensive plan. As Commissioner Sadiq pointed out, this is already approved projects. And we already approved development agreements on how they're going to put the roads in. This is just the mechanism for how they're going to fund them. So this letter is 100% factually correct. It's at a request of our delegation to facilitate them doing what they're going to do with or without us, whether we vote yes or no. Because we're not voting no on a project. All we would do is vote no on refusing to sign a letter to Representative Robinson to make his life slightly easier, but it's going to go up to Tallahassee and it's going to get passed with or without us. And all we're doing is acknowledging that this does meet our comprehensive plan, which it does. So this is an opportunity. We should be encouraging this. I wish more people would come to us with stewardship districts and offer to build infrastructure with their own money on our behalf. This is a great opportunity for Manatee County, and this should be more of an administrative type situation today, in my opinion.
Thanks, sir. Commissioner McCann.
This did come in.
This did come at a very late hour, and, you know, if the letter is meaningless, I don't see a reason for us to be signing a letter. The thing is that, you know, what this letter does say, and I think Commissioner Cruz is wrong in this, is it says we have no objection. They want to move a boundary line, you know, and this has had no public comment. It hasn't had time for public comment. We have a problem with putting things on the agenda at the 11th hour. People have to review these things. I did get a call. I did get an email on this. That email and that call was yesterday. The thing is, if you're going to be making changes on boundary lines or anything else, you know, with all the problems we've had with the FDAB in the past, I think we really need to, you know, let the process take its thing. But, you know, this is actually saying that we condone this process. We do not object. And I do object to this type of process.
Commissioner Feltz.
I do find the timing of this a problem. As I understand it, I don't know if we've mentioned specific dates, but weren't we scheduled to have a land use meeting on January 9th, right? And then this would have been heard on January 9th, which would have given us adequate time to understand the process and what all of this encompasses. But I believe the reason that we canceled the meeting on January 9th was because we have a meeting with Will Robinson, right? Is that correct?
Delegation meeting.
Right. So I guess I'm concerned as far as why did this just come up at the last minute? Why was it given a priority? I mean, the truth of the matter is, how many times do we have citizens' comments that they want to see something on a future agenda? And I could probably count on one hand. We don't even keep track of that. But apparently this is something that, again, we're back to, it's just a letter. We have a new board up here that the Gesta is we're going to need a little bit more background. And I think I asked, actually, for, with staff, did staff have that map prepared for me? Can they show it? Because the documents that I received, I wasn't comfortable with my ability to ascertain what was being done here, because there wasn't, this was not included in a briefing. It was just at the last minute, and we're told it's a formality, Again, how the letter states is no objections. We do have some objections, so that would be untrue. We have objections about how and when it was proposed, that we didn't get a briefing on it. I've asked for a map, and as you can see here, can you enlarge that? Because I haven't seen this map either. But what I'm looking at is all of that red, and I'm assuming this came from our public mapping system. There's a lot of red. Again, my district, District 1. Also notice that this is extremely close to our Hillsborough County line, which is another thing that's a little bit different about my district and where I live and where the people who voted for me live, in that my district borders 4 other counties. So what happens in those other counties affects us, maybe more so than other districts, and also what we do affects other counties. This is a, I don't know if you're familiar with the area, but you'll also notice that this is right up next to Lake Manatee State Park, which is in Hillsborough County. You'll notice the area around this park is rural, and it is in Hillsborough County. I would feel much better if the letter did not state we had no objections, because we do. We do in many things, how it was presented, what it presents, and keeping in mind that we do have a new board here. And as for commissioners' remarks about our prior commissioners in this position, if they were truly representative of the constituency in District 1, they'd still be here, and they're not. I am. So I appreciate that this is important, but the reason it's been important, the reason that it's the scheduling of events. That's what precipitated the issue of it being added to the agenda at the last minute. Not that we had control on. Okay? So we have to look at what precedence this sets. Putting things on the agenda at the last minute and expecting us, especially the new commissioners, that don't have, I mean, it takes a lot to understand all this. I could tell you what every red spot used to be there, but I campaigned for a year. So I've asked for some additional information. And if staff could please explain where this property lies on your map that I've asked you to generate.
Sure, Denise Greer for staff. Sorry about the map, but I didn't know about this till this morning, so I put this together very quickly. I did pass them out while on a break, so you should all have one. I did highlight the Little Manatee River State Park on this map, which is not highlighted on yours, but, Commissioner Feltz asked for the distances, which are shown on this map, from the Jones Farm parcel and from the Deer Park parcel. And those distances, of course, are as the crow flies. Jenny, if you could go back to the map that was online. So this is the map that was uploaded last night. With the agenda, you can see the 2 blue, or the cyan blue boxes north of Buckeye Road. Thank you, Jenny. Those are the 2 parcels that are being added. And then if you go back to, no? Okay. I think we may have the applicant here to correct that, but the map shows Jones Farm and Deer Park on there, so I assume both of them were part of this agreement. Okay, so applicant may change that. So if you can go back to my map that's on the document camera. Thank you. So on the document camera, you can see Jones Farm is here. This is Deer Park. I'll let the applicant explain if that is part of this application or not. And I do have information with me regarding Jones Farm and Deer Park, if we need it, on what the previous approvals have been.
Hello, Ivory Matthews again. So in this past year's session in 2024, we added Deer Park to the Stewardship District, as well as a portion of the Chin property that abuts North River Ranch. So this application for this upcoming session is adding Jones Farm. Jones Farm was approved, I believe, 2 years ago. It has all of its entitlements, and we are just adding this in so that we can prepare for building the roads and infrastructure.
So just to clarify, Deer Park was already included. Okay, my mistake on that.
Commissioner Felch, you good? All right, Commissioner Siddiq.
No, I appreciate the applicant providing that clarity. And I appreciate Commissioner Cruz's comments. I'm familiar with stewardship districts. Obviously, we want to encourage public-private. I'm a big proponent of that because government is terrible at building things, as I'm finding out on 51st and other areas. But fundamentally, if you're telling this board, if you're telling us to go to our state delegation, an incoming state Senate president, and then Chairman Will Robinson, that our Board of County Commissioners has done its homework, meaning staff has done its homework, and had the adequate time to do its homework, even if it's a simple matter, and we're not rushing things through literally the day before, to tell them you have our seal of approval on this, that we've done our due diligence. If we haven't done those things, I don't feel comfortable signing this, and I don't think that's the kind of work that I would want to expect out of this Board of County Commissioners. And I think respecting the process is important. I'd ask my fellow board members to recognize that, and at the very least, let's not hold up good business, but I do want to see our board take some steps to really evaluate, are we actually a pro-business Board of County Commissioners, or are we just going to let our inefficiencies get in the way? So if we need to bolster staff, I'm for that. Part of being a good conservative is making sure we can support our business community. I just don't feel comfortable signing this today because I don't think we can comfortably say we've given staff the adequate time to do their time. And I appreciate, the late night call at like 7 or 8 p.m., but I'm literally on the way home after getting back from a million different things, and that's not the right way to do business. And that's just, again, that's just the position we're in. But the other thing I'll simply add is, I just don't think we should encourage a bad process. That's all I'm saying. We should encourage a good process. We should encourage staff to have adequate time, meaning we have adequate time, and we should be looking out for their interests as well. Thank you.
If I may, and I don't mean to be out of order, but just understanding where y'all are coming from on the timing issue, perhaps we could continue this to, I think, January 7th is another possible date.
8th.
Or 8th, okay, January 8th. Again, I do think it is a simple matter. Really, all you're saying is it's consistent with the comp plan, and that's basically it. And it is, like Commissioner Cruz said, and like y'all are saying, it's a way to deliver infrastructure. It's also an excellent management and operations mechanism, which we'll talk about separately. But if we could continue this to January 8th and give you all some more time to ask some questions and get the information you want, that we'd be happy to do that.
Let's do that.
Commissioner Cruz.
No,
You good?
Well, I was on the board, but I'm fully okay with moving it to January 8th. I mean, this is just a signing of a letter, so it can be done at 7 o'clock in the morning on January 9th, hypothetically. I mean, they just want it in their pocket by the time they show up at 8:30 in the morning on the 9th. So we've got time on the 8th. We've got a meeting set on the 8th. This gives everyone 3 weeks to understand stewardship districts and what's going on, and I think you'd rather have universal support on a 7-0 vote by this board when you go to Representative Robinson than some sort of a 4-3, 5-2, 6-1 decision. So I think you're better off that way, so.
And Mr. Chair, if I just state, the purpose of the continuance is two things. One is staff has to examine the requested amendment to the boundaries of the stewardship district to make sure they're consistent with the county's comprehensive plan. And normally, we have staff look at the legal description, confirm its accuracy and complete, and coordinate with the applicant legal description. And those two things just be done and entered in the record in writing on that day would be helpful.
Okay. Commissioner Bearden.
No, thank you, Mr. Chair. No, I just appreciate Commissioner Siddiq's comments. I think that's a great idea. Gives everybody ample amount of time to make that decision, and we'll go from there. Thank you, Mr. Chair.
Well, thank you, sir. Commissioner McCann.
There's been a lot of legal opinions given here, and I appreciate those, but this does not say that it just goes with the comprehensive plan. It also says we have absolutely no objection. and that isn't true. So, giving those kind of legal opinions, to people that don't have a bar card is not a good idea, because I think that a lot of people here are of the opinion that, you're giving them authoritative stuff, and that's not authoritative. That last line in there, if that line wasn't in there, we could probably sign it today. But what you're asking us for is to condone this procedure the way it's being done. And if the county commission has no objection, that is a legal statement from us. So again, I think we need to be very careful in how we state these things to the commission.
Thank you, sir. Commissioner Cruz, you're on the board again.
Yeah, I'm just going to make a motion to continue item number 30 till January 8th.
Second.
Okay, it's been, all right, there's been a motion moved by, staff, do you want any presentation or anything? You guys good?
Well,
Commissioner Bearden's on the board.
Thank you, Mr. Chair, and I just want to make a statement that I will vote yes on some items here in the future, just so everybody knows. So, and this is going to be one of them. And also, some other, land use items, I will be voting yes on some of those items as well. So, sometimes you're in the moment. Thank you, Mr. Chair.
All right, sir. All right, staff, anything? All right. Public comment, is there any public comment regarding this legislative item?
For the record, Glenn Gibolina, Manatee County, have been sworn. I'll tell you, if this was the old board, this would have blown through. We wouldn't even be having these discussions, right? That's the old school. That's what they thought they can get away with. There's a new game in town, and I really appreciate Dr. McCann pointing out all the deficiencies and the legalities of it.
should be just
Here it is,
continue.
second revision, right?
Glenn, we have a motion on the floor to continue, so that's the motion you have to address.
Oh, continue, okay. Well,
Only the motion to continue. The item's been moved, so I mean,
Okay.
you see the motion to continue.
all right,
Thank
so
you.
I'm going to talk about the motion to continue. I disagree with it, I'll tell you why. They said, you have January 8th coming up. You guys didn't ask staff, say, hey, what do you think the next appropriate date is? They're running all over you again. Nothing's changed, for the record.
No, I disagree with you, sir. Nicole Knapp, Director of Development Services, came and said we can move this to the 8th if the applicant would be so applicant to do that. So the staff has no issues with that. All right, so we've had public comment. Anyone else would like to give public comment on this item? Seeing none, close public comment. Staff, any closing comments?
Because it's legislative.
There is a motion on the floor. All right, so the motion's been moved by Commissioner Sadiq, seconded by Commissioner Ballard. Oh, so Commissioner Cruz.
Hey,
Okay, you don't care? Okay.
Commissioner Ron, just quickly, I think that we have to take phone comment because it's legislative.
Okay, yeah, it is legislative. Is there anyone on the phone that would like to give public comment on this item?
No colleagues, Mr. Chair.
Thank you, sir. Okay, we'll close public comment again. There's been a motion made by Commissioner Sadiq, seconded by Commissioner Cruz seconded by Commissioner Cruz. It was Commissioner Ballard. I don't know what's going on, but to move the item to January 8th. If you all cast your votes at this time, I mean, the whole thing changed. Thank you. The motion carries 7-0. Thank you very much. All right. Wow, that was craziness. All right, Ms. Knapp, can you read item number 7 into the record, please?
Number 2?
Oh, sorry, 2 and 6, we still got to go. All right, sorry, Dr. McCann, I skipped over your items. All right, number 2, can you read number 2 in the item, please, into the record, please?
Yes, sir. Approval of a final plat and associated documents for Palm Grove at Lakewood Ranch Phase 1, and your staff presenter is Kevin Oatman.
Okay. All right, is there any ex parte regarding this item? No. Okay, applicant, you're up.
The applicant is first, yeah.
Yep, you're up, applicant.
Mr. Chairman and members of the board, my name is Ed Vogler. I have been sworn, and I represent the landowner and developer of this wonderful project known as Palm Grove. And without belaboring anything that I said before, I would just like to underscore that this is a fully approved vested project, that it has all of its entitlements. We are building the infrastructure. We are making improvements to State Road 64 at an intersection in coordination with FDOT permits. And so I think that it meets the profile that's been presented several times here today. And it's a final plat. And I ask that you approve it because it meets all the codes and ordinances and is consistent with state law.
Okay, thank you. Any questions of the applicant or the board? Seeing none? Kevin, you're up.
Always have to lower this mic. Good morning, board members and staff. My name is Kevin Oatman. I am with Development Service, and I have been sworn. So today we are requesting to approve a final plat, final residential subdivision plat for 345 single-family residential lots. This is located in District 5. It's just north of State Road 64 between Yulon Road and Burnside Boulevard. The ordinance was approved back in March of 2023. It was formerly known and approved as of State Road 64 North property. But again, it was approved in March of 2023 for 706 units, and that included phases 1 through 4. So this plat today is just for phase 1. The FSP, or the final site plan, was approved September of 2023, and it is in the urban fringe 3 future land use category with the zoning district of a planned development residential PDR. And that's all I have, sir.
All right, Commissioner Beard, you're on the board.
Thank you, Mr. Chair. No, I believe this is a project that I did not vote in favor of, and so I'll still not vote in favor of this particular item. Thank you, Mr. Chair.
All right, thank you, sir. Commissioner McCann.
In this plat, how many houses will be built? And again, it was approved in 2023 before I was a commissioner. Go ahead.
Yes, sir. We have proposed 345 single-family residential lots. We've got 56 single-family detached. We have 76 detached single-family, as well as a couple of villas, which would include 70 units, with a couple of townhomes, which is 6 per building, which encompasses 90 units, which a total, again, 345 residential lots, sir.
Okay, thank you. Just a question for the applicant real quick, because I keep hearing legalese where he keeps saying, you know, we're in compliance with this, we're in compliance with the statute and stuff like that. You know, just to educate the people in my area who, you know, ask questions about this, you're in minimal compliance with each one, correct?
I would say we're in maximum compliance with each one, but.
Can you define minimal and maximum for me?
Yeah, I can do that because the land development codes establish minimum criteria. Every one of the NEO projects exceeds all those criteria, I'm confident to say. And so, therefore, I would say that the way that we present our community to the public exceeds the minimum and more likely approaches, I guess, a maximum of market acceptance. And the only reason, Dr. McCann, I'd just like to take just a minute and say the reason that we say this about meeting the codes and ordinances is because we recognize areas of broad discretion by a board of county commissioners. Local government has broad discretion on many items. And as your county attorney told you, as you proceed down through the approval process, the discretion is significantly less. And so someone like myself that wants to collaborate with you and is hearing what you're saying, I have to say for the record that we meet these codes and ordinances, which is another way of politely saying you really don't have the proper discretion to vote no. You can, because you're elected official and you can vote, and you will vote, and you have. But when I'm an applicant and an advocate, I have to say these things. And there's no disrespect intended. It's just the fact that when you get to a final plat, there's no discretion left. The discretion is whether we meet the criteria of the final site plan and whether we are consistent with these codes and ordinances. This is a state law program. And so at the end, very briefly, it is approved and signed by the Board of County Commissioners, and it is recorded in the clerk's office because that is how you subdivide land legally. You probably own a home in a lot, and it's been subdivided out of a bigger piece. And so, at the end of the day, that's why we say those words.
Again, I appreciate the education. I have a lot of people watching this, and I wanted them to hear it from you, not from me.
Thank you.
Sir, all right, Commissioner Cruz.
Yeah, I'm not gonna keep going on about Plats, but like Commissioner Bearden said, I also voted no. In fact, this came up 3 times. First was a little jog of the FDAB line to match a utility line, and then there was 2 different proposals on this, and Commissioner Bearden and I voted no 3 times on this project. That said, I still have to respect the will of a board, and believe me, I'm perfectly aware of what being on the minority side of a board for an extended period of time is. But once a board has made a decision, just like with all of you, when 4 of you make a decision, even if I disagree with it, I respect it and honor it. That's how a board of 7 works. And a board of 7 voted in favor of this project against my wishes, and it's moved forward. And as Mr. Vogler said, development approval and our ability to dictate land use is like an upside-down pyramid. And at the top, we have a lot of discretion. We can change we can work on our comprehensive plan, our land development code. There's gonna be discussion about what we do with the FDAB line. Very broad. We have a lot of discretion. And then you start getting into legislative and then quasi-judicial, and it works its way down, Each step of the way, we have less control. We can't weaponize the bottom point of that pyramid to make up for something we believe a previous board did wrong previously. We can't go and say, for your project, we're gonna make sure your road lanes are 30 feet wide just to make sure we stop any kind of front yards to keep them from building. We don't have that level of discretion, and we do have discretion. As Mr. Orr said, you can vote however you want. In theory, I could vote yes or no on everything all day long. That's what we're elected to do. But there's still a right way and a wrong way to handle development. And when we get to this stage, we have very limited ability, and I've said that before, and that's the only time I'm gonna go on this board. But I look forward to seeing all of you on the top side of that wide part of that pyramid dictating how future development goes in Manatee County. I think we're collectively going to make a meaningful change in how development happens in Manatee County and land use is perceived in Manatee County. But when we get to that bottom part, now it starts getting a lot more administrative, and we just need to honor that process, even if we disagreed with what happened prior to us being here.
Thank you, sir. Commissioner Bearden.
I don't know if I agree with you on that, Commissioner Cruz. I think that's the reason why it's coming up for a vote, and I'm just not going to just check off and say, okay, I'm going to vote yes, or check off and say, okay, I'm going to vote no on every single item that's going to be presented in front of me. I think that if there are, issues in regards to what each individual thinks there is, they shouldn't have to just vote yes. So I'm just going to have to disagree with you on that. So, thank you, Mr. Chair.
Thank you, sir. All right. We've had staff presentation, we have applicant presentation, we've had questions. Is there any public comment regarding this item?
You did bring us gifts, so we're going to give you some leeway.
Glenn Gibolina for record, I've been sworn. So, you know what? Here we go again, another 700 cars, right? Another 700 cars. Here's what I don't hear. Hey, Sheriff Wells, you want to send one of your officers down and tell us what's going to happen when we have 700 more cars turning out of this development, and how many more accidents that you can predict with all this extra traffic and the timeline you're going to create for that? I don't hear any of that. All I hear is, oh, traffic study's been done. You don't deal with real issues that are going to become of this. So I'm going to read my letter into the record, and then I'm going. Dear County Commissioners, I am writing to express my deep concern regarding the alarming rate of unchecked development in Manatee County. Our community has experienced an explosive increase in construction without the necessary safeguards to protect our residents and natural resources. This rampant overdevelopment has resulted in significant and detrimental consequences, including severe traffic jams, congestion, safety hazards, flooding incidents, and troubling reduction of our wetlands and wildlife. The ongoing destruction of our county is unacceptable. We have reached a critical point where it is imperative that we provide the safety and well-being of the citizens of Manatee County over the interest of developers. Many other counties and municipalities in Florida have successfully implemented moratoriums to pause the development, allowing time to assess the impact and develop strategies to ensure sustainable growth. It is time for us to consider taking similar action. A temporary halt on new development would provide much-needed breathing room to address the existing concerns and create comprehensive plans that prioritize the environmental health and safety of our community. We cannot afford to let our county's infrastructure and natural beauty suffer anymore. I urge each of you to take this matter seriously and advocate for the implementation of a moratorium on development in Manatee County until effective measures can be established. Our citizens deserve to live in a safe and sustainable environment free from the adverse effects of uncontrolled growth. Thank you for your attention in this crucial matter. I look forward in seeing decisive action, might be after the first of the year, on behalf of the people of Manatee County. I hereby certify that a true and correct copy of my public comment of uncontrolled growth has been hand-delivered by Glenn Gibolina this 12th day of December 2024 in the BOCC Chambers, 112 Manatee Avenue. Glenn Gadfly Gibolina. Thank you.
Thank you, sir.
I'm done for the day.
Commissioner Bearden, you're back on the board.
Thank you, Mr. Chair. And Glenn, I always appreciate your comments, but that's just going to be something I'm not going to agree with. I mean, there's people out there that need to pay bills and feed their kids, and there's a better way of doing things. And fundamentally, I just don't agree with you on that particular matter. Thank you.
Thank you, sir. All right, we've had public comment, and we'll move on from there. All right, is there any more public comment? Come on down. I didn't see him raise his hand back there.
Yes, sir, Dalton Nelson, I have been sworn in. I just actually have a quick clerical question, just to make sure that it was accurately stated for the record. Is this Palm Grove community the same one that's on Google Maps in District 1? It is on the north side of 64?
Okay. I'll give you a chance to rebuttal. Hey, I'll give.
The map would be helpful.
Yeah, that's just where I want a clarification, because I understand the one that I see that it has not been built yet, it is not the trailer park. It is on the north side of 64, so it is in District 1.
They'll answer your question on rebuttal.
Okay, no problem.
Thank you, Dalton. Okay. Are you asking a question of staff or?
I'd like to answer the constituents' question.
Yeah.
Your public comment, I'll take it at the end.
All right, Commissioner Feltz.
The project is in District 5, Mr. Nelson. The project is in District 5. It would be appropriate if we had a map up there to make sure we all knew. Could we get that up there? You'll notice that this is the project that was in very close proximity to Lake Manatee State Park. The district, this also was one right on Bournside Boulevard, so Bournside 64. We don't get to District 1 until 675. So this would be Dr. McCann's district, and I defer to him for discussion. Thank you.
All right. Are there any questions of staff regarding this item? All right, applicant, your rebuttal.
Well, I want to make sure, I don't know it matters what district it's in necessarily. You can vote for it if you'd like. It's on the north side of State Road 64 between Uline and Borenstein Road, and it is part of the Lakewood Ranch Stewardship District.
Thank you, sir. Kevin, anything from staff?
No, sir.
All right, thank you. All right, any more deliberation or discussion? There has been a motion made by Commissioner Sadiq, seconded by Commissioner Ballard. Everyone cast their votes at this time. And the motion carries 4-3. All right, Ms. Knapp, can you read item number 6 into the record, please?
Item number 6 is execution of a land use restriction agreement for the Livable Manatee Single Family Rental Incentive Program for Lily Chu Revotable Living Trust, DTD. The Lorraine Crossings West Affordable Housing Units located at 3518 Lorraine Road. And your staff presenter, I believe, is Rachel Layton.
Okay, is there any ex parte regards this? No. All right, thank you.
I don't think
Yeah, it's quasi. And what, it doesn't say, it says, doesn't say anything on my
And
agenda.
Mr. Chair, legislative,
Okay,
sorry.
it doesn't say anything on my agenda which one it is, so I assume it's quasi, so. All right, so it's not quasi, so. Ms. Layton, you're up.
Good morning, Rachel Layton for staff. I have been sworn, and I'm a resident of Manatee County.
Right.
Would you like the applicant presentation on
Yeah,
this?
I'd like, let's do the
Okay.
applicant first. I didn't know if staff wanted to present or not. Be it, it was.
I'll just answer questions.
Okay, thank you.
Thank you.
All right, thank you. Mr. Russo.
Good morning, Mr. Chairman, again, and members of the board. I'm Scott Rudisill. For the record, I've been sworn. This is a project that was approved under the Livable Manatee program. It is 66 units, single-family attached units located on the west side of Lorraine Road. As part of that program, the applicant is required to execute a land use restriction agreement to ensure the affordability of those particular units. And so that is what is before you today. Our client is at the final site plan stage. They have sign off from all the county departments. So this is the last piece that is waiting for approval prior to final site plan. So happy to answer any questions that the board may have.
All right, Dr. McCann, you're on the board.
When you say this is the final approval, can you explain to me what that means?
Sure. So when we came forward originally, it was for a rezone with a preliminary site plan, and so that was the approval that was obtained last year. And so the next step is a final site plan and construction plan approval. So it's a more detailed level of planning and engineering on the project for all the horizontal improvements. And so that's the stage, right now, that's the stage that the county requires the applicant to execute the LURA.
Okay, so it hasn't been finally approved, it hasn't been approved to build yet?
That's correct. That would be, the next step would be building permits.
Okay, and you need this in order to do that. I've been out to the site there. Can you tell me what kind of infrastructure is there now?
In terms of the,
In terms of roads, in terms of sewage, in terms of, water, is there anything in that land now that's usable?
so obviously the Lorraine in that section is a 2-lane segment right now, planned for 4. This project will be, we're in discussions with staff. We have a draft agreement to extend the sewer force main in that location. So that would be done as part of this project.
Okay, when you say Lorraine's going to be a 4-lane road there, when?
Well, that is a fine question. My understanding is that is currently scheduled for sometime between 2026 and 2030.
Okay, and right now, all you have there is a right turn out and a right turn in, is that correct? You could only turn right onto Lorraine Road. You can't turn left onto Lorraine Road from that project, correct?
I don't know the answer to that, actually. I don't.
Okay.
Well, staff will when she gets up. When staff gets up, she will.
Yeah, I just don't know if there's a barrier in that location or not.
Is that it, Dr. McCann?
Let's hear the staff presentation
Well,
on that.
Well, we'll let the applicant finish, and then staff will come up for their presentation. That's the way it works.
Okay, I don't have any more questions. I obviously ask questions I know the answers to.
All right. Well, Commissioner Bearden's on the board. Is that for applicant?
Yeah.
Okay, thanks.
Yeah, thank you, Mr. Chair. No, I don't think I was in favor of this project as well in the past, so I'm going to be a no on this, just so everybody knows.
Okay. All right. Rachel.
Rachel Layton for staff. I am a certified planner with 27 years' experience and a county resident, so I want to just kind of make sure that the new commissioners know a little bit of history about me. So Lorraine Road today is an unrestricted condition, so they would be able to unrestricted make a right or left in and out of that property. No construction has begun on this site because staff have not been able to administratively approve their final site plan and construction plan because it's reliant on the land use restriction agreement to be signed by the board, approved by the board, and then recorded. So in their incentives package, they were granted expedited review and permitting, which we have been navigating with them on behalf of their contribution to include 17 affordable housing units at the 81 to 120% of the area median income. They're also codifying by way of the land use restriction the 66 dwelling units on site, which is the density bonus they requested during plan development review. But there were no financial incentives requested with this transaction.
Commissioner Cruz.
Yeah, I just want to point out, this is a LURA agreement. This is a document that we put together that we request of the applicant, not the applicant begging us to sign. It's restricting the applicant's ability to rent things in exchange for incentives that we presently have in our comprehensive plan. Some of those incentives I don't agree with. You know, talk to me about our mixed use incentive, which I hate every time it comes up. But it's in the comp plan until I can get it out. And this board, fortunately, has 7 of us that can modify that comp plan, and we're actively working on it. So if you want to have discussions about what our affordable housing density bonuses are, what the AMIs are, we've talked about getting rid of the 120%. But I can't do it now, and it's in the comprehensive plan. And when we vote on things, it has to do with, does it conform to a comprehensive plan? This project came to us with zoning that they had a right to take and asked for density bonuses based upon incentives that are currently in our code. We agreed to give them that density in exchange for them promising something. This is documenting word for word the promise that we asked them to make to us. So my concern is if you push back on a LURA agreement, you're basically saying, we asked you to do something in exchange for something, and now we're refusing to allow you to do what we asked you to do, like by not signing this document. They're not coming to us renegotiating. They're not saying, oh, I want to do 10% or I want 150% AMI. They're honoring a commitment to us that we as a board, admittedly a different set of board, we asked for a commitment, and they're here today to honor the commitment that we asked for, and now we're refusing to accept the commitment from them that we asked for. That's bad business practice, honestly, when it comes to LURAs. This is not an approval of a project. This is an acceptance of a letter that we asked them to write for us. And they're trying to hand it to us, and now we're saying, whoa, we don't give me that letter that I asked for anymore. I've changed my mind. I'm reneging on our agreement. And that's tough pill to swallow, especially since we say we want more affordable housing. And everyone always says, not in my backyard. Every time I approve an affordable housing project out in Onico or someplace else, they're like, you would never want one in Lakewood Ranch. You never want one in your neighborhood. The stores and restaurants and businesses in Lakewood Ranch are clamoring for affordable housing. Why? Because someone's serving coffee at a Starbucks and working at a First Watch and working down Lakewood Ranch Main Street. There is no affordable housing there, and we have no bus service there. They're begging for apartments like this. And recently, this board has approved not 1, but 3 different projects with affordable housing components in it, 1 on Lena Road and 2 on Lorraine, to start allowing the workforce in Lakewood Ranch to have an affordable place to live. And this developer came forward and proposed a project that gets us the type of mixed income housing that we are currently lacking in the entirety of Lakewood Ranch community. And to pull back and say, we've changed our mind, we don't want affordable housing there anymore, they still have the rights to build the project. They would just have to build less units, 0 of which is affordable, because we're going to refuse to accept the exact letter that we asked them to do based exactly word for word on the Livable Manatee program we have in place that's codified in our code today. I just think that's bad practice. If we want to have a further discussion about changing Livable Manatee or changing our code, That's a great topic to have, and we will have that topic as we rewrite and update our comprehensive plan, our land development code. But that's not something you rewrite from the dais today after somebody's coming in with what we asked them to come in with.
Thank you, sir. Commissioner McCann.
I understand what your previous board did. I don't know how many people have been out to that site and how many people can see the building on there. I've talked to the people in Savannah. It's right next to Savannah. It's right off 64. I tried to turn into it, and I almost missed the turn into it. The thing is that the infrastructure is not there in place. At the last meeting, we talked about putting the infrastructure concurrently with the building. We know that that road is not going to be available until 2030. Okay, I talked to the traffic engineers about that yesterday. If we look at what the Planning Commission wrote as the disadvantages there, they were the ones that signaled there's only a right turn out of there and a right turn into there from 64. They indicated that there was no, ability to turn in the other direction. It's a very narrow road over there. And the thing is that, it just doesn't have the ability to house 66 more units on it and, put all that traffic out there. There is no way to get out of there. If you're working on 64, you're going to have to turn right. You're going to have to go all the way around and come back to your place of work. If you want to come home, you can't go down Lorraine. You're going to have to go down 64 and come back into that place. For them, for us to even ask for something like this right now and for them to proceed to go forward is not something that, we would favor in our district. And we took a look at this place. I drove there myself. So, I understand what Commissioner Cruz is saying and what happened. I don't know what his vote was on that last time. But again, if the board voted to have this kind of language or something put in there, well, the last board did a lot of things that they probably shouldn't have done. And, right now, I'm speaking on behalf of my constituents and myself going to this site and saying that it's inadequate for what they want to do.
Just to quickly clarify, not only did I vote yes on this, but I made the motion to approve it.
Thank you, sir. All right, Commissioner Bearden.
Thank you, Mr. Chair, and Commissioner McCann and Commissioner Cruz make solid points, but I don't know if I agree with Commissioner Cruz in regards to this. What you're essentially telling me to do is I voted no on this, and you're saying I need to say yes on this, even though I voted no on it, and I'm not going to be there with that. So I knew when I first voted no on this particular project that it was going to add more cars on Lorraine Road, and I just didn't want to do that. I don't want to add any more cars on Lorraine Road because I used to drive on that road every single day. So again, I just fundamentally disagree with you again in regards to just saying yes to something when I said no, when I stated no before, voted no before. So thank you, Mr. Chair.
Very good. I'm on the board. I got a question for Rachel. Rachel, if this ordinance gets signed, how many units could they build on this? They already have the right to build. So how many units could be built if they wouldn't if the LoRa wasn't in place?
I need to phone a friend.
Huh?
I need to phone a friend.
Okay.
I don't know what the acreage of the site is, to be able to get you the math.
Doesn't it just double the density? Wouldn't it be approximately 33 to 35?
35 units, something like
It's
that?
UF3, but I don't know the acreage of the parcel. So I'm looking to Nicole or Scott to tell me the acreage.
Yeah, I don't remember the exact acreage it was, but the density that was approved was actually well under what would be allowed. Because in the UF3, under livable Manatee, you could go to 9 units the acre. What was approved here was 6.85 for the 66 units.
Okay.
So it was less than.
Yeah, 30-something units. Okay. All right, thank you. All right, is there any other questions of staff? All right, look, I got my question. I mean, we know in general, so
Okay.
I don't need an exact to the,
It would be around 27 or 28.
okay, so close to 30, okay. All right, thank you very much. All right, any other questions, staff? All right, any public thank you, staff. Any public comment?
You said that was the last.
Yeah, I'm not recognizing you, Glenn. You said it was the last one.
Glenn Gibelina, for the record, this is for affordable housing, so doing 2 terms of affordable housing, I know a little bit about Laura's. I think if all the components work, I think if the traffic works, the density works, Laura is a wonderful document. Needs to be tweaked, get out of that 120 zone, get back where we need to get. But I believe you want affordable housing, every development, your 300, your 700, your 5,400 houses, should have a LoRa of a minimum of 10%. You want 5,000 houses? We need 500 that be affordable, or you're not getting a permit. They do it in other parts of the country where affordable housing is tough. George, Commissioner Cruz, you brought up a good point. We have service workers that are dying for affordable housing. We have hospitality industry. We have hotel maids. We all need affordable housing. And I think moving forward, there should not be a development approved without a LoRa. 10% aside, school teachers, firefighters, our sheriff, they all should be able to afford to live in that gated community. So LoRas are great if they're used properly and it's zoned right and all the numbers work. But I think every development should have a LoRa, not 25 years, 50 years. Thank you.
Thank you, sir. I'm trying to get it board up. All right, Dr. McCann. Oh, you got more public. I'm sorry, sir.
Yes, my name is James Alvino. I have not been sworn.
It's not, yeah, you don't have to be sworn.
I know we're speaking about affordable housing here, and I just wonder if you guys all know what the actual limits are to be qualified for affordable housing, because I had an uncle that came to live with me who fell on some hard times. As we know, the economy has been quite tough, and he found a job, and he tried to apply for affordable housing. As we know, there's basically none available here in Manatee County, but after about 8 months of searching, we did find some. He applied only to be denied because with a full-time job as a security guard, making a whole whopping $17 an hour, that didn't qualify for him to live in affordable housing. So his take-home pay was too high, and meanwhile, at the same time, he could afford 0 places here in Manatee County. Presently, he finally found a place to go to, but he is staying in essentially a converted hotel on a weekly rental. And that's essentially the state of, we talk about affordable housing. The whole system, in my opinion, for affordable housing is pretty broken. It is good in theory, but the income limit for it actually to qualify apparently is around $21,000 a year, which essentially means you need to have a part-time job at the current at base wage, essentially. So if a security guard with a full-time job can't get into affordable housing, I don't really know who would. So essentially attaching affordable housing, I don't know if that really does anything for our community. Yeah, I just wanted to put that in there. So thank you.
Thank you, sir. Mister, you could please state your name and county residence.
I'm Arlo Leinhart, Pinellas County. I wasn't going to come up here and speak, but gentleman actually composed me to come up here and actually discuss an issue about affordable housing. When the gentleman mentioned affordable housing in other states, he probably failed to mention those were probably most likely blue states where crippling regulations have caused housing to explode out of control. And if you want affordable housing, we put in the hands of private industry, we'll actually build more. If you want affordable housing, you build more. It's called supply and demand. We build less, prices go up. Demand is higher. You want more, we build more. So I guess certain people might have to educate themselves on how supply and demand works, how Florida is one of the top growing states in the country. You can't stop growth in the state of Florida. No more than you can stop the sun from setting. So I would like to challenge a lot of our new commissioners to take that into consideration, and also take into consideration the very fact that talking about putting moratoriums on development, talking about stopping talking about stopping housing is more talk for more government regulations and more increase on costs. Thank you.
Thank you, sir. Is there anyone else in the room like to come give public comment on this item? All right, being that this is not quasi, it's legislative, is there anyone on the phone that would like to give comment on this item?
No callers, Mr. Chair.
All right, thank you very much. With that, I'll go ahead and close public comment, but I do have several commissioners on the board. And Commissioner McCann, you were on the board.
This isn't a question of affordable housing. This is actually a question of the affordable housing in that area right there. You know, we definitely need affordable housing in Lakewood Ranch. There's no question. We have a lot of people working there that can't live there. We don't want more cars on the road. We don't want them driving in from other places. You know, we would like to have affordable housing in Lakewood Ranch and in East County. But the thing is, at this place here where we're talking about this specific thing right now and opening this up to affordable housing, it just doesn't work. We had a meeting 2 days ago, and in that meeting 2 days ago, we talked about concurrency with roads, we talked about concurrency with putting things together, and we had a 7-0 vote that actually said, we are going to do this, okay? So now we need to do what we voted in 2 days ago and say that this does not conform to what we need for the affordable housing because the roads and the infrastructure are not there.
All right, sure, thank you. Commissioner Bearden?
Thank you, Mr. Chair, and I completely agree with Commissioner McCann. However, I don't fundamentally agree with Glenn on the issue of we need to have every developer get a LoRa. I don't know about that, but do completely agree with Commissioner McCann on this issue. Thank you, Mr. Chair.
Thank you, sir. Commissioner Cruz?
I came on just to respond to two people in the public, but real quick, I will point out, as we're talking about things we've recently discussed and plans we have for the future, they don't exist today. And we as a board, especially when it comes to land use meetings, are bound to honoring the codes and the comp plans and the application process that exist at the present time, at the time of the application, not upon hypothetical future things based upon conversations about what we plan to do. And even if we do those things, there's grandfathered in clauses in Florida statute, and if applications have already been submitted before we change anything, they still get to be bound by the previous version. So conversations about, you know, concurrency and so forth, which I 100%, I'm looking forward to those conversations. They don't exist today, and applications in front of us today are not bound by those, even if they got changed tomorrow. As for the two comments, Glenn, inclusionary zoning is not even legal in the state of Florida. You can have voluntary inclusionary zoning, which is what we do. That's where the incentives come in. That's where the LoRas come in. You can't have mandatory inclusionary zoning because the municipality has to effectively pay the cost of that burden, for lack of a better term, it's in the thing, to the developer. So you can force somebody, and there are some places, you said there was, that require 10% affordable. But to force that 10%, you also have to give them additional density to compensate them for that, which just creates more density in every project we do everywhere. So if the complaint is there's too much traffic, too many cars, schools are too congested, what you're proposing is make everyone build affordable housing, but also make everyone build even more and cram even more stuff onto every lot in exchange for it, which I think starts exacerbating a different problem. So I think you start causing more of a problem than you solve on that. I think our solution of optional is the better option today. There are some other options we're going to talk about, one of which being ADUs later in this evening. As for the other thing, the HUD limits, I don't know where he was looking for a property. There are different levels. What your income level is has to do with what the agreement is for affordability. There are some places, you go to Astoria on 9th, for instance, they use 9% low-income housing tax credits. They have some units that are restricted at 15 and 30% AMI. That's a very, very low number. That's what they use to incentivize getting those tax credits. Most of what you're gonna see in Manatee County is at the 80% or 120% level. Those are the other extreme. They're so insanely high in terms of what the income limits is, that even people that don't technically need affordable housing as you see it, qualify for it, and the rents are actually higher than what our market rents are. That's why 120% is a broken metric and doesn't work. I'm looking at HUD for right now. Manatee County HUD at 120% for a single person, not a family collecting money, is $84,000 of income for one person qualifies for that affordable housing unit. So it's a broken system. So most of what we're concerned with is the other extreme. If he couldn't get in because of 17,000, he was probably looking for one of the few units that are using 9% tax credits that do have very, very low income limits for a very specific reason, and it's usually only a handful of their units.
Thank you, sir. Commissioner,
I took myself off the board because I wanted to address what Commissioner Cruz just
okay.
talked about.
All right, thank you. Commissioner Siddiq?
Thank you, Mr. Chair. I think it's pretty clear over the past 2 weeks, we have a board that's very passionate about affordable housing. And I think seeing the market provide that, it's going to be, I would obviously prefer to see that. But we've taken some motion, I won't belabor the point, to approve a motion to investigate whether gap financing is an option and other mechanisms to provide the market to be able to penetrate into an area that it hasn't been able to in the past couple of years. So we have that on the radar. Please look out for that. And I'd just like us to get back on track on this particular item. We have a lot of great comments and topics, but let's kind of get back to the specific, Laura. If you are entertaining motions, Mr. Chair, I'd like to motion to approve this.
I'll second.
Dr. McCann's on the board.
Well, the motions are definitely out of order because we aren't done yet. The second thing is, I have a question for Commissioner Cruz. Since we weren't making an ordinance or a law, when we made our decision on 2 days ago, we were talking on board procedure and how we would be looking at concurrency. Those are not law in itself. So when does that go into effect? Was it just a nebulous vote that meant nothing? Or was that something that goes into effect immediately and it talks about this board and not necessarily an ordinance or a law?
I'm confused. We didn't vote on anything that would be even conceivably construed as law. We voted on starting a process to potentially discuss sometime in the future that discussion. You couldn't even extrapolate a law out of the language that was used on this dais 2 days ago.
That's correct. That's why I'm saying, you made it sound like it was being applied retroactively.
I
And
was
you were
implying
talking
that you
about
could not. I literally said the opposite, Dr. McCann. I said you could not retroactively look back on things, and applications already in the process wouldn't be bound by it if we started that process. And I said it certainly can't be bound by it based upon a conversation about thinking about starting that process sometime in the future. So that's why I was just saying, because it was mentioned over there that we discussed concurrency, and this is a perfect example. And I said, whether it's a perfect example or not, it's not relevant to the discussion at hand. And we're discussing a specific motion about a specific request to sign a lawyer agreement that we asked them to sign. And previous discussions about future conversations on concurrency has no relevance in this discussion this morning.
We good? Take it off the board. Commissioner Ballard.
If, I'm ready to vote, so I'd move to call the question if that's not where we're already going.
We don't think we need to. I think we're ready.
I think we are too.
I think we're there. Okay. So we have a motion, we've had public comment, we've had a motion on there's a motion on the board by Commissioner Siddiq, seconded by Commissioner Cruz on item number 6. Everyone cast their votes at this time. And the motion carries 4-3. Thank you very much. Yeah, I'm going to pull it right now. All right, we're at 11:53. What I'd like to do is have everyone back by 1 o'clock. We're going to recess for lunch right now. Thank you very much. And we are back from our lunch recess. We'll pick up where we left off. We're under presentations upon request. Ms. Knapp, can you read item 7 into the record, please?
Item number 7 is LDCT 2402, ordinance number 2450, County-Initiated Land Development Code text amendment regarding mobile vending. This item has been requested to be continued to January 14th, 2025 at 9 a.m. or soon thereafter, as may be heard.
All right, thank you very much. This is an item to be continued. There is a motion up on the board. Commissioner Cruz has moved it. Commissioner Siddiq has seconded it. Is there any public comment regarding the continuation of this item? All right, I'll see none. I will go ahead and close public comment. And if you cast your votes at this time. It moves 7-0 with Commissioner Bearden not in his seat. All right, so Ms. Knapp, can you read item number 8 into the record?
Item number 8 is LDCT 2404, ordinance 2465, County-Initiated Land Development Code text amendment regarding Chapter 10. This is a general cleanup, and this item is requested to be continued to January 14th, 2025 at 9 a.m. or soon thereafter, as may be heard.
All right, thank you, ma'am. There's a motion up on the board. Moved by Commissioner Siddiq, seconded by Commissioner Feltz. I'll open this up for public comment. Does anyone in the public like to comment on the continuation of this item? Seeing none, I'll close public comment. If everyone can cast their votes at this time. And the motion carries 6-0 with Commissioner Bearden not here. All right, Ms. Knapp, can you read item 10 into the record, please?
Item number 10 is Z24-10, Shria Lakewood Ranch Real Estate LLC. This is a rezone of approximately 5 acres, generally located 800 feet south of Rangeland Parkway, approximately 500 feet north of 59th Avenue East, on the east side of Lorraine Road, from General Agricultural Special Treatment Overlay Evers Reservoir Watershed to General Commercial Zoning District, retaining the overlays. And your staff presenter, should you need one, is CJ Mills.
Would anyone on the commission like a presentation on this item? All right, seeing
Yes,
none.
I would.
All right. All right. We are, okay, so we're going to do the presentation on item number 10. Is there any ex parte regarding item number 10? All right, seeing none, thank you very much. Is the applicant here for the presentation? Good afternoon, Mr. Roussel.
Good afternoon, Commissioners. For the record, I'm Scott Rudisill with Blaylock Walters Law Firm. I'm here on behalf of the applicant, and I have been sworn. I have just a brief PowerPoint presentation, and I'm going to turn it over to Bob Schmidt. He is our planner on this project. He is an AICP certified planner and has been doing this a long time. Okay, so this is an aerial of the project site. It is approximately 5 acres located on the east side of Lorraine Road between State Road 70 and Rangeland. This is the zoning map. The property is currently zoned A. Future land use designation on the site is Res 1. There was a Scrivener's error on the future land use map, so when you pull this site up on the GIS, it actually shows as MUCAC1, which is part of SMR's activity center to the east. It is not. It is in the Res 1 future land use category, which limits the potential uses of this site to neighborhood serving commercial only. And this is a map that just shows the current and proposed development projects in this area. As you can see, this is a mixed-use activity node. You've got everything from commercial shopping centers, fairly dense multifamily with Oasis, church, Preco facility, Lakewood Ranch IDA operations, self-storage, single family. I mean, it's got pretty much everything just in that one little quadrant. So it is a mixed-use area, and we think the proposed commercial zoning is appropriate and compatible. So with that, I'm going to turn it over to Bob.
Good afternoon, Commissioners. For the record, my name is Bob Schmidt with Land Planning Associates, and I have been sworn. I'm glad that Scott left this slide up because, as he mentioned, I won't be redundant, but this is a rezone of 5 acres from A to general commercial. The property is currently vacant. It's just north of the Risen Savior Lutheran Church there. And there are a mix of uses around the parcel. When the client contacted me initially, there is the parcel that doesn't have any color on it, just to the north and the east of the subject parcel, is owned by the school board for future school use. And when my client contacted me, I asked him what he wanted to do with the property. And I know this is a straight rezone, but we are limited to neighborhood commercial uses at this location because of the Res 1 future land use category. He already has a contract for a daycare center of 12,000 square feet, which blends very well with schools. There is enough room to build a couple other things, and he is entertaining things like dance studios, other school-related types of uses, even possibly an ice cream shop or something like that. So that's his plan for the property. And again, we are limited to the neighborhood commercial uses by code, and there's also a deed restriction on the property that limits the uses. So you won't see a racetrack or any sort of a heavy, intense commercial use at this location, and there's frankly no market for it. With that said, I did read the staff report as a professional planner, concur with its findings. The project is consistent with the comprehensive plan and the land development code, and therefore we ask for your approval. And with that, Scott or I will be happy to answer any questions.
Thank you very much. Is there any questions of the applicant? All right, see none on the board. Thank you very much. Staff, you're up.
All right, good afternoon, Commissioners. My name is CJ Mills with staff, and I have been sworn. I'm not going to be redundant with the location we know and the intent to rezone to general commercial. I will give a little bit of history on the site. It is, since the adoption of our land development code, it has been zoned general agriculture. And since from the adoption of the comprehensive plan, it has been held the Res 1 future land use category. Again, these are the range of potential uses. As they noted, neighborhood commercial is one of them, and also school uses. This is the Scrivener's error on the GIS. This says MUCAC 1, but it is actually Res 1. Some of the intended uses of general agriculture is to preserve agricultural land and allow for coexistence of other uses generally consistent with agricultural activities and protect from the encroachment of incompatible uses. General commercial is retail use and service in freestanding parcels, generally related to community general commercial needs, and then also to facilitate attached dwellings, multifamily residential units. There are a few overlays on the site. There's special treatment and then the Evers Reservoir watershed protection overlay. I do want to note that this does increase the minimum open space required from 15 to 30%. The consistency with the comprehensive plan can be found with the 2.2192, again, neighborhood commercial uses and school uses, and the density and maximum floor area ratio allowed can be found consistent with the Res 1 future land use category. The positive aspects is that the property is located within an activity node where commercial development is encouraged, and the increase in trips will occur on a major county thoroughfare with adequate infrastructure. Some of the negative impacts are the maximum allowed height in GC and could be incompatible with adjacent properties, and the GC allows for more intensive uses in the current zoning district. That being said, neighborhood commercial would be as intensive as you can get. Some of those mitigating measures are the fact that there are no residential uses adjacent to the property, and at time of FSP review, the development of the site shall comply with all applicable provisions of the LDC. Opinion of staff, the proposed rezone is consistent and compliant with our comprehensive plan and land development code, and I'll be here if you have any questions.
Okay, thank you. Commissioner Bearden's on the board.
Thank you, Mr. Chair. Just a quick question. What's the percentage increase in traffic based on this rezoning on that road?
For that, I would have to defer to Nelson Galliano, our transportation planner.
Good afternoon, Nelson Galeano, Transportation Planning, and I have been served. Regarding this rezone, let me clarify that we always work on the rezones with the worst, most probable scenario. It means we pick the land use in terms of the high intensity that is allowed for any rezone. In this case, we pick the general commercial. It means the shopping center land use. And the project will generate approximately, under these conditions, during the PM peak hour, about 500 trips on, and the roadway on Lorraine has enough capacity to support this type of trips that the project generates on the roadway network.
You good? All right, thank you. Commissioner Cruz.
This is just a clarification question. This goes back to staff in general. One of your slides said the future land use is Res 1. I'm trying to figure out where Res 1 comes in. It's zone ag, and we're saying that the future land use is mixed use, commercial or community, but where's that res, right there? What does that asterisk mean?
So the error is on GIS. The property was mistakenly included in the GIS mapping with the northeast quadrant, but it is actually Res 1.
So wait, so all this conversation, this whole package is based upon some preconceived assumption that this is a mixed-use future land use category to justify the general commercial and everything else being requested, but you're saying that's more of a Scrivener's error mistake on a website, and this is not mixed use. This is Res 1 as its future land. It's ag today, and they're effectively being given the rights to Res 1 as a future zoning. How do we move, where's the linear path? I see the linear path from ag to Res 1. That's future land use map. I get that, and I support that. That's part of the comprehensive plan. Where's my path getting me from Res 1 to general commercial as an implementing zoning right? Other than just asking us to change the zoning blindly. This isn't, before it was saying it's mixed use, and you can kind of also just assume it's general commercial. That's a zoning classification within mixed use. But you're saying this is not actually mixed use. That's a mistake. And we're not going to be bound by a mistake. I mean, a typo is a typo. It doesn't mean we change the dynamics of the world in real life over a typo. So this is not mixed use. This is Res 1. It's being asked to to increase the zoning to general commercial blindly. There's no progression to get to that other than our vote.
So the general commercial zoning district is an implementing zoning district for Res 1 if it is meeting commercial locational criteria.
And you're saying this does because?
Is within 1,500 feet of an activity node, which would be at Lorraine and Rangeland.
How many feet is that? 1,499?
No, I think it's around 1,300 for the full property. And I will say that because it is Res 1, it does increase the maximum floor area ratio from what we thought was 1.0 in MUCAC1 to 0.35. So it decreases the actual amount of building entitlements possible on the property.
By a lot.
Yes. So the fact that it is Res 1 instead of MUCAC1 is actually a benefit and makes it more applicable and compatible with the surrounding areas.
Well, do you put a big building on there?
I'm sorry?
Okay, you answered my question. I mean, I wish that would have been a little bit more clearly defined in all the information I was reading through. I didn't even realize this R1 popped in until your slide, only because I happened to be looking at it when you put the slide up. That seemed to be quite a miss in the, it should have been like bolded on this staff report somewhere. Okay, thank you.
I do just want to say that the staff report has been corrected to reflect the residential
I'm
one.
literally reading it. Right here, there's an analysis on page 12 that says, though not required, blah, blah, it does meet commercial location criteria, per policy, whatever, mixed-use commercial, and then you go into a whole big deal about mixed-use commercial in the staff report I'm looking at on the current on-base agenda. So maybe it's been corrected, just not updated with the corrected version. So, okay. Thank you. I appreciate the clarification.
Thank you, sir. Commissioner Bearden.
Thank you, Mr. Chair.
They'll need to adjourn.
Okay. I'm very familiar with this road and the traffic coming in and out of that Publix, and I just know that increasing it to commercial is gonna add even more traffic onto that road until we have improvements. Like, if that road was improved today, I'd approve this. I'd be yes vote on this up zone all day long. But until I see those improvements on that road, I just can't continue to add more road or add more cars onto that road.
It's right there. Okay. That's
I mean, I like the fact that you are putting commercial there. It's just, I don't know if I'm ready to be a yes on this right now. Thank you, Mr. Chair.
All right, any other questions of staff?
I don't want to I just want to clarify, just to
Yes, sir.
correct myself, because I corrected you somewhat incorrectly. There is a revised staff report. It's 13 items down on my agenda thing. The old staff report is at the top, which is what I'm reading, because that's where staff reports are supposed to go. All the way down here on the bottom is revised, and it does in fact reflect Res 1. So I just want to make sure publicly, you were correct. You did update the staff report. I just missed it. It's in a different place.
Appreciate the clarification, Commissioner.
All right, any other questions, staff? I will open this up for public comment. Is there anyone in the room that'd like to give public comment on this item? Seeing none, I'll go ahead and close public comment. And staff closing comments. Nothing? You guys good? Applicant, you ready?
Thank you, Mr. Chairman. The only thing I wanted to clarify very quickly, as it related to Nelson's comments on the traffic impacts, our traffic impact analysis was based on when we all thought that this was an MUCAC1 site. And so and you plan for in that study the most potential transportation impacts that could be accommodated under that category. And so when we went to Res 1, it actually limits the potential square footage on the site by about a third of what's allowed in MUCAC1. So only point being, even under that traffic analysis, we will have significantly less transportation trips than that.
Commissioner Bearden?
Thank you, Mr. Chair. So, quick question for you. Would you be willing to allow that section to be rebuilt before you guys offer a CO? That particular section where it's, we're gonna, to be widened until we issue guys out, let a CO be issued before, right?
Yeah. I understand.
You understand what I'm saying?
Yeah, I understand.
I want the road built first before you issue out a CO.
Right.
Will your applicant allow that to happen? Because if it is, I'll give you a yes vote today.
No,
Okay.
I appreciate the comment. This is a straight rezone, though, so we don't stipulate these like we would on a planned development project where we'd come in and say, hey, this is, we're adding this stipulation and that. This is just a straight rezone to GC, so we don't really have the ability to do that.
Well,
But,
I'm asking you here on record.
right, I understand.
I mean, let's negotiate right now. Let's make this happen.
Do you know what the client?
Madam Chair.
Well, thank you again. Commissioner Bearden, the answer to your question is, I don't think my client can agree to it, only because the timing of the opening of the daycare center, he wants to be consistent with the timing of the schools. And the schools aren't built yet, though. But that is something that the school year, regardless if those new schools are there yet or not, play into it. And I have a feeling he would not want to agree to that.
Okay, thank you, sir.
Thank you.
All right. Applicant's rebuttal. Okay, do we have a motion on the board? Yep. Someone wants to move the motion? Huh? I
Go for it.
I'll hand the gavel to Commissioner. Okay. Moved by Commissioner Siddiq. Yeah, we did. I opened the public comment. Nobody showed up. Okay, the motion's been moved by Commissioner Siddiq, seconded by myself. If anyone would cast their votes at this time. Please cast your votes. Please cast your votes. All right. And the motion fails. What?
Oh, hold on.
What?
Commissioner Cruz's vote didn't get counted.
It doesn't matter, it failed, whether
Yeah, the motion fails 2-4. All right, thank you very much.
Well,
Ms.
wait a minute, Mr. Chair.
Yeah, there you go.
So whenever you have a denial, you always have to have written findings of fact report back at a subsequent meeting. So I have to, oh, are you going to vote? Motion approved, fail, are you going to move to vote to deny?
Yes.
So I need to know.
Yeah.
Okay, when we do that, then I'll have to add to the denial motion at the end and direct the county attorney's office to read back written findings of fact at the next land use meeting.
Yes, ma'am. Thank you. All right, the next, Ms. Knapp, can you read item 11 into the record, please?
Item number 11 is PA 2416, ordinance 2494, capital improvements element.
Well, wait a minute. So you have to, is someone going to move to deny this then?
Item number 10 was moved, it was 2-4 to deny.
So the motion
The-
was to
the-
approve.
Yes,
Yeah,
so
the
we
motion
have
was to
a denial
approve.
motion. We need another
Okay.
motion.
Oh, yeah, you got to bring another motion up.
So I need to have the findings in there, inconsistent with comprehensive plan and non-compliance with LDC provisions. So the denial motions as stated in the form with the added sentence, and direct the county attorney's office to read back written findings for denial to the next land use meeting on January 8th, 2025.
No. Ow.
No, I made the motion to approve and the motion to deny.
I mean,
To deny.
yeah. So, you make it, seriously?
business going,
I guess, okay, this is the, there's been a motion to deny moved by Commissioner Siddiq, seconded by Commissioner Ballard. All those, if you'd cast your votes in the motion to deny, cast them now. Okay, I was standing by my original vote, but okay, the motion to deny carries 6-1. All right, Ms. Knapp, could you read? Sorry. Can you read?
Agenda item number 11,
Yes,
PA
ma'am.
2416, ordinance 2494, capital improvements element. This is a comprehensive plan amendment updating the schedule of capital improvement projects, general government and enterprise operations, funding, revenue sources and account amounts, 5-year schedule of capital improvements, expenditure summary, summary of revenues, expenditures for capital projects and capital project funds, potential revenue sources applicable to fiscal years 2025 through 2029, and updating locational capital improvement maps and updating policy 10.2.1.3 to amend the adoption date of the educational facilities work plan by the school board. And your staff presenter, should you need one, is Elizabeth Schulman.
All right, is anyone on the board like a presentation on item 11? Seeing none, I'll go ahead and open it up. This is legislative, so I'll open up for anyone on the phone that would like to give comment.
No callers, Mr. Chair.
Is anyone in the room that would like to give comment on item number 11? I do have a speaker on the board, Commissioner Cruz.
Yeah, I just wanted to clarify, because I did speak to Public Works about this. This is just a standard annual report we have to submit, so just if the public's looking at it, this isn't us confirming anything on here, we're not agreeing to anything on here, we're just submitting a report based upon a previous CIP. I've already talked to Public Works as well as County Administrator. We are going to have a long work session on this, so everyone can opine on what they do and don't like about CIPs, whether they be parks or roads or sidewalks. So this board can have some meaningful input on how we move forward with future CIP projects. This is just an approval of a previous CIP to finish up the year before we all have that conversation.
Okay, thank you, sir. All right, see, there's no public comment. I'll go ahead and close public comment. There is a motion on the board.
Yeah, the motion's not up.
You don't have it? It says motion, okay, there it is. Okay. Yeah, I mean, yeah, we're clicking it and nothing's happening. Commissioner Ballard's about to bang a hole through her laptop.
Motion to approve.
All right.
Second.
Motion's been moved by Commissioner Cruz, seconded by Commissioner Ballard. All those in favor by voice vote, say aye.
Aye.
All right, the motion carries 7-0. Ms. Knapp, can you read item number 12 into the record, please.
Item number 12, ZL 2404, MSB North Yard, MSB Real Estate LLC. This is a rezone of approximately 3.71 acres, generally located approximately 730 feet west of the intersection of Lena Road and 81st Court East, from suburban agricultural to light manufacturing limited zoning district. And your staff presenter, should you need one, is James McDevitt.
All right, thanks. 1 minute, some technical. I'm still seeing item number 11 when I click current. Yeah,
Same.
so, all right. Is everybody reconnecting?
Yep.
All right. Well, I'm number 12. The documents, current item. It's still showing item 11, waiting for a motion. I know we probably didn't feed the hamster, keeps that wheel running at lunch, but we need to do something with them. All right. Yeah, everybody want to go old school on this?
Yeah,
What's
it would be old school, we used to have a binder with the actual,
I know.
I can't look up, I'm using my iPad.
I mean, yeah, I mean,
We need to be able to see the documents.
I know.
Yep.
Yeah, I mean, I can get it on my
I
phone,
use
whatever,
those.
but I mean,
Oh, there we go. I can get to the document.
you got a document now?
Yep.
Yeah, for a second. I'm still showing number 11.
So what I ended up doing is going to agenda
Yeah, yep,
and then
yep. I did the
go
same.
to documents.
I did the same thing.
Hit go to document. There you go.
They're on their
All
way
right,
down.
There you go.
all right,
So now you can see the document.
okay,
And then just go to details.
yeah, I got it. Okay. All right, can everybody see the document? Everybody's got it? Okay, would anyone like you see it, Commissioner Bearden? Click on the little, Commissioner Ballard figured it out.
They're on their way down.
Messed up. All right, has everybody got the document pulled up? This is bogus. So bogus. If you go to agenda, click on the paperclip, go to documents,
And then go to details.
and you can go to, and it'll, details, and it'll show you the cover sheet, and it'll show you the documents. Okay, we're on item number 12.
The whole service went down.
Everybody got it? Everybody see the document? All right. Would anyone like a presentation on item number 12? All right, seeing none? Is there any public comment regarding item number 12 here in the room? We do not allow call-ins because this is quasi. Would you like to comment on the item number 12? All right, seeing none, I'll close public comment. How do we get a motion up then? I guess we'll do,
Voice.
okay. Who said that?
Cruz.
All
Ballard,
right,
second.
Commissioner Cruz, motion to approve, item number 12. Commissioner Ballard seconded, item number 12. All those in favor, by voice vote, say aye.
Aye.
Any opposed? Seeing none, motion carries 7-0. Ms. Knapp, can you read item number 14 into the record, please?
Item number 14 is ZL 2329, Marker 37 Holdings LLC rezone. This is a rezone of two contiguous parcels with a total area of approximately 4.69 acres from general commercial and neighborhood commercial within the coastal planning area and coastal evacuation area overlay districts to light manufacturing limited zoning districts retaining the overlays, generally located on the west side of US 41 at the juncture of US 19 and US 41. And your staff presenter is James McDevitt is filling in for Laura. Thank you.
Ms. Knapp, would anyone like, would anyone like a presentation on this item?
No.
Okay. And there's been no ex parte on this item?
No.
Thank you. All right, I'll open the item up for public comment. Is anyone in the audience that'd like to come forward and give public comment on item number 14? Seeing none, I'll close public comment. Well, let's go back to a voice motion or a verbal motion. All right. All right, the item 14 has been moved by Commissioner Sadiq, seconded by Commissioner Ballard. All those in favor at this time by voice vote, say aye.
Aye.
Aye. Any opposed? The motion carries 7-0. Ms. Knapp, can we read, now we're going on to item, presentation scheduled. First up is item number 9. Ms. Knapp, can you read item number 9 into the record, please?
Item number 9 is ordinance number 2478, establishment of the Firethorn Community Development District, creating section 2890 of the Manatee County Code of Ordinances entitled Firethorn Community Development District, establishing the Firethorn Community Development District pursuant to Chapter 190 of Florida statutes. And your staff presenter is Loretta Merrill.
Okay. Staff's up. This is legislative. And it's county initiated. Wonderful.
Good afternoon, Loretta Merrill with staff.
Let's have Commissioner Cruz on the board. We can do the same things.
All right, we are here for the Firethorn Community Development District. So what is a community development district? CDDs are established through Chapter 190 of the Florida statutes. They are independent units of local special purpose government. They operate independent of the county government and the BOCC in provision of certain services. However, all governmental powers related to planning, environmental and land development laws, regulations, and ordinances are retained by the Manatee County Board of County Commissioners. CDDs have the power to plan, finance, construct, operate, and maintain community-wide infrastructure and services specifically for the benefit of its residents. CDDs serve as a governmental and public purpose by financing, providing, and managing certain basic infrastructure systems, facilities, and services. Only property owners within the district are assessed through the district for these improvements within its boundaries. CDDs benefit residents by allowing them to control the quality of the services they receive. Here's the Firethorn CDD. It is approximately 549.2 acres, generally located west of US 301, north of Buckeye Road in Parrish. It is a residential project approved under PDR 22-21G for 1,540 dwelling units. The request is for you to approve ordinance 24-78, the petition to establish the Firethorn Community Development District. The special powers requested are parks and facilities for indoor and outdoor recreational, cultural, and educational uses, and security, including but not limited to guardhouses, fences, gates, electronic intrusion systems, and patrol cars. The request appears to be consistent with the Uniform Community Development District Act of 1980, the comprehensive plan, and in compliance with the requirements of the Land Development Code. And I'm here if you have any questions.
Does anyone have any questions of staff? Okay, seeing none? All right, this is a legislative matter, so there is no call-ins are allowed. Is there anyone on the phone that'd like to give public comment on item number 9?
No callers, Mr. Chair.
Thank you. Is there anyone in the audience that'd like to come forward and give comment on number 9? Seeing none, I'll go ahead and close public comment. David, are we up and operational yet? Okay. All right, so what we'll do is we'll go by a voice motion again on item number 9. So would like to make a motion on item number 9? I need a,
I think Commissioner Phelps would
You-
like to request to speak.
you know what, you gotta, I can't bring up on the board because the board's not up, so you have to like wave down here. Commissioner Phelps.
Again, this is a development in my district. I'd just like to point out proximity of this to our Hillsborough County line. This does put more of traffic issues onto 301. We don't really have a good map to show you where this is in proximity to our state park, also to acreage with less density, and an unimproved or incomplete work on 301. So I do have some hesitancy in this because we are developing a taxing authority. If you would look at a picture of what we have right now in that area, there is nothing. So doing anything is going to add to your traffic levels, is going to add to your school district. We do not have a school that is not working with portables already. So I would caution, again, any further development in the area without the accompanying infrastructure as far as our roadways and our schools go, and creating another taxing authority that supposedly will pay for it, but I don't know if we have the ability to, if you're not aware, there is right now over the border in Hillsborough County a movement in the Waimama area to also reduce development until 301. At that point is two-lane. So I think that some interlocal discussion should be on the table with this too, because again, my district is dependent on activities in other districts, and I know right now that Waimama is also looking at reducing the amount of development and the stress on their infrastructure. So I think that should be a consideration for this, because as I said, there's nothing there right now. Anything we do puts something there, and we don't have the capacity to handle it right now. That's the facts.
Yes, sir. Commissioner Cruz. All right, thank you. I have a second. I have a motion by Commissioner Cruz to approve, a second by Commissioner Siddiq. By voice vote, well, everyone give their voice vote on this item. Everybody say, those who approve, say aye.
Aye.
Those that oppose?
Aye.
The motion carries 4-3. All right, thank you very much. All right, moving on to item number 13. Ms. Knapp, can you read item number 13 into the record?
Yes, Mr. Chair, but before I do so, if I could just share that the IT and Business Services is working on, we're having internet issues in addition to on-base issues.
We're having internet issues?
Mm-hmm.
We gotta get Skylink in here or something, you know? We have internet, okay.
So item number 13 is Z2414 Red Rooster Road rezone, Triplet Family Trust. A rezone of approximately 5 acres generally located 820 feet south of US 301 and on the west side of Red Rooster Road from general agricultural to agricultural suburban zoning district. And your staff presenter is Alicia Henry.
All right, thank you. Would anyone like a presentation on this item?
Yes.
It's a presentation schedule. All right, staff, you're up, or applicant, you're up. Sorry, Bob.
I thank
Lost
you,
without my
Commissioners.
laptop.
My name is Bob Gauls with Gauls and Associates. I have been sworn. In the interest of, I guess, time, I know Commissioner Phelps wants a presentation. Do you want a full presentation or?
Sure.
Okay, then let's bring it up. All right, this is the Red Rooster Road project. It's the Triplet Family Trust and contract purchaser Sarah Langham. And basically, this request is for a rezone of a 5-acre parcel from agriculture to A1. And there's the property. You can see it's south of US 301. It's actually west of Fort Hamer Road on Red Rooster Road. The future land use for the area is UF3, which allows 3 dwelling units to the acre, 9 dwelling units to the acre if you have a density bonus. The zoning of the property is agriculture. To the north of it is RSF1. To the east and the west are both PDR zoning districts. To the south is agriculture, although ironically, and you'll see it maybe a little more closely in the next slide, but that's actually a 2.5-acre parcel to the south of it. Here's the subject parcel. The parcel to the south is 2.5 acres, and so you may wonder, how can you put a house on a 2.5 acre parcel that's zone A? Well, the answer is that the parcel to the south is also owned by the guy that owns the next parcel to the south, so he does own 5 acres there. So at any rate, but those are actually 2.5 acre parcels. So the RSF 1 to the north has a minimum lot size of 30,000 square feet. The PDR zonings on the east side and the west side, so to speak, have about 0.2 to 0.25 acre lot sizes. And then, as I said, the parcel to the south is 2.5 acres. This site's got 357.75 feet of frontage according to the survey. It's 5 acres. And section 330.2C1CI prohibits flag lots if doing a lot split. That's just to let you know that. So why did my client want the A1? Well, actually what they want to do is they want to split it because they'd like to have the ability to have a second lot for their son to build a house on. So that's sort of what drove this whole thing. They're looking to buy it. It's a nice house on the west end of the property, but if they want their son to be able to build a house on the property, then they need to rezone it from A to A1. So that's sort of what initiated this process. It does comply with the Comprehensive Growth Management Plan. Staff report supports that, and it complies with all applicable LDC review guidelines. There were no comments on this project when we went to the Planning Commission. It was on presentation upon request. There was no comments. It did receive unanimous recommendation for approval from the Planning Commission. So at that point, I'm happy to answer any questions that anyone may have.
Commissioner Feltz, your mic's on, are you?
No.
Okay.
One time I don't want it.
I like it. That's all I gotta
Commissioner
say.
Bearden.
I like it, Mr. Chair, so
Thanks.
I'll vote yes on this.
I think, are there any other questions? Yeah, ma'am, your mic's not on.
Okay, now we do this. I appreciate the presentation. That
No
is
problem.
the reason. The only question that I had when I got my briefing was, and I still haven't gotten it, was we were supposed to present a pic with it. As far as there being no public comment, my question was notification to the area, which staff was supposed to supply me with a picture of where the sign was placed for the public hearing. Did we ever get that?
If I can, we provided staff a picture. We actually always try to do that. I brought this picture up again of the subject parcel. If you look, you can see the driveway to the existing residence is at the south end. The sign was posted at the end of the driveway, right at the property line.
Right.
and
All I had asked for was
and
a proof of the signage being
And we provided
displayed.
this week a copy. The sign is still there. Had the realtor who actually lives down the street from this.
Very good.
Take a picture and confirm the sign's still up.
So at this point with the trust, you only really anticipate them adding one more house to the area?
Realistically, that's correct.
Even though it's A1?
Well, and that's, one of the things I was going to tell you is that, you look at something, and this is something that people don't realize. You have a 5 acre parcel.
I know what you're going to say.
You can have 1 unit to the acre, and people
Right.
think you're going to put 5 lots on it.
Doesn't mean
And you can't. I can put this on the Elmo and just
Between
show
your
you.
setbacks, your
Yeah,
driveways,
you could
that kind of thing. We
realistically
discussed that.
put 3 lots on there, realistically.
Right.
4 would require you to go through a minor subdivision because you couldn't do a flag lot. And realistically, you wouldn't even have 4 good lots. If you went to 5 lots, you're probably going to have all kinds of problems because now you're going to get into stormwater. So,
Correct.
I just wanted to make sure that was clear too, is that, when people think that you can put X number of units on a property just because you have that, you can't. Not realistically. Denise, you're getting ready to provide correction.
Is that it for,
Denise Greer for staff. Bob is a little bit wrong. We recently changed our code to allow, for easements over lots in these situations. So
But
technically,
for
the,
minor subdivision only.
yes.
But
So you
for a
could,
lot split, we can't do that.
yes, they can.
Oh, they can.
So
Yeah, Bob.
they could possibly have 4 or 5 lots if they lotted it out correctly. And their surveyor is very in tune with how to do that. So I just wanted to say that the code has changed recently.
okay, thank you for that insight. And Mr. Goss learned something today.
I did. I actually looked at Muni Code this week to make sure I was right. So,
Could I make a quick comment?
Do you want to?
Oh.
Yeah, go ahead.
Well, I don't have a question. I don't want to bash Bob. I just want to say
Thank you.
that I feel that it would be extremely heavy-handed not to approve something like this. A family who is literally, they have a 5 acre parcel that they want to split so that their so that their child can live on their property with them. Like, this is easy peasy, exactly the kind of thing that should move forward without any problem. I will feel really concerned if we're not voting to approve something like this.
Wait. Let Commissioner Ballard finish.
That's all.
Commissioner Cruz.
Yeah, well, that's why item number 23 later today is so important, where we can expand our uses of ADUs to allow people to have their family members live on their own private property with their own private money. We talk about affordable housing issues, and we prevent people from building housing for family members or for renters, for that matter. This is one example. We've had this a couple of times, and every time I've complained about the same. In fact, one time we actually refunded somebody's application fees because we were so, as a board, upset by making somebody jump through hoops for a year.
Right.
We're not going to refund yours.
Thank you.
But there was no precedent set in that situation. But nonetheless, this is just overreach by government, and we're all sick and tired of it. And I think this board has good intentions on stopping development, but we also have good intentions of making sure people can use their private property rights and we can get housing where it should be, being done the proper way, and this is the proper way. So I fully support this.
All right, thank you, sir. Are there any other questions of Mr. Wait a minute. Yes, ma'am.
And I appreciate the presentation. This is exactly why we wanted a presentation on this, to establish that you can take a 5-acre property and effectively develop it on your own. And again, if we want to split our properties up for family members or things like that, but that's why I was very appreciative of a presentation to explain that this is how we grow a community effectively. Thank you.
Thank you.
Thank you, ma'am. Are there any other questions of Mr. Goss? All right, staff, you're up.
Alicia Henry here for staff, and I have been sworn. Okay, so I'm here to present for a Red Rooster. Do you want a full presentation, or?
I think we're
Oh,
fine.
okay. All right, so what I will do is point out some, one thing I do want to point out is that the proposed site is in an area where the infrastructure for potable water, sewer, and reclaimed water exists, but is not directly connected to the site. This will be at the expense of the developer to basically take care of any expenses in regards to that if they wanted to extend the utility lines to that site. I'm also going to go over the positive, negative, and mitigating factors. So the positive aspect of this is that the agricultural suburban zoning district in which they want to rezone to is an implementing zoning category for the UF3 future land use category. The A1 zoning district provides transition between the general agriculture properties to the south and RSF1 to the north. The project use is not a large trip generator, increasing the use of the road that is expected to have a sufficient level of service. And transportation has also have a positive aspect here where no apparent issues are related to transportation. And I already explained the negative aspect here where there is no utility lines that are connected to this particular site. And again, I will mention the mitigating factors is that if improvements to the public infrastructure or facility are required, cost of these improvements will be made at the expense of the developer. Okay, and staff concludes the proposed rezone to be consistent with the comprehensive plan and in compliance with the applicable provisions of the Land Development Code. Any questions?
Any questions, staff? None, thank you, okay.
None? All right.
I'll open this up for public comment. Is anyone in the audience like to come forward and give public comment on item number 13? All right, it's quasi, so there's no call-in, so I'll go ahead and close public comment. And staff closing comments, sure, you're good? Bob, you're good? Okay. There is a motion on the board right now.
Motion to approve.
We are up and operational.
No, we're not.
We're not? We were, for like 10 seconds, we were.
Second that.
Okay, so there's been a motion moved by Commissioner Ballard, second by Commissioner Siddiq on item number 13. We'll go by voice vote. All those in favor, say aye.
Aye.
Any opposed? None opposed, the motion carries 7-0. Ms. Knapp, can you read item number 15 into the record, please?
Excuse me. Item number 15 is two different ordinances, I believe I have to read separate into the record. We'll need two different motions.
I couldn't hit the move.
Item number 15 is Plan Amendment 2406, Ordinance 2470, and Ordinance number 2471. So the first ordinance, 2470, is a county-initiated large-scale map amendment of the future land use map for approximately 389 acres of specific real property owned by the county and generally located throughout the county from recreation open space, agricultural rural, Res 1, Res 3, urban fringe 3, Res 6, Res 9, industrial light, retail office residential, mixed use activity center 1, and mixed use activity center 3, to the public, semi-public 1 future land use classifications. And then the second ordinance, companion ordinance, is number 2471, a county-initiated large-scale map amendment to the future land use map for approximately 49 acres of specific real property owned by Peace River Electric Corporate, Inc., generally located throughout the county from agricultural, rural, Res 1, urban UF 3, Res 6, mixed use activity center 1, and mixed use activity center 3 to public, semi-public 1. And your staff presenter is Rachel Layton.
Ms. Layton. Oh, she's already up there.
I'm
So
here.
fast. Oof.
Good afternoon, Commissioners. Rachel Layton. I'm a certified planner. I'm also division manager for planning within the Development Services Division and impact fee administrator. So if I could get my presentation. And I have been sworn, although this is text amendment, so it's legislative. Map amendment for comprehensive plan. Okay, so as Nicole explained, we have two different ordinances here today. Both of these ordinances place property into the public, semi-public, future land use category. So the first, they are both county-initiated large-scale comprehensive plan map amendments. The first is for ownership within Manatee County. And then the second has properties for ownership with Peace River Electric Cooperative, a public utility company. So the proposed request to change to public, semi-public would allow for public and quasi-public facilities, airports, landfills, major maintenance facilities, recreational uses, solid waste transfer stations, water, wastewater treatment facilities, storage disposal facilities. Also, these parcels have stormwater ponds, lift stations, and a variety of other public infrastructure and public uses, and also allows for public schools. These sites are located throughout the county, both for the county-owned property and for the Peace River Electric Cooperative property, for a total of 439 acres. Positive aspects: the request has the potential to improve the county's community rating system established under the National Flood Insurance Program to a Class 4, which would result in an additional 5% discount for residents' flood insurance premiums from 25% to 30%. The request will remove residential entitlements out of the 100-year floodplain, thereby reducing potential damage and increasing public safety by removing development potential out of these flood-prone areas. The reclassification of the subject properties will more accurately reflect their current and future uses, thereby improving the accuracy of the future land use map series. We found no negative aspects. Mitigating measures, if any future rezones that may be requested may occur to ensure consistency of current and existing uses between the future land use classification and zoning districts of these applicable properties. So those would all have to be plan development, public interest. So the application and the ordinances proposed are consistent with the comprehensive plan under policy 2.1.1.2 to designate on the future land use map land within the existing developed areas at densities and intensities which are compatible with the existing development, and then consistent with the proposed public, semi-public future land use category. This item was previously heard and transmitted to the state. The state had no comments for staff on this item. Therefore, it is the opinion of staff that PA 2406 ordinances 2470 and 2471 can be found to be consistent with the comprehensive plan and in compliance with the applicable provisions of the Land Development Code. And again, as Ms. Knapp pointed out, this, each ordinance would need a separate motion. Thank you.
Okay, so you need a separate motion on
2470?
and 2470 and 71.
Yes, sir.
Okay. All right, there, okay. So is there any questions of staff on item number 15?
More of a question, not a comment.
You want,
Sure.
Commissioner Siddiq?
I'd just like to appreciate staff and Ms. Layton for the briefing. This is a good learning experience, and I encourage other commissioners to check this out as well. I was a little bit surprised in my district. I had, I think, a lift station and then Bishop land in there as well. I was surprised to learn about why that was zone res 3 or 6, one of the two. So I'm in support of staff going ahead in the future to just look at the future, to look at the maps, identify county-owned property, and clear up those inconsistencies and provide us with more latitude to give public land, provide the public benefit with public lands that they already own. So commend you all for doing that. Thanks again for the briefing. I'm certainly looking forward to more of this. Hopefully we don't need too much of that, but
Thank you.
thank you.
Okay, on adoptive ordinance number 2470, there's been a motion by Commissioner Cruz, seconded by myself. If all those could, if you'd cast your votes at this time.
I still don't have it.
Oh, you're not up?
No.
I do.
It seems to be intermittent. So what do? There's a motion by Commissioner Cruz, seconded by myself on 2470. I'll take voice vote at this time. All in favor?
Aye.
Aye. Any opposed? Seeing none opposed, the motion carries 7-0 on 2470. On 2471, can I get a motion to move 71?
So moved.
Thank you, Commissioner Siddiq. Can I get a second?
Second.
Second by Commissioner Ballard. The motion on 2471 has been moved by Commissioner Siddiq, seconded by Commissioner Ballard. We'll go through a voice vote again. All those in favor, say aye.
Aye.
Any opposed? Seeing none, 2471 also carries 7-0. All right, Ms. Knapp, can you read item 16 into the record, please?
Item number 16 is Z2409, Kraton rezone. It's a rezone of approximately 3.17 acres, generally located at the northeast corner of the intersection of 12th Avenue East and 64th Street Court East, from agricultural suburban coastal planning area to residential duplex zoning district, retaining the overlay district, and your staff presenter is Camden Jenkins.
All right, thank you very much. Is there any ex parte on item number 16? All right, seeing none, Mr. Schmidt, you are up.
Thank you, Mr. Chairman, Commissioners. This property is in a family trust, and there is nobody here representing them. With all due respect, can I ask for a continuance in this item until they have they might need to seek a little bit more help just based upon my observations today?
You're asking for, did you say you're asking for a continuance?
Continuance, correct.
Okay. When do you like to continue till?
Next land use meeting if possible. It should give me enough time to.
That's on the
inform them
14th?
of my concerns.
Are they? No, it's
The
on the,
8th of January?
is it 8th?
Well,
14th is the next land use.
well,
Isn't the 14th the next land use,
I
Ms. Knapp?
recommend continuing to no date set and re-advertise so we can look at the calendar.
Okay, is that all right with you?
Yes, it is.
Okay.
Nicole, but I thought the next land use meeting was that Wednesday.
Oh, that's regular meeting.
I need to know because I might have misstated something in a prior motion.
The 8th of January is a regular meeting, the
Yeah.
14th is a land use,
Okay, okay.
but we may already have too many items. That's why I suggested no date set and re-advertise.
Okay, thank you.
Okay, that'll work. Thank you.
Okay. So the motion on the board be to continue item number 16 to no time,
Second.
No date set and
no
re-advertise.
set date and to be re-advertised. All right, can I get there's been a motion made.
Second.
There's been a motion on the board, Commissioner Ballard, moved by Commissioner Ballard, second by Commissioner Cruz. All those in favor, cast your votes at this time.
Public comment on the
Oh,
continuance.
I'm sorry. Can I get public comment on the continuance? Anybody on the phone?
None on continuance.
No.
We did have someone.
Is anybody in the audience like to comment on the continuance of item number 16? Seeing none, I'll close public comment. We can all cast our votes at this time.
I can. Mine's not there.
Yeah, that was in there, Dan.
I'm still on my work.
You still isn't voting?
Still on.
Commissioner Feltz, try exiting out and restarting. Commissioner Sadiq and I had to do that, and then our systems reset and worked again.
What we'll do is we'll go ahead and do this by, on the continuance by voice vote. All those in favor, say aye.
Aye.
Any opposed? Seeing none, the motion carries to continue this item. Ms. Knapp, can you read item number 17 in the record, please?
Item number 17 is ZL 2411. This is 6016 Manatee Avenue. It's a rezone of approximately 8,800 square feet, which is part of a 0.7 acre site generally located at the northeast corner of Manatee Avenue and 61st Street West. From professional office medium to general commercial limited zoning district, and approving a schedule of permitted and prohibited uses as voluntary proffered by the applicant and attached as Exhibit B. Your staff presenter is Alicia Henry.
All right, is there any ex parte on this item?
No.
I see none. Marshall, you're up.
Good afternoon, Commissioners. Mr. Chair, my name is Marshall Robinson with Grimes Galvano, and I have been sworn. Today with me, I'm joined by the applicant, Andrew Smith of CSE Properties. We also have our traffic consultant, Michael Yates with Palm Traffic. We have our surveyor, Eric Blackburn of EBI Surveying, and we also have Mr. Caleb Grimes here with us today. Mr. Chair, we're here to talk about property located here at the northeast corner, 61st Street West and Manatee Avenue West. The property is a single parcel. It's 0.68 acres in size. It's located at the it's located in the Southwest Improvement District, or the Southwest TIF, and we're also located in the urban service area. Here's a look at the future land use map for the property. As you can see here on this map, we have two future land use categories. We're in the Res 6, and we have the ROR future land use. And here it's the northern 0.2 acres we're talking about. As Director Nicole Knapp pointed out, we're zoned PRM, and the request is to rezone the 0.2 acres on this property to GCL, and that's a limited general commercial zoning district. And the limitation in our request, Commissioners, is to limit the uses of the property. The applicant did submit a schedule of permitted and prohibited uses. 86 of those permitted uses in the GC zoning district were stricken out. And what's requested here is a Chipotle restaurant for this standard rezone. And here on the screen, you look at the development standards that the general commercial zoning district require. There's the setbacks, the open space, the minimum lot size, and the minimum lot width. Here's a look at some of the standards that we would be required for the proposed use. We have our screening, we have our buffering, we have our setbacks, all required as a part of this request once we get the project to the next step for the site planning phase, if approved here today. And the two arrows there represent the access that will be proposed under our final site plan. I should mention that the applicant did have a pre-application conference with FDOT about the access on Manatee Avenue. They got through that process pretty good, and we don't see any problems moving forward for access management. Here's a look at the development pattern along Manatee Avenue. As you can see in the purple there, that's all what we call ROR, future land use, along with the general commercial zoning district along the roadway there. And here's a look at how we demonstrate our requirements for commercial locational criteria. This map demonstrates that we're about 600 feet off of the two qualifying roadways for the commercial activity node there at 59th and Manatee Avenue. The Chipotle restaurant is proposed for about 2,300 square feet. We meet all the development standards that would be required of this district. We did have an online neighborhood workshop back in September, and on November 14th, we did receive unanimous recommendation for approval by the Planning Commission. I'd be happy to answer any questions if you have any.
All right, thank you, sir. Commissioner Sadiq.
Oh, thank you, Mr. Chair. Read through the neighborhood workshop you held. I'm glad you were able to work out the survey boundary concern with the resident, so thank you for that. I think it's a great location. The zoning is consistent with that area, and That's my neighborhood, so
Yes,
I
sir.
think it'd be great to see that kind of development, especially along Manatee Avenue. We just got a Chipotle on Cortez, so now I don't have to go to that one to go here. But in all seriousness, there was a concern from one resident about the encroachment of commercial into residential areas and the effect of devaluing that property. So I appreciate the comment, Mr. Ridgway. You're not here, but maybe you can watch afterwards. But I do believe this would potentially add value to the community. I mean, the property now it's not blighted, but it feels that way in some ways, just looking at it. So it's consistent with the comp plan LDC based on my analysis and staff feedback as well. I think it'd be a great opportunity to bring some more jobs to the community and a pretty good restaurant, so I'm okay with it. I recommend encouraging my fellow board members to approve it as well.
You like Chipotle then?
Sorry?
You like Chipotle then?
A little bit.
Simply up to me.
But it's not because, I'm not approving this because I like Chipotle. I'm just going to put that on the record, all right?
All right, thank you, Commissioner Sadiq. Commissioner Bearden.
Thank you, Mr. Chair. No, I'm going to approve this one. I'm going to say yes on this one. I like Chipotle, right? I got a couple options now, Chick-fil-A, now Chipotle, so here we go.
All right, good, all right. Thank you, sir. Staff, you're up. Any other questions of Marshall? Seeing none. Staff, you're up.
Alicia Henry here for staff, and I have been sworn. I'm here for project 6016 Manatee Avenue rezone. I'm going to go ahead and go through my entire project, my entire presentation. Okay, so the applicant is requesting to rezone approximately 8,878 square feet of a 0.68 acre parcel from professional office medium to GC Limited. The rezone will apply only to the northern portion of the site due to the southern portion already under the GC zoning district. Applicant has proffered a schedule of permitted and prohibited uses that will restrict development of a more intense use. Okay, just a little bit of history here. Since the adoption of the 1990 Land Development Code, the zoning district has been PRM, and since the adoption of the comprehensive plan, it has been Res 6. And here's the aerial site. It's generally located at the northeast corner of Manatee Avenue and 61st Street West. And as you can see there where it's outlined in red, this is the portion of the site that will be rezoned. The northern portion is where they will have access off of 61st Street West. The activity node to the east creates the Manatee Avenue West, and my apologies. The activity node to the east created by Manatee Avenue West and 59th Street West allows for the site to meet commercial locational criteria. Site is connected to water and sewer public facilities. Here's the future land use category. Okay, and here we are showing the surrounding zoning districts. To the north, we do have RSF 6, which is a single family residential. To the west, east, and south is general commercial. Okay, and for the positive aspects, the proffered uses will provide complementary commercial uses for the residents that are to the north. Proposed zoning district would be compatible with existing commercial uses. This project exists in the South County Improvement District, which encourages redevelopment and infill. And I'm going to go ahead and go over to our negative aspects. The rezone could generate external incompatibilities with the northern residential uses like increased traffic, lighting, and noise. Any potential incompatibilities generated by a proffered use on the subject site would need to comply with the relevant requirements of the Land Development Code. Applicant has proffered a schedule of permitted and prohibited uses that will restrict development of a more intense use on site. I just want to mention one last thing about the positive is that transportation had no apparent issues related to transportation. Okay, and staff concludes that the proposed rezone is consistent with the comprehensive plan and in compliance with the applicable provisions of the Land Development Code. Any questions?
Are there any questions, staff? All right, seeing
Okay.
none. Thank you, ma'am. All right, I'd like to open up for public comment. Is there anyone in the the audience like to give public comment on item number 17? Seeing none, I'll close public comment. There is a motion to approve on the board. The motion's been moved by Commissioner Siddiq, seconded by Commissioner Ballard. If everyone can cast their votes this time. Can everybody cast their votes? Is everybody up and operational? We're good now. Okay, thank you. And the motion carries 7-0. Thank you very much. Ms. Knapp, can you read item number 18 into the record, please?
Mr. Chair, can I just make one correction on something I said? Under agenda item 10 on the Sharia denial findings, instead of bringing back the findings on January 8th, I'll bring back the resolution for denial on January 14th, because that's your next regular land use meeting.
All right, thank you, ma'am. Thank you for the correction.
We could have wrote it
Ms. Knapp, can you read item number 18 into the record, please?
Item number 18 is PDEZ 0822G Revision 3, Buckeye Industrial Park, PDEZ Revision. This is amending and restating ordinance PDEZ 0822ZG Revision 2, retaining overlays and approving changes to the general development plan, and the ordinance regarding the removal of stipulation A.7 and A.12, amending stipulation A.14 are stated in ordinance PDEZ 0822ZG Revision 2, and providing changes to area D1, including the addition of outdoor storage as a permitted use and increasing maximum floor area ratios from 0.5 to 0.75 on the property zoned PDEZ, comprised of 190 acres and generally located south of Buckeye Road, east of 41, and north of 113th Street East. And your staff presenter is C.J. Mills.
All right, is there any ex parte on this item? Thank you. Good afternoon, Senator Galvano.
Good afternoon, Chairman, Commissioners. For the record, Bill Galvano, Grimes Galvano. I'm from Manatee County. I have with me here today our expert, Bob Schmidt, who's been working very hard today. I'm going to give you an overview and then ask Mr. Schmidt to come up and see if he wants to have additional comment, and then we can answer any questions. I'm here today on behalf of Port Manatee 76 LLC, as well as other owners of property within the Buckeye Industrial Park. This is a park, as you heard, that is at the southeast corner of the intersection of Buckeye Road and 41, Commissioner Felt's district. This industrial park originally began as a county-initiated project, an encouragement zone to create opportunities for port supporting activities on the property. What we are here today asking for is to maintain what has been done in terms of the encouragement zone, but to cure some inconsistencies that presently exist, meaning, as you heard, with the ability to have outdoor storage, some of the areas within the park are allowed to, some are prohibited. The floor area ratios in the park are inconsistent. Some are at 0.5 and some are at 0.75. And we want the entirety of the park, namely D1 and D3, to be able to have the outdoor storage and have the ratios on the floor area. I mean, this is already developed from an infrastructure standpoint. Given what's happening right now, the current trends in the area, the opportunities that exist with Port Manatee, which you all know I'm extremely bullish on, it's good timing to clean up this ordinance. Staff has made clear in the staff report, and probably tell you in just a couple of minutes, it's consistent with the IL future land use category. It's consistent with the land development code. And frankly, the outdoor storage is a less intense use than what is currently available to these same properties, meaning warehousing, distribution, some types of manufacturing internal. The other thing about the outdoor storage is it's less traffic intense. In fact, there's no impact with this request to traffic. It's compatible with the surrounding areas where you do have, along Chapman, some residential units. There is a specific requirement for 40-foot buffers, enhanced landscaping, and opaque fencing. Staff is also asking this request that we add an additional requirement that access be limited to Bud Roden and Buckeye, so you won't even have traffic on Chapman utilizing this park. I would submit to you before I call up Mr. Schmidt that, 21 years ago when these conditions were implemented, may have made sense at the time. I can't really figure it out, but I believe at this time, they're certainly antiquated. So with that, Bob, if you have any other additional
Commissioner
comments.
Cruz, do you have any questions of the Senator? Are you gonna wait till Bob is done?
He can finish, Bob
Okay.
can go first.
Thank you, sir.
Thank you, Mr. Chair. Again, for the record, Bob Schmidt, and I have been sworn. I don't have anything to add. I think Senator Galvano did a great job. I did process the application, so if there's any questions about that, I'll be happy to answer, but I don't have anything else to add. Thank you.
Commissioner Cruz.
Do you know why there's so much deviation in terms of use on these parcels? Were they just done at different times, or was there previously a plan for these? Like some have outdoor storage, some don't, some have different FARs.
Yeah.
How do we end up with this patchwork?
So, and we've had this discussion, and it's really hard to go back and roll tape because it really began when it was a PDI, then became the encouragement zone. I really don't know. Maybe it was the southern residential folks that had raised something. I'm not sure. But when we look at that issue in today's glance with the other restrictions that are in there, like the 40-foot buffer, the enhanced landscaping, I don't know how that was an issue. The other I don't know, and that's why I think we're in agreement with staff. I know we are in agreement with staff that we're just curing some inconsistencies and helping create these opportunities for port-related activities.
All right, second question, there's three total. Second question, I think this had a 6-foot wall on the southern side. Do you feel, with outdoor storage, I mean, with iOS type space, I mean, those are pretty big semis. Do you feel that the 6-foot wall is sufficient considering there's residential homes right on the other side of that?
I do, given that it's a 6-foot wall plus the 40-foot buffer plus the enhanced landscaping, plus when it comes in, if it goes for an actual approval to develop, all of these things will be looked at with the site plan submittal.
Okay. My last question, which is kind of the heart of my questions during my briefing, was stipulation 7. Why is that removed? It seems like you have a lot of good intention on what you're doing around with this thing. I support what you're doing. iOS space is a great use, and this is honestly, I love hearing something's going to happen on the site. I mean, the site's just been sitting here underutilized. It had so much great intent when it came about. We've had, I think, the sheriff's cattle there at one point in time. Seriously, this is what we were doing with this space around our port. But so everything you're doing is positive. I like the direction you're going. But then when I get to stipulation 7, you asked to remove 2. You're removing outdoor storage and loading zones shall not face residential uses, and you remove that. What do you intend to do on this site that stipulation needs to be removed, or what mitigation are you putting in place to account for that? It seems like an odd one to remove, unless you directly intend to have outdoor storage and loading zones facing residential uses.
So again, this was just to make it consistent with the others. We do continue to think that the buffers, the landscaping, the fencing covers it. There was, and you can correct me, Bob, an additional modification to the STIPs that the staff had put in. Let me take a quick look here. On number 12, with truck loading, where they added south, southeast, and southwest, and identified the hours.
Correct. I know that you have the hours, but to say you removed stipulation 7 to make it consistent with the others, stipulation 7 refers to D1 and D3. The only other component is D2, and D2 isn't up against a residential, so that wouldn't even be applicable to it. So you're not removing stipulation 7 to make it consistent. The entirety of stipulation 7 is encompassing the entirety of the areas that would be affected by it, so.
And again, I think what we're doing is micromanaging with that stip, that you will have the site plan that comes in that is analyzed. And if we're saying that we're going to have storage at all on those parcels, and that the mitigation requirements are sufficient, how it's positioned becomes less important.
Commissioner Cruz, during the processing of the application, there was question as to whether or not that interpretation eliminated the ability to put outdoor storage on Lot 13. And so the enhanced buffer, the wall, there is a substantial landscape, high landscaping there now. We thought the easiest way to address the issue was just to eliminate the stipulation.
Okay, fair enough.
All right, thank you, sir. Commissioner Beard, you're on the board. You're good? Okay, take it on. Commissioner Ballard.
I think that my question was already addressed. It was along those same lines. So basically, you want to have the freedom to place the outdoor storage facing residential, but you feel that the buffers and screening requirements are sufficient that it won't be a problem.
Right.
Is that correct?
Correct.
Okay.
And then the hours.
Okay, thank you.
Thank you very much. All right, we go to applicant, staff.
All right. Good afternoon again, Commissioners, Mr. Chair. My name is CJ Miswell, staff, and I've been sworn. Again, this is Buckeye Industrial Park revision. That includes areas D1, D2, and D3 over the entire 190-acre planned development. This is the GDP broken down into the current parcels and current lots that are there. Give a little bit of history on this. So all the properties have been the industrial light future land use category since 1989, except area D3, which was light manufacturing until 2011. And since the adoption of our Manatee County Land Development Code, the area D1 has held the Plan Development Encouragement Zone zoning designation. Again, the stipulation that we were previously discussing was to remove the outdoor storage and loading shall not face residential uses. Stipulation A12, that also states the preliminary site plan associated with the PDI 0556 zoning ordinance shall remain in full force. This is something the preliminary site plan has long since expired, so it is not applicable to this anymore. Again, outdoor storage, addition of outdoor storage is a permitted use in area D1, and the increase of the maximum floor area ratio from 0.5 to 0.75. These are some of the range of potential uses, and you can see the future land use categories surrounding the area. And this is also the intent of the PDEZ zoning district, which is to provide for the development of land with uses compatible and that support the economic health of Port Manatee and Manatee County. The property is also within the manufacturing development and all three of the coastal overlays. And the current future land use allows for a maximum of 1 dwelling unit per area, and IL does allow for a maximum of 0.75. Also, some of the other information is the uses that are going to be there, or the uses that are permitted there, which include light industrial, and prohibit heavy industrial uses by looking at what would cause objectionable impact to surrounding areas. Some of the positive aspects is that the proposed amendment will allow expanded port-related uses in the PDEZ, and the increased FAR in Area D1 will provide consistency, as Ms. Schmidt was previously saying. One of the negative aspects is the proximity to residential uses could result in adverse impact in the form of noise, light, and air pollution. And as previously stated, during that final site plan review, any kind of incompatibilities will be mitigated for and reviewed for. In the opinion of staff, this is consistent and with the comprehensive plan and in compliance with the Land Development Code. And I will be here if you have any questions.
Is there any questions of staff? Seeing none, thank you very much. I'd like to open us up for public comment. There's no call on allowed because it's quasi. Is there anyone in the room that would like to come give forward and give public comment on this item? Seeing none, I'll go ahead and close public comment. Staff, any closing? You good, CJ? All right. Senator, any rebuttal? You're good. Thank you very much. All right. There's been a motion on the board, moved by Commissioner Beard and seconded by Commissioner Siddiq on item number 18. If everyone would cast their votes at this time. Motion carries 7-0. Thank you very much. Ms. Knapp, can you read item number 19 in the record, please?
Item number 19 is Plan Amendment 2322, Ordinance number 2413, Bus Barn Northeast Quadrant Large Scale Map Amendment. This is providing for a privately initiated map and text amendment to Element 2, Future Land Use Map of the Comprehensive Plan, amending Policy 2.14.1.6, commonly known as D56, to remove 23.37 acres from the northeast quadrant and to reduce the single-family detached entitlements from 9665 to 9640 units, and the single-family attached entitlements from 2900 to 2874 units for a total reduction of 51 units. And your staff presenter is C.J. Mills.
All right, this is legislative, and applicant, you're up.
Good morning, Commissioners. My name is Isaiah Smith, and I have been sworn. I serve as the Public Policy Coordinator at Neal Communities. Today, we will be presenting an application for our company, Simply Dwell. Some of you may remember, about half of you, supporting a previous application for Simply Dwell. That is now known as Broadleaf, located on Golf Course Road. I'm pleased to share that we have achieved 51 sales since its opening in May, with 40 of those to young professionals under the age of 40, 33 to first-time homebuyers. Awesome. And I believe most of them are under the age of 40. We are excited about this opportunity to create more communities that support our young residents. You will hear more details about our application from Katie LaBar. Thank you.
Katie, you look different
Or Ed
today.
Vogler, yeah. Can't hold the candle to Katie, that's
you
for
got
sure.
a little uglier, but that's all
Well,
right.
y'all have had a long day, and so we'll be brief. I've been following you on the, you're moving much quicker now. This is interesting. So I thought, I didn't know what time I needed to come back, but Pat Neal is the owner of Simply Dwell, and he is on his way here, and he wanted to say a few words to you about that. And I'm going to try my best, Pat Neal channeling for just a second. We're selling homes in the $290,000 range. These are completed, nice homes. This is an affordable housing project that is not subsidized by government or grant. And we're very proud of these communities. The Broadleaf, I don't know the marketing names all the time. Broadleaf is a very successful community on Golf Course Road, and we're bringing young people and people that need to have affordable housing into our communities. That's what this project is. Now, if you've been confused by anything today in this land use world, you're going to be really confused by this one. But I want to say to you, to all of you, and to specifically some of my friends that want to slow down development, this is not a change that will impair our project. Our future land use is in place for this project. It has been approved and it is approved. This is a technical change that has been really asked for by the staff because the Lakewood Ranch project, the Northeast Quarter project, used to go north of 64. And when we did our Palm Grove change, Commissioner Cruz notes he's voted 3 times against it, but nevertheless, that was changed, you remember, and we removed that from the northeast quadrant of the Lakewood Ranch project. This little piece was not removed then because it's owned by the school board. And so now we're coming forward, we've changed the land use, and we're conforming the northeast quadrant ordinance to remove the school board piece, the bus barn piece, from that northeast quadrant. But if that doesn't happen today, it just messes up the accounting for the staff, and and how many units are in the northeast quadrant, and of course we want it approved because we'd like to have easy consideration. And my final point, Commissioner Bearden, the last time we were here on this, there was some discussion about the zoning application. That will come forward next year. That's not what this is here today. And I want to reaffirm all the things that I said to you personally at this dais about that zoning matter. And we're going to have a lively discussion, but that's not today. So Katie, please.
Good afternoon, Commissioners. I'm Katie Labar with Stantec, here on behalf of Simply Dwell, and excited to bring this comprehensive plan map amendment before you. This is an adoption hearing, and so we are here because the commission, prior to several of you being seated, voted to transmit this particular application to the state. And so the Florida Department of Commerce had all of the different state agencies review the request, and they, and I'll share in my presentation, no comments and no issues were raised by any state agencies, and so we're here today to ask for your adoption of the amendment. I do think that Ed did a great job of explaining, but because we do have new commissioners and because we are sort of in between the process, I want to give you a little bit of context. So 23 acres is proposed to be removed from the northeast quadrant. That 23 acres is part of a 44-acre application, 44-acre project. And that 23 acres lies within the northeast quadrant, which was previously owned by Schrader Manatee Ranch. Back in 2009-2010, SMR processed a large-scale comprehensive plan map amendment where they created land use categories, and in doing so, they established a maximum density and intensity on 6,000 plus acres of land through the comprehensive plan. When they established those specific density and intensity limitations, they had to be written into the comp plan. And so anytime we choose to make any changes to that, or we choose to reduce the land area within the northeast quadrant, we have to go through an accounting process where we proportionally reduce the acreage of the northeast quadrant and also proportionally reduce the number of dwelling units or commercial entitlement so that everything remains equal, so to speak. On November 7th of this year, the Board of County Commissioners acted on a small-scale comp plan amendment for property on the north side of State Road 64, and that project is known as the Bus Barn. It got its name because a portion of the site was owned by the school board, and it was originally slated to be a bus barn, and so the name sort of stuck, and that's how we've been processing our various applications. That amendment unified land use categories in the area, and it's all UF3 now, urban fringe, 3 dwelling units per acre. We have a site plan that's in review, and it will come before this board for consideration in the next several months. But today's request for adoption is specific to the 23 acres, removing that area from the northeast quadrant boundary, and like I said, proportionally amending the unit count to ensure consistency with the approved density limits. And so this is a map of the area that we're talking about. The brown and tan areas to the south of State Road 64 represent the northeast quadrant and the land use categories of mixed-use community, residential, and activity center as it was approved in 2009-2010. And as it's been since then. The area in red that's got a red hatch on it, that's the area that we're talking about today. So as you can see, the northeast quadrant is 6,393 acres and is allowed to develop with up to 14,065 units, which represents a density of approximately 2.2 units per acre. The box on the right-hand side of your screen actually represents the land use, we call them D5 provisions, but the land use condition that establishes the density and intensity of this particular project. And so you will see that the language is proposed to be amended to reflect that 23-acre reduction, as well as a total reduction of 51 dwelling units, with a combination of some being detached and some being semi-detached. So with this change, total project acreage is now 6,370 in the Northeast Quad, with a maximum unit count of 14,014, which represents a 2.2 DU per acre density. And so the density remains effectively the same. We have proportionally reduced the number of units that are allowed within the Northeast Quad. As for consistency with the comprehensive plan, the amendment will support the development, a more predictable development pattern. As Mr. Vogler shared, it will simplify accounting and make sure that the D5 provision for Northeast Quadrant is reflective of the land area that is covered by that boundary. And it will support our ability to move forward with the application, but it is not necessary in order for us to develop our property. I alluded to this earlier in my presentation. This did go through the expedited state review because it is considered a large-scale comprehensive plan map amendment. And so staff received responses from 3 agencies, and none of them had any comments or concerns of substance. And we have prepared a complete application. It has been thoroughly vetted, it's been thoroughly vetted by your staff, by the state agencies, and it is in compliance with your comprehensive plan and your land development code. And for those reasons, we respectfully ask that you approve that application today. Mr. Neal, Senator Neal is here. I think he'd like to make a few closing remarks, and then we'll ask for your vote of approval for this adoption.
Thank you, Katie.
Yes.
Do we have an Elmo, or is Elmo?
No, we have
That's
it.
it.
It's right here.
Okay. Hello, Mr. Chairman. I'm Pat Neal, 1003 59th Street, Northwest in Bradenton. If this is sworn testimony, I'm not sworn.
It's legislative, sir.
I'd like to talk a little bit about background and our new division, Simply Dwell. Remarkably, Mr. Chairman, I've built homes in Manatee County from 25,900 to Bluebird at Wildwood Springs in 1975. In those days, we'd go down to Nino Spagna with our site and development plan on a Monday, and we'd usually pick it up on a Thursday and a Friday. Today, it usually takes about 2 years to get to the comprehensive plan and about another year and a half to get through the zoning, preliminary and final site plan, S&D plan, core permit, and the rest. Our average home today is about $672,000 in Manatee County, and we've built about 23,000 such homes in this town. We created, out of a good guy move, our Simply Dwell company 2 years ago, and this is our second proposed project for Simply Dwell, which currently sells homes in North Manatee County for just over $300,000. Remarkably, we sell those same homes in Sarasota County for almost $400,000 because of the cost of doing business in Sarasota County. We got stopped roughly 3 weeks on a golden rain tree, a broken golden rain tree in the city of Sarasota, and these things cost money. Our goal, if we get through this, is to build 99 homes from 1,536 square feet. They're mostly homes like I show on the Elmo. If Christian has gotten here, he will tell you who buys these homes, but they are almost all first-time homeowners. Our goal, if we can get through this process, is to build roughly 2,260 such affordable homes in Manatee and Sarasota and Lee counties. I hired the person who I thought was the very best home builder for Berkshire Hathaway and Starlight and Ashton Woods from Nashville, Tennessee, and he's an expert in buying and building homes for about $300,000. His name is Jag Rupnarian, and you will hear from him next. I'd like to, I'm not sure if this is the right evidence for you, but I'd like to give you a brochure of Simply Dwell so you can see the price and style of the homes we hope to build. Is that permissible?
Yes, sir, you can hand the clerk and the staff, they'll bring it over, sir. A young lady right there.
Can you talk?
Sure.
Yeah. It's your time.
Good afternoon, Board. I'm not sworn in. Jag Rupnarian, Division President with Simply Dwell Homes.
You don't have to be, it's legislative, you're good.
Okay. I want to share a story. Excuse the dress code. I was in a project that we're building in City of Sarasota where we torn down 4 condemned housing and we're putting in 7 new homes across from Booker High School. And that project has turned out to be very interesting in the sense that we attempted to deliver homes in the 300, sub 300 mark, and due to difficulties of doing business in the City of Sarasota, we are short of that number, but are still having a great amount of success. 4 of those 7 homes are sold, and if you go take a look at what we've done in that area, it's really amazing. If you take a look at Broadleaf, you've heard a lot about that community. There's 266 lots. We've sold roughly 64 homes in that community. We've closed about 40 people that live in that community. If you drive through that, you see that they're living their life. They've got families, they've got kids. They're able to get into homes in the 300 mark. We have homes starting in the 290. That's very difficult to do from a costing standpoint. I've done this for a long time, and in this market, it's very challenging. And luckily, we have the resources and the ability to do that, and we're asking that we get to do that again with this project, Bus Barn, with 99 lots. A little more about the business. We've got 10 floor plans that range from 1,300 square foot to 2,500 square foot. We put a lot of thought into every single floor plan that we build. Every floor plan is intended to target a buyer profile that might have a need. A parent that's living with an adult child would have a bedroom on the main floor. So we've got multiple configurations. We've got 2 bedroom configurations. So we've got all buyers covered in our community. It's really well received. In Broadleaf, as an example, the community to the left, the community to the right is average price points of $600,000, and our buyers are able to live in that. So I think what's the beauty of Simply Dwell is that we're not going to secondary locations to do this. We're going to A locations where our buyers can get into homes at the right price and get out of the rental proposition. If we have time and some of the other team members can get here, you'll hear some more stories about actual people that have moved to this market that were in a rental proposition and couldn't get into houses. So our ask today is more support from the board on this. I know Commissioner Cruz has been able to do a tour of Broadleaf. I encourage anyone else who would like to do that to come out and take a look at what we're doing, walk our model homes, meet our buyers, interview our buyers, and see that it is what we say it is. And any questions from the board, I'd be willing to answer.
Commissioner Ballard, Commissioner Ballard's on the board.
Okay.
Yeah, just briefly, I really appreciate the Simply Dwell product. I know that we have a lot of people in my age range who have been really trying to buy their first homes, and they've just felt really priced out of the market for a very long time. The 290s, the barely 300, that is something that, you know, a middle-class person in Manatee County can afford. So if you happen to find property in District 2, there are a lot of District 2 residents who would really appreciate a Simply Dwell neighborhood.
Thank you, ma'am. Are there other, yes, sir.
Mr. Chairman, I know this is comprehensive planning. I'd like to ask for one more team member to talk about the people who buy these homes, and then we'll be still. May I do that, please?
Yes, sir.
Good afternoon, everyone. My name is Christian Jennings. I'm the area sales manager for Simply Dwell Homes, and I kind of just wanted to talk to you guys a little bit about what we talk about when we have our buyers that are coming in and give you some stats that actually back that up as opposed to just our words, right? So of the 64 homes that we've actually sold in that broadleaf community that Jag has told you about, 78% have been to families or individuals under the age of 40. 78%. Of those, 76% are true first-time home buyers that have never owned a home. It's the first time that they're getting that opportunity to actually own their very own piece of real estate. And we have individuals from all types of healthcare, education, customer service, hospitality, construction, and more that are moving into this community. 81% or 52 of 64 home buyers that are in our broadleaf community are actually already from Southwest Florida. So we're helping the individuals that already live here be able to afford an actual home as opposed to just continually renting. And that's why I think we're here today, just to ask for your assistance in giving us the ability to continue to provide that for our own. Thank you very much.
Thank you, sir. All right. Any other questions of the applicant from the board? Seeing none. All right, staff. Hey, Katie, can you pull down that and give it to the clerk?
Yes.
Thank you.
I'll give you your dais back too. Eventually.
Senator Neal, she needs that paper you put up there on the overhead. She'll give it back to you. Yes, sir, CJ.
All right, again, CJ Mills with staff, and I have been sworn. All of them did a very thorough job of this, so really, I think the main thing that I want to get at, we know the site location, we know the acreage that's being removed. There's previous acreage that was removed from the northeast quadrant, and this kind of confines it in between State Road 64 and State Road 70. Again, these are the proportionate reductions of the dwelling units permitted with the 23 acres taken out. I also want to say that the UF3 future land use category was the original future land use category that was designated here. And in the opinion of staff, it is consistent with the comprehensive plan and compliant with applicable provisions of the LDC. And I'll be here if you have any questions.
All right, any questions of CJ? All right, seeing none, thank you very much. All right, I'm going to open it for public comment. This is legislative, so we can allow a call-in. Is there anyone on the phone has a comment, public comment regarding item number 19?
No callers, Mr. Chair.
Is there anyone in the room that has public comment regarding item number 19? All right, seeing none, I'll close public comment. Are there any questions for staff or CJ? You got any closing comments? Mrs. Katie, are you good?
We're good.
All right, thank you very much. All right, so there is a motion on the board to.
I was on the board.
Oh, you are? Okay. I didn't, all right, see you now. It just came up late. All right. Commissioner Bearden, sorry, it came up late.
Thank you, Mr. Chair. I know there was a comment out there that said, you know, we want to slow down building. I never want to slow down anything. I just want my roads built. We've pushed and pushed and pushed for the last 15 years. And now we're at a breaking point. We are literally adding to our population 12,500 people a year. In the next 10 years, we're going to have an estimated population of 550,000. In the next 20, we'll most likely have around 600,000. Currently, right now in permitting, how many do we have slated to be built? Can anybody tell me that? Do we know? It's probably 20,000 or 30,000 more homes. It's probably more than that, right? So I love the product, and I've told this to Mr. Neal himself as well, that this product is an amazing product. I think this is things that we need. However, when I look at the metrics and the analytics, tells me that we have 6 months' worth of inventory currently right now today in Manatee County. Currently, today, we have 6 months' worth of inventory. And so, again, guys, I'm not against slowing down anything. I just want my roads built. That's it. That's all I'm asking for, and I don't think that's a hard ask. And I know that we've been having conversations, and I had some conversations with Mr. Grimes today, that we can maybe have a possible sit-down conversation on how we're going to achieve this goal. That not just this board wants, but what the public wants, and every time you guys get in the vehicle, what you want, personally. So that's just where I'm at with it today. I think this is a great product, but, you know, I'm not in favor of the current situation. Thank you, Mr. Chair.
Sir. Mr. Cruz.
I don't disagree, but there's things we need to encourage, and there's a time and place to push back on things that are going to cause traffic. And Simply Dwell, and I've said this before on this dais, it's probably my favorite product out there right now. We get a lot of affordable housing that's rental. Virtually no affordable housing. And I'm using a lowercase a. There's no LoRa, there's no anything for this that's for sale. That gives someone an opportunity to live in a place that they own and build up their own equity and build themselves up. And these are young kids. These are, I've been out to Broadleaf a number of times and met some of the owners out there, both during construction and the ribbon cutting. And since then, they're starting a life here in Manatee County. It's disproportionately teachers and law enforcement there. Like it's insane what percentage there is there. We always talk, every time we talk about teachers and nurses and law enforcement, they're actually doing it, and they're doing it in a way where someone can live someplace. Otherwise, they're waiting for one of the 7 to 10 Habitat for Humanity houses to come along every year. And they're building hundreds of them. They're building 2 a week over at Broadleaf, like clockwork. And they've done it in a way where it's infill location, it's predominantly land that's slivered off of other Neal community land, that rather than build market rate homes, they've taken these slivers and built these homes that are insanely cheap. I sat with Jag and tried to figure out, how are you doing this? How are you building these homes and selling these homes so much cheaper than anyone else can? We keep getting told it's impossible. And they're not using any of our money. They're not even asking for impact fees to be waived. They're not asking for gap financing and catalytic loans. They're doing it on their own. And they don't even have HOA fees and CDD fees and things that make it cost prohibitive. This is a great product. I think we need to encourage this. Even if sometimes you have to hold your nose a little and say, traffic, I get it. Something's going to be built here. Whatever's built here is going to have a car attached to it. But if we can have this built here, there is a lot of people moving in, but those people need homes. And if something's going to be built anyway, I'd rather be Simply Dwell. And I'd rather encourage not just this company to keep looking for more opportunities in District 2 and elsewhere, but other companies to say, hey, this board may be pushing back on a lot of things, but it's encouraging for sale homes for our teachers and our law enforcement. And that's something we can get over the hurdle, because while there may be 40,000 homes in the pipeline, there's not 40,000 affordable homes in that pipeline. It's almost entirely 40,000 market rate homes that are going to be out of reach for a lot of people. It's a very small number of homes that are affordable in that pipeline. This and Broadleaf and the property that we recently sold to them to try to build more, which is, I believe, just outside of District 2, maybe in a redistricting, you can grab that down the road somewhere. I love this product. I'll always be a fan of Simply Dwell if they come to us, because I want to see more of it. I want to see other market rate developers come up with their own version of this to come to us to try to get more of these things built. So I don't want to stifle that innovation that they're creating for the good of this community. So I voted to transmit this in the first place, and I thought I made the motion, but I guess my button didn't work. Now I've seconded the motion to approve this right now.
All right, thank you very much. All right, any other comments by the commissioners? Seeing none, we have a motion on the board moved by Commissioner Ballard, seconded by Commissioner Cruz on item number 19. If you would cast your votes at this time. And the motion carries 5-2. Thank you very much. Thank you. All right, Ms. Knapp, can you read item number 20 into the record, please?
Item number 20,
I'm gonna call a break in about after the next couple items.
And could I,
You should take a break after 20, because your meeting takes some time, and the ADU will take some time.
and I'd request a 20-minute break if we can. If
right.
not, I will stay out for 20 minutes.
No, we're good. All right, what we're
Okay.
gonna do is we'll take a 20-minute break and we'll come back at, she has,
I'm breastfeeding. I have to
well, we don't need to tell we don't need to tell everybody that. You know, we'll come back at 20 after 3. We'll come back, and for those in the military, come back at 15:20. We stand in recess. 20. Can you please read that into the record, please, Ms. Knapp?
Item number 20 is Plan Amendment 2408, Ordinance number 2322, Community Rating System, Class 4. This is a county-initiated large-scale map amendment to the future land use map of the future land use element for designating these real properties located at different locations. So the first one is 2425 Televas Road, Sarasota. The second is 16410 Rangeland Parkway, Lakewood Ranch. The third is 5895 Post Boulevard Road, unit number 17, all in unincorporated Manatee County, from public, semi-public 1 to industrial heavy future land use classification, and recreational open space to mixed use community residential future land use classifications, and recreational open space to the MUC Mixed Use Community Activity Center 1 future land use classifications respectively, totaling approximately 235 acres. Your staff presenter is Rachel Layton.
Thank you, ma'am. This is legislative, so Layton, you are up.
Good afternoon again. Rachel Layton for staff. I have been sworn. Again, as Ms. Knapp presented, this is for the community rating system. This is a supplemental amendment to the previously approved ordinance to remove and revert 3 parcels back to their original future land use categories. Again, county-initiated large-scale comprehensive plan map amendment, approximately 234.94 acres to revert future land use classification on 3 county-owned parcels, which were recently designated under Ordinance 2322. So the first 2 parcels are in the area of the East County Facilities or Premier Sports Park. So we have the one on the south side of Rangeland Parkway, 74.27 acres on the northern portion. And it's currently with the recreation open space overlay, future land use with some overlays. Those overlays will remain. And it's currently zoned PDPI, and you will hear that PDPI amendment early next year. The southern parcel currently has our premier sports park soccer facilities for the county. It's 124.39 acres for the southern portion, and it's the east side of Post Boulevard. And that again also was designated recreation open space and is currently zoned A. And again, you'll see that application upcoming. So this is an update to our future land use map series where you can see where that area is circled on the map. The second location is the Televas property. This is the northwest quadrant of the intersection of US 301 and Televas Road. Acreage is 36.28 acres. This is the county's fleet facility property. The previous land use designation was industrial heavy, which matched the existing future land use code and needs to be reverted back to as such because of the intensity of the existing use. Today, it is public, semi-public, with a light manufacturing zoning district on it. So things just didn't quite align properly when we needed to make sure that we were moving forward for future development on behalf of Manatee County. So as you can see here, this is where it is circled on the existing and proposed future land use map series. Again, 3 total parcels totaling 234.94 acres. Various zoning classifications had been recently designated recreation open space for East County facilities and public, semi-public for the Televast fleet facility location, with that parcel in particular had airport overlay impact. So positive aspects are the reclassification of the subject properties will revert their future land use categories to their pre-ordinance 2322 categories without adversely impacting the county's community rating system or the class 4 classification, thereby improving the accuracy of the future land use maps. We find no negative aspects with this, and any future rezonings that may occur will ensure consistency of current and existing uses between future land use classifications and zoning districts of these properties. It's the opinion of staff that the supplemental map amendment to Ordinance 2322 can be found to be consistent with the comprehensive plan and in compliance with the applicable provisions of the Land Development Code.
All right, thank you very much. Is there any questions from the board to Ms. Layton on this? All right, seeing none, I will open up for public comment. This is legislative, so it does allow for call-in comment. Is there anyone on the phone regarding item 20?
We have one caller ending in 454.
Caller 5454, please state your name, county of residence, and you have 3 minutes.
Charlene Gao, Manatee County. I was just curious as to, why exactly now? This just for education purposes, because we're still in the process of going through the comprehensive plan redo, and so I'm just trying to figure out why this has to be done now and not part of the overall comprehensive plan revision project. And it's just for education purposes. I'd like the answer. Thanks.
All right, thank you, ma'am. Do you want to respond, Ms. Layton?
Again, Rachel Layton for staff, I have been sworn. At this time, we are proposing some map amendments as cleanup efforts. We have development applications already in process for county projects on these facilities, and so we found that we should move ahead with these and not wait until the comprehensive plan has been updated and then move to the future land use map process. They will be two separate processes. We expect comprehensive plan to be moving forward full steam next year, but the map amendments will not follow until after that process is complete.
All right, thank you, ma'am. Is there any other callers on the line?
No, Mr. Chair.
All right, thank you. Is there anyone in the audience who'd like to come forward and speak to item number 20? Seeing none, I'll close public comment. There's been a motion placed on the board for item number 20. It has been moved by Commissioner Siddiq, seconded by Commissioner McCann. All those, if you'd cast your votes at this time. And the motion carries 6-0 with Commissioner Bearden absent. All right, item 21, Ms. Knapp, can you read that into the record, please?
Item number 21 is PDPI 1922 ZGR East County Facilities, and this is a request to continue to February 6, 2025 at 9 a.m. or soon thereafter, as may be heard.
Okay, thank you very much. So this item has been, there's been a continuance made. Can we pull up I need to open up for public comment. Does anyone like to publicly comment in the building on item number 21 on the continuation date? Seeing none, I'll go ahead and close public comment. Motions, there's been a motion. This motion has been moved by Commissioner Ballard, seconded by Commissioner McCann. Anyone would cast their votes at this time? That motion carries 6-0 with Commissioner Bearden being absent. Ms. Knapp, can you read item 22 into the record, please?
Yes, bear with me. It's a very long one.
You want to say just read it yourselves?
I think for the record, I have to read a large
No,
portion.
Cole, you don't have to read it verbatim.
Yeah.
Just
Okay.
summarize
Great.
chapter and verse.
Yeah, just chapter verse.
Okay, item number 22, LDCT 2408, ordinance number 2448. This is county-issued land development code text amendment regarding earth moving revisions. This is amending the land development code, chapter 2 regarding definitions, chapter 3 regarding review authority and procedures, chapter 4 regarding zoning, and chapter 5 regarding standards of accessory uses, specific uses and structures, chapter 7 regarding environmental and cultural resource protection, to update language for consistency and clarification of standards, all to do with earth moving, and to update code section references to provide consistency, providing for other amendments as necessary for internal consistencies.
All right, thank you, ma'am. And Ms. Layton, you're up again. Lucky you.
It's a busy day for me.
It
No,
is.
actually, I'm turning this, Rachel Layton for staff, I'm turning this one over to Scott Browning with Natural Resources
All right.
for the presentation.
All right, thank you. Good evening, Scott. Good to see you.
Good afternoon. Afternoon, Board. Scott Browning, Mining Services Manager for Natural Resources Department. So, yeah, this is just a text amendment to an existing section of the LDC addressing earth moving. That's moving of soil, sand, shell, limestone, dolomite. It's currently in section 702 of the LDC. So generally, we want the existing section of the LDC is fairly jumbled, so we wanted to clarify some things. We wanted to clarify the exemptions There was quite a few questions coming in from the regulated public about whether or not their activities were exempt from getting the permits required for earth moving. Clarify some of the language of the LDC, clarify the difference between major and minor earth moving permits, and relocate this section from Part 1 to Part 2, which is a little more appropriate. It does not, in general, fundamentally change any of the current earth moving requirements in the LDC. Again, so the purpose of this section of the LDC is to protect the public health and safety, ensure environmentally desirable design, ensure that there's proper reclamation of the property after the earth moving activities are done, and protect adjacent properties. So again, getting back to the exemptions that are under the existing amendments, some of them weren't spelled out very clearly, so this text amendment was addressed to clarify those exemptions. Transporting and stockpiling of dirt from one construction site, one permitted construction site to another is now an exemption. Stockpiling of fill, from sites that have already been approved under the planning process is exempt. And then transporting up to 1,000 cubic yards of earth moving material is exempt unless it's requiring a minor earth moving permit. So again, that's getting into the difference between major and minor earth moving permits. Major being greater than 1,000 cubic yards over in any 1 year period, more than 10 acre excavation operation, and the material being removed from the site and being sold off site. A minor is going up to 1,000 cubic yards and can involve grade changes at property lines. Both of them have different earth moving site plan requirements, but the major earth moving site plans require an operating permit issued by the Natural Resources Department. So that operating permit covers environmental monitoring requirements before the operation begins, during the operation, and afterwards. It has annual reporting requirements where we require them to tell us how much has been removed from the site. And then it also has bonding requirements where they have financial assurances that they need to put forth to continue to get this permit. The permit's good for 5 years, and then they need to go through the renewal process. So just to be clear, this part of the LDC always had a fugitive dust control plan requirement. They are required to submit one under a major earth moving site plan. That's to address the control of dust and dirt that's airborne from the operation itself. And anything below the major cutoff would have to follow Public Works technical memorandum that was actually issued this year and is now part of the Public Works operating manual. So again, no substantive changes to the current LDC requirement in this regard. And then finally, as another clarification, this part of the LDC does not address phosphate mining. That's covered by a different ordinance completely. And so phosphate mining itself are not required to get earth moving permits. They are required to go through a totally different permitting process through our department also. And that's it. I'll be happy to answer any questions if you have any.
All right, are there any questions for Scott regarding earth moving? He is our dirt guy. All right, see no questions. Thank you very much,
All right,
sir.
thank you.
Good to see you today.
Thank you.
All right. What we're going to do is open this up for public comment. It is legislative, so if there's is there anyone on the phone regarding item 22, the earth moving?
No hands raised, Mr. Chair.
All right, thank you very much. Is there anyone in the audience who'd like to come forward on item 22 regarding earth moving? Seeing none, I'll close public comment. There is a motion on the board. The motion's been moved by Commissioner McCann, seconded by Commissioner Feltz. If everyone cast their votes at this time. And the earth moving passes 7-0. Thank you very much. Thank you, Scott. Thank you, staff. All right, next up is item 23. Ms. Knapp, can you read that into the, you have a question?
Oh, no.
Oh, okay. Oh, is it for the next one? Okay. All right. Ms. Knapp, can you read item 23 into the record, please?
Item number 23 is LDCT 2407, ordinance number 2477. This is a county-initiated land development code text amendment regarding accessory dwelling units. Amending Land Development Code, Chapter 5, Standards for Accessory and Specific Uses and Structures, specifically Section 511.18, accessory dwelling units, to amend the maximum square footage permitted for an accessory dwelling unit, to establish a number of accessory dwelling units that can be permitted on a property based on acreage, and to address Scrivener's errors and to provide clarification on standards, providing for any other amendments as may be necessary for internal consistencies. And your staff presenter is Rachel Ayton.
It is your day.
I know, I feel like I'm back in the private sector with all the hearings. No, I appreciate the opportunity to be here.
Morning.
Rachel Layton,
Good afternoon.
certified planner with staff. I have been sworn. Okay, so our request today is accessory dwelling units and a modification of that. We have, as a jurisdiction, quite a long history of how many times we revised the ordinance before it was adopted. And we have been implementing it for 3 years. What we see today is that there is a need for some modifications again. So I have a few modifications to present to the commission for consideration. And I will walk through this as best I can with all of the research. So again, this is County-Initiated Land Development Code text amendment to Section 511.18, accessory dwelling units, to provide flexibility in the square footage allotted for the construction of an accessory dwelling unit. The original ordinance was approved in the fall of 2021. Staff has received an increase in inquiries to request flexibility with the maximum square footage permitted for an ADU. Furthermore, an increase in inquiries were received regarding the number of ADUs that can be constructed on a property. Our current regulations do not take into consideration the proportionality of scale of the overall property or the overall size of a residence. So during Planning Commission, there was a lot of questions on the definitions of guest house, ADU, and resort cottage. So I pulled all of those to share with the commission today. So a guest house shall mean a structure accessory to a residential use, used for the occasional housing of guests of the occupants of the principal structure, and not as a rental unit for for permanent occupancy as a housekeeping unit. A guest house does not include a kitchen or dining facilities. Mobile homes, recreational facilities, or structures built in conformance with Florida Statute Section 320.823 shall not be deemed a guest house. Accessory dwelling units shall mean an attached or detached residential dwelling unit with separate sleeping, cooking, and bathroom facilities, which is subordinate to and has separate entrance from the primary dwelling unit. We also have a new term, resort cottage. This is a temporary living and sleeping quarter that is accessory to a country club for the exclusive use of its members, and at a minimum includes a main building that offers full food services such as a restaurant. So they all have a principal structure associated with them, but the guest house and the resort cottage do not have the kitchen facilities associated with it as an accessory dwelling unit does. So I pulled how many we've seen in 3 years. We have seen a total of 24 different accessory dwelling unit applications come through the permitting process. 14 of those are in District 3. 3 of them are in District 2. District 3 has 5 ADU applications, and Districts 4 and 5 have 1 each. So you see the bulk of them are in District 1. And these were printed out in order of date. So you can see we have several that are in agricultural districts, and I did kind of categorize these by zoning. I added square footage, acreage, and commission district. So we have a lot of larger parcels that are here. You can see we have a 23.3 acre site with a 3,100 square foot ADU. We also have an ADU that is 1,260 square feet on 0.45 of an acre. We have 1,010 square feet. We have 2,148, 1,152. These exceed the maximum allowable currently and were permitted under the administrative determination that was issued last December, which is another reason why we're here today to amend the text amendment, the text for the accessory dwelling units. Because again, it doesn't necessarily meet with the intent of having that availability of an additional housing type. So in total, 5 accessory dwelling units exceed the size limitation based on the Land Development Code. So our proposed language today includes removing the maximum square footage limitations for RSF, Village, and PD, and A and A1 to only state that 80% of primary structure, air-conditioned, under roof, square footage can be permitted for, based on the primary structure. So an ADU size based off of a 2,000 square foot home, the ADU could be 1,600 square feet, as long as it meets all of the criteria of the Land Development Code, setbacks and things like that. So additional proposed language for this is under B, Development Standards, Item 7, conforming lots less than 5 acres in size shall be limited to 1 accessory dwelling unit or 1 guest house. That is how, generally how the language reads today. But we also added in 2 other additional options. Conforming lots 5 acres or greater, but less than 20 acres in size shall be limited to 1 ADU and 1 guest house. And C, conforming lots greater than 20 acres in size shall be limited to 2 ADUs and 1 guest house. Part of the proposal for this is looking at it as if these were zoned agricultural, they would be allowed 1 dwelling unit per acre. So if they are between 5 and 20 acres, they would have been allowed up to 4 units if they had decided to split the lots. So that was the methodology behind that, and we did a significant amount of aerial research to see how many of the larger lots had multiple structures on them. So as a conclusion, it's the opinion of staff that LDCT 2407, Ordinance 2477 can be found to be consistent with comprehensive plan and in compliance with the applicable provisions of the Land Development Code. There is no action required today because there will be a second reading on this. But because this is the first reading and the first time everybody is hearing it, I certainly would welcome feedback on if this is the proper approach or if there is more work to be done.
Well, saying that, Commissioner Siddique's on the board.
I know this is a relatively new resolution, but I think it's going a long way forward in giving property owners more flexibility to do what they want with their property, and it's a great way to expand property rights in Manatee County. I do like the clarification of the 3 different types of, if we can go back to that slide real quick.
Oh, absolutely.
3 different types of ADUs. I believe it was guest houses, residences, and resort cottages. I think the definitions.
The resort cottage, the guest house, and the ADU. It was like the first or second slide.
Yeah, there we go. Guest
Okay.
house, accessory dwelling unit, and resort cottage. I think that's great. There's been certainly some concern from the public around what exactly an ADU is. I first kind of became aware of it in Manatee County with our celebrity speaker, Glenn Javelina, and he had a great idea with Uncontained 360. It was a pretty cool container house concept. I quite enjoyed it. And his feedback was we don't do well with ADUs, specifically with how we regulate what size they can occupy. So I did some research in surrounding counties. I like the fact that we're looking at 80%. That seems to be fairly generous considering what other municipalities look at, but I haven't cast a wide net across the country. I just looked in neighboring counties. So I think 80% is good, gives additional flexibility, and we can kind of avoid little big mansions popping up on some pretty large properties as well. That can potentially cause residents to be concerned. Other than that, I was a little bit, I know it's only been 2 years. I'm hoping with the clarification, we can potentially see some more options open up for the market to provide more products for affordable housing or workforce housing options. I was a little bit disappointed to see the numbers, but I am glad to see that you brought them up. I think it's a good learning experience to see how many in each of our districts. Actually, if you can pull that slide up real quick,
Yeah.
I think that was pretty cool to see that. Yeah, I'm just looking at the square footage per unit. Actually, yeah, next one. Oh, no, there it is. Yeah, I think the district breakdown was neat. It's kind of interesting to see how they are 2, 3, 4 relative to 1. Kind of figured 1 would have a lot. And then in terms of the size, seems to be a little bit all over the place. I was kind of hoping to see, I was kind of curious to see what the 1,000 and under mark would look like. I would kind of indicate maybe it's a not a container home, but something smaller, probably something that's more geared towards the workforce, but.
Square footage of the primary residence.
Oh, the primary residence, my bad, I read that wrong. But in any event, I'd be curious, I like the direction we're going, and I'll just end on saying I'd be curious to see in another 2 years what this data looks like, so, thank you.
Thank you.
Thank you, sir. Commissioner Cruz.
This was one of my top priorities when we were talking about changing that comprehensive plan. I'm glad it's come back early, and we're not sitting around working on the comprehensive plan rewrite that's been 2 years. Yeah, I think it was January 2023 when Chairman Ron made a motion to start that process. I'm glad we're getting some of these important things done. Look, we just had a bunch of discussions today about Laura's affordable housing. Here's the fallacy in how we're doing affordable housing. I know I'm kind of going a little bit off on a tangent, but it's relevant. Here's the fallacy in how we're doing affordable housing, and everyone does affordable housing. Nobody builds one affordable housing unit. They build 200 affordable housing units. To get affordable housing in Manatee County, we offer some ridiculous 25% incentive at 120% that's not even affordable. To make it worthwhile, someone builds a 200-unit apartment complex someplace, which is a massive project that puts 300 to 400 cars on the road in that immediate area because they're all concentrated on one parcel, pave over the whole parcel, cause flooding issues everywhere. Why? To get 50 units of quote-unquote affordable housing. Guess what? We've got hundreds, if not thousands, of non-conforming lots probably sitting in our surplus land right now that nobody can build on because they're too small, or because there's issues with that. It's ridiculous. These ADUs at 750, I fought hard to get this ridiculously small 750. I mean, if you guys were paying attention in 2021, at one point, my board wanted 500 square feet, and that included the overhangs. And they wanted max one bedroom. So if it was a single mom with a kid, you had one bedroom. I had to fight to get to 750 square feet under air with unlimited bedrooms. They're tiny, they're not economically feasible to build, and putting one of these on a 20-acre lot is comical. It's the treehouse you built for your kids on your 20-acre lot. This is much better. My only request to change, and we talked about this at the briefing, is guest houses. I get we don't want to remove them because it's just a hassle of removing the language. That's fine. You can leave it. The reason guest houses got grandfathered in 2021 is because people who had them wanted to keep them because they were allowed to be bigger than ADUs. Now with this new language, that's not necessarily the case. I know sort of, I think guest houses are 1 square foot less than primary. This is 80%. There's a little difference. That's why I'm saying leave them, I don't care. But in section B, 7B, or sorry, B7, you have 3 tiers there. I don't think it makes sense to say, for B and C, 1 is fine, it solves its own problem. To say 1 ADU in 1 guest house, I think we're overthinking it. It should just say limited to 2 ADUs or guest houses. I don't care what you put. And for C, it should just say limited to 3 ADUs or guest houses. Build whatever you want. I don't care if you put a range in there. What? God forbid someone's allowed to cook their own food instead of going out and paying $30 for a hamburger at Chili's nowadays. Like, you know, why? I don't understand why we bifurcated it like that. That's my only request to change here. If we want to fix affordable housing, we're not going to fix it with incentives for density bonuses that encourage cramming a bunch of units onto one lot, and then we have to pay their impact fees, and we have to waive all their permitting fees, and it costs taxpayers a fortune to put a bunch of units next to people who do not want those units there, to tie up infrastructure because you've concentrated. We're going to fix affordable housing by encouraging people to build meaningfully sized ADUs in their backyard and on their property, like the people who came off of Red Rooster and wanted just to build 1 house, and they had to go through this whole process. This process would allow them to do it as of right if they didn't want a separate tax parcel, without wasting their time and their money coming in front of us and hiring attorneys and engineers. You know, and the next step is, and it's going to come up during the comp plan, I'll just foreshadow that one. We need to fix our minimum lot sizes, because that's the other way of fixing this. Because as long as they're adhering to all the setbacks and all the other requirements in our land development code, why do I care if Glenn Gebelina puts a 500 square foot house on a 1,500 or 2,500 square foot lot if he's hitting all the other setbacks and requirements and parking and you name it? We've got tons and tons and tons of those little postcard or postage stamp size lots that nobody can build on because we don't let them, because we micromanage regulations on our land. you would get hundreds upon hundreds of, we get more affordable housing units on non-conforming lots and bigger ADUs. We're ever gonna get given away free density bonuses all over the place on apartments that nobody wants next to their place. We don't even need to do those apartments. We'll get way more this way. We need to just get rid of the regulations to let people start building these things one by one, because then they'll be scattered in every district all over the place, and they won't affect infrastructure because it's one car here, one car there, not 400 cars there. There's much better ways of doing it than we're doing it today. This is a first meaningful step that I really, really appreciate. That's my only change that I would request is in Section 7, giving people a little more flexibility. But thank you for bringing this back.
I did also bring a few examples of site plans that are either in or have been recently permitted. If you would like me to put them on the overhead to see how these are actually coming together for properties.
Okay. That's okay.
So you see, this lot itself is a redevelopment lot, I believe. And they're proposing a new residence and an accessory dwelling unit at the same time. So that's lovely to see. This next one is also, and these are in, these might both be in District 3. And then the last one will be District 1. And again, a new proposed residence and a new proposed ADU on the same lot. I think they've done a good job. They may get a comment about it being too close, but that's all right. They'll go through the process. And then the final one is can you zoom in a little bit closer, please? Oh, sorry, can you zoom in a little bit, please? A little bit more, please. This is a very large lot and everything's on the front. Perfect, thank you. So you can see that we have here the existing home, and they've got their ADU is going to be here. So they're able to add on because they have a larger lot. So I thought those were good examples as I was doing the research that I wanted to share with the commission, because we are seeing them. We're just not seeing quite as many as I think we had hoped for. In 3 years to only have 24 applications is not solving our housing problem. Thank you for your comments, Commissioner.
Commissioner Ballard.
So I will agree emphatically with Commissioner Cruz on every point that he made related to the ADUs. I'm very excited to see this come forward. Very saddened that we have only seen 24 in the past couple of years. I think that this is a really meaningful step. I have been trying to think of, creative things that we can do to solve the affordable housing issue. And one of the things that I have been pushing for, I kind of put in the hands of the county attorney's office, and they told me, sorry, we can't do it, it's a state level thing. So I pushed for this last year. Somehow, after the board agreed to it, it just fell away and somehow didn't make it onto our legislative priorities, even after we voted to put it on our legislative priorities, which was changing Live Local to add affordable single units to our tax exemptions. So that's something I'd like to revisit in January, because I do think it could have a significant impact. And I bring that up only because we were talking about, kind of creative things that are not going to add to our problems with traffic and all of the other issues that come with that super dense affordable housing. But yeah, I'm excited to see this come forward. I'll bring up my other issue again in January and give you guys a full rundown. But yeah, thank you.
Thank you, ma'am. All right, any other questions for Ms. Layton? All right. Thank you very much. What I'll do is open us up for public comment. This is legislative, so there's no call-ins, but, well, there is call-ins, But anyone in the room that would like to call would come forward on ADUs. See, none, is anyone on the line that's on ADUs, item 23?
We have one caller ending in 445.
Caller, if you could please state your name and your county of residence, and you have 3 minutes. Caller, are you there? All right, caller, are you there?
Glenn Gibolina for the record. Thank you. George, I was right there with you at that 500-foot level. That was ridiculous. And if you remember correctly, they wanted to, if it was above the garage, they wanted to include the stairwell as condition space. How ridiculous is that? Anyways, I'm glad we're moving forward. The 3,300, let's make no bones about it. This is a two-edged sword. I can live with both. So you've got a 6,000 square foot house. You go 80% of that, you can build a 4,800 square foot ADU. To me, that's a second house. But I will consent to that, or I agree with that, as long as we can do minimum lot sizes with the setbacks for smaller homes on infill lots. We are missing the boat. I've been singing that song and dance for years. I'm glad it's finally coming around. So I think we can probably, in this one instance, thank Carlos Baruch for bringing this up, because he wanted a bigger ADU and keep his guest house and blah, blah, blah. So, you know, kudos to him for moving this forward to the benefit of the rest of the community. I don't think they're going to get their own street name, but at least we'll be able to get an affordable, smaller house with this concept. And, you know, your regular, you know, if you look at Robbins Apartments, they're converted motel rooms. They're about 160 square feet. And for some people, that's great. That's all they need, especially workforce housing. You know, if they're working hard and they don't have a lot of money, they can do it. And that's just a small step to home ownership. If they can get a reasonable lot and the infrastructure's already there, the water, the sewer, it's a home run for them. And that would produce tax revenue as well. And it brings up the community. You know, you can go into Samoset and find lots all day long. They're not buildable because the county makes it too difficult. This will pave the way to smaller, and by the way, those smaller houses, they still have to meet the 155 mile-an-hour wind load, all the other code compliance stuff. So they're going to be sturdy, built, strong, small houses, which is fine for a lot of people. It sure beats living under a tree. So anyways, I'm glad this is moving forward. I would like to see in January the complete package on that. But you're right, less government, smaller lots, meet the setbacks, and 24 ADUs is pathetic for all the work we went in. But by the way, I tried to pull an accessory dwelling unit. But I'm zone light manufacturer, so you
Thank
guys
you, Glenn.
get a big fat no.
Thank you, sir.
You can't do it, Glenn, because you're not zoned for it. But
Thank
how
you.
do you like them apples?
Thank you very much for your comments. All right. There's no more public comment. Is there nobody else on the line?
We have one more caller ending in 454.
All right. Caller, please state your name, county residence, and you have 3 minutes. Caller. Caller going once.
This is Charlene Gao, Manatee County. Hi. Yeah, I appreciate the effort to make it much easier to get the ADUs done, because 24 and all this time is kind of small. But there's also, of course, the question about, you know, when you have someone with such a large house, now you're basically permitting them to make a whole other house that's like almost 2 times the size of probably like the average single family home in this county. So maybe, I don't know, an idea about having size thresholds, you know, for that 80%, maybe 80% up to, I don't know, 4,000 square feet, and then maybe change it for like a bigger house than that. Like, and that way we don't have basically a whole other mansion being put up because there's a house that's 6,000 square feet or bigger. Yeah, thanks. That's my comment right there.
All right, thank you, ma'am. Are there other callers on the line?
No, Mr. Chair.
All right, thank you. I'll go ahead and close public comment. We need a
There's no motion,
This
there's
is
no
no motion,
action.
it's a first
I'm on the
reading.
board just to clarify
you are?
something. And then we can be done with this, just because they just mentioned. Look, again, we just went through this with trying to set all these random caps and have government take control. Is there hypothetically going to be somebody who owns a 6,000 square foot house that, for whatever inexplicable reason, wants to have a person living next to them? Probably not. Usually people at 6,000 square foot houses are doing pretty well for themselves, not like their privacy. But in theory, but I'm not gonna throw the baby out with the bathwater and risk capping this and losing opportunities for the isolated instance. If someone wants to build a 5,000 square foot house on their own lot, mind you, with all the setbacks and all the FAR requirements and everything else, next to their 6,000 square foot, knock yourself out, man. It's just one more house. I don't care what you do with your property. It's not my problem. And there's no 6,000 square foot house crammed into some like little neighborhood someplace. They're usually gated and walled up. I don't care. And that's not gonna happen. And if it does, good for them. I don't want to set arbitrary ceilings. We did this last time, and we got 24 ADUs out of it.
Thank you, sir. All right. There's no action needed on this. It's the first reading, so I'm sure Ms. Layton will bring it back again.
I will. I would like to ask the county attorney if we need an amended motion, or if I need to make amendments to B and C,
There's no motion.
per Commissioner Cruz's suggestion.
There is an amended motion on the agenda cover sheet.
Yeah.
This didn't change in the staff report.
Okay, so I can make that amendment that he suggested?
If he needs a motion, I'll second
Oh,
it.
you mean the modification?
No.
Yes.
Speak up by motion.
Mr. Cruz, you back up?
Sure, when it's coming back, I'd like to make a motion that we modify section B7, subsections B and C. B to read that it would be no more than 2 ADUs or guest houses, and C to read no more than 3 guest houses or ADUs or guest houses. I mean, you get what I'm going with on it.
Is that it? All right.
That was the motion, I need a second.
Second. Okay. There's been a motion by Commissioner Cruz on amended language for item 23, the ADUs. There's a second by Commissioner Bearden on the amended motion. We'll just do a voice vote. All those in favor of the amended motion, say aye. Aye. Any opposed? No, the amended motion carries 7-0. Thank you, Ms. Layton. All right, we're gonna take just a quick break because we're gonna trade attorneys out. So we'll take about a 5-minute break and be right back here. Thank you very much. We're in recess for 5 minutes. 24, 25, and 26, there's no action required on any of those, so we are not even visiting those items today. We're going to move to item 27, which is required to have a second vote. So this, again, is legislative, and Ms. Layton, is 27 you, or 27 Ms. Knapp?
Correct. This LDCT 2407 ordinance 2477 is the request to hold a second hearing prior to 5 PM. And this would be to hold your second hearing specifically to the Land Development Code text amendment for ADUs that you just heard.
Okay. So nobody needs another presentation or anything, correct?
There isn't any.
Well, all right, no more conversation on it, right?
No.
No questions, no nothing? You never know.
Just public
All right.
comment.
So there's a motion on the board for item 27. Did you get, is it up now? Okay. The motion has been moved by Commissioner Cruz, seconded by Commissioner Ballard. If everyone would cast their votes for item 27 at this time.
We do need public comment.
We need public comment on the item that we've already.
On the motion to hold a second public hearing. Yeah.
All right. So what we'll do is we'll go to public comment on the same item we had earlier on the voting of the item on the second hearing. And is there anyone on the phones that would like to speak to this item?
No hands raised, Mr. Chair.
Is there anyone in the audience who would like to come forward and speak to item 27 on the earth moving? Commissioner Cruz, you're on the board?
No, it's for the next one. I thought we were already voting.
Okay. All right. So I'm going to go ahead and close public comment on the item we heard earlier. And if everyone could cast their votes at this time. And again, the motion carries 7-0. Thank you very much. All right, moving on to item 28. Ms. Knapp.
Item number 28 is the Planning Commission Advisory Board appointments. We have 2 open seats. Both open seats expired in October of '24, and they were with Commissioner Bedford and Rutledge, who are both seeking reappointment. Otherwise, you have a total of 25 or 26 candidates that are on the matrix in front of you.
I technically put myself on, but it was for the wrong one.
Early in the day, I wake up early in the day. All right. County Attorney.
Thank you, Mr. Chair. In the interest of saving time, we can open this up for public comment now for anyone to come forward on the appointments for the Planning Commission Advisory Board.
Okay.
Oh, I see one person coming forward.
Good afternoon, Commissioners. I appreciate the hard work you do.
Sir, could you please state your name for the record?
Amaro Lionheart.
I'm sorry, could you repeat your first name?
Amaro Lionheart.
Thank you.
Thank you for this opportunity to speak on behalf of a candidate who exemplifies the highest ideals of leadership, integrity, and community service, Mr. Keith Green. I stand here not just as an advocate, but as someone who recognizes the critical importance of ensuring that our County Planning Commission is comprised of individuals who deeply understand the balance between growth, economic vitality, and the needs of the residents here. Keith Green is exactly that person. In Keith, we find a citizen servant who has walked the walk. He is a proven advocate for community, a staunch supporter of our local businesses, and a committed steward of thoughtful and sustainable development. His extensive volunteer service, as you can see upon your resume, and I won't get too deep into that, includes actively already being a planning commissioner. Keith Green is also a fellow Brother Knight of Columbus, as well as our Dr. Bob McCann. Keith Green understands that Manatee County's strength is the diversity of its people, industries, and perspectives of actually believing in a pro-business environment, knowing that that is the backbone of our communities. Again, Keith Green has a track record of being a commissioner, a planning commissioner for the city of Bradenton, which speaks volumes. He has demonstrated the ability to make informed, balanced decisions, weighing the needs of developers, businesses, residents with integrity and fairness. And I will be closing. In closing, Keith Green represents a future We want for Manatee County a future where growth is guided by principles, where business thrive, and where communities remains a place where we are proud to call home. Ask you to support this appointment. This is a critical role to someone who will serve with honor, dedication, unwavering commitment, and share prosperity. Thank you.
Good afternoon, Commissioners. It's my first time to congratulate everybody who was just recently elected.
Sir, could you
Oh.
Could you please state your name?
For the record,
Come
my
on,
name is
Matt,
Matt
you know
Bauer, Manatee County native. It's been a while. Yeah, so I sat on the Planning Commission for a term and really enjoyed the time I had there. I think I brought a different perspective to the board. I'm a CFP, financial advisor. The devil's always in the details. You got to do your homework. We're already seeing quite a bit of change with the new board. I think that being reappointed to the Planning Commission again, I'd be happy to do that. It'd be an honor to represent this community like I have been since I've been born. So I've had the distinction of living with my father on the west side and my mother on the east side. So I've seen how obviously Manatee County has changed over the years. So I appreciate your vote, but either way, I think change is good. Whether you choose me or you choose somebody else, I choose change. So thank you guys and gals.
Hi there, my name is Anthony Shulo, Manatee County resident. I'm also an applicant here today. I applied, I've been a Manatee County resident since I retired from the military here in Manatee County. It's my last duty station, so I've been in an HOA community as well as an ag community, or excuse me, an ag property here. I'm really excited at the changes this county sees, but I'm also just being a waterway manager for the majority of my military career. I think as far as planning goes, I think besides housing and the development that we see or the challenges we see with vehicles, I really am concerned with our waterways here. This is here long before these cars and these homes have been here, and waterways, I think, are a very important part of that planning. I hope to get a different perspective from a lot of folks if I am selected for that position, but I'm encouraged by the recent elections and a lot of the community advocacy for waterway management and how that can really impact us all. So I thank you so much for the consideration.
Sorry, Lindros Välimäki. Thank you for the work you do. I have had the pleasure to meeting a lot of you in the last 6 months of campaigning, as I was on the ballot with with my opponent. I had the time of my life in getting to know a lot of the details about Manatee County. I would like to take the opportunity to continue that. I did my campaigning with ChatGPT. I have built several LLMs. I have an LLM called Manatee Policy Generator. I have been able to, I am a cybersecurity and IT expert, as you are, Mr. Siddiqui, Commissioner Siddiqui. And I bring a totally different perspective to research. I come from Finland. I have a different way of looking at things. Sustainable development is something we do from ground up. We believe in planning instead of reacting to problems. I think my diversity, my different way of thinking would be a benefit for the county and for the board. I absolutely appreciate all of you taking the time to listen to me, and I hope you consider my candidacy. Thank you.
Anyone else wishing to come forward to speak at public comment on the appointment for the Planning Commission seats? Seeing no one, we should go to the phones.
We have 3 callers, Madam Attorney. First one ending in 454.
Number 454, please go ahead.
Charlene Dow, Manatee County. there are a lot of really great candidates on here, and I'm so glad to see such a lengthy list of candidates, and many of whom are very obviously qualified. I'm only going to speak for one, and because I can't really decide on a second, but Glenn Giblina, you know, he's been so involved in these kinds of issues for so long. I can't say enough about Glenn. I'd like to see him appointed to the Planning Commission. And good luck with the others. There's a lot of great choices here. Sorry, Matt, and a few others that really stand out to me. Joe, the Bartolomeo. I mean, these people have stepped up and been involved in the community, and they're learning about our community. If you know, and there's too many really to mention, but the one definite I have here is Glenn Giblina. Thanks very much.
Next one ends in 969.
Caller 969, please go ahead.
Hello, yeah, my name is Alan Gray. Sorry, I wasn't able to make it in. I was traveling over Thanksgiving and picked up a sickness, so I didn't want to come in today. But I'm a city planner. I actually worked with Manatee County for a couple months this past year. I'm a local resident, Alan Grace, Manatee County. I really do think that the county has a tremendous opportunity for change in the next couple of years, especially with the comprehensive plan and probably future lane development code rewrites that are coming down. It's just really a shame to continue to see all the development patterns maintain how they have been for the past 30 or 40 years. And I would, like just about every other candidate, bring a fresh perspective into trying to develop the community in the best possible means in terms of development patterns, in terms of innovative new technologies, bringing them to the ground here, and really trying to make Manatee County a premier place and a spotlight in Florida in terms of sustainable measures, resiliency measures, and trying to protect, you know, the things that matter most to the people. So I appreciate everything. Sorry I wasn't able to come in person.
Okay. I thought I said there's a third caller. Any other caller on the phones?
Yes, caller ending in 639.
Number 639, please go ahead. Number 639, are you there? Last call for number 639. Any other callers on the phone?
None, Madam Attorney.
All right, at this time, we'll close public comment. Commissioners, just so you know, the voting process, since we have 2 seats that are available, we'll take nominations from the floor, and when, after debate and we get to voting, each commissioner will get 2 votes. So you'll get to vote twice. At that point, the 2 candidates with the highest number of votes will receive the positions. I see a look on your face, Commissioner Cruz. Would you like to modify the process? That is how.
But is that what you're referring to, or you're saying each person says 2 names simultaneously?
No, sir.
Okay, that was my
Each
confusion.
commissioner is permitted to vote for 2 potential candidates.
So we vote for
You
one,
can't
and then kick them out, and then that person wins. Kick them out of the list, because they won.
They'll have 1 seat.
You nominate the entire list.
Okay.
You nominate, let's say you nominate 6 people.
Yes.
Each commissioner gets to vote for only 2 of those 6. Depending on who has the highest number of votes, those will receive.
So
the
when it's my
seats.
turn to vote, I say 2 names.
No, we will list every name in order. You'll know that there are 6 people that you can potentially vote for.
Oh, I see what you're
And
saying.
you
Fair
only
enough.
get to vote
Fair enough, I get you now.
twice.
I get you. I get you.
Aren't you glad I didn't have to explain this?
Yes,
See,
sir.
Jason doesn't know.
We're just going to go through 1 round of voting? of one person?
No,
and then
sir.
the second time people are going to nominate, or you want us to nominate?
We will call all the
everyone.
nominations for both seats. So we will have the complete list of names, and then every commissioner knows who are our potential candidates. And then everyone gets 2 votes because
See,
there's only 2 seats available.
Here's my only concern with that is, you want some diversity on that board, and you're making us pick both people simultaneously, but if one person gets in, like say an affordable housing person, I don't necessarily want 2 affordable housing people, you're not giving us an opportunity to assess the first vote to make an educated
That's-
decision on the second vote.
This is exactly,
Let the county attorney speak.
this is exactly the reason why I wanted to let you know the voting process. So if it is the will of the board to have it a different way, you can weigh in now, and we can change that
I'd
process.
rather everyone vote once, somebody wins, and then we go back through the list the second time, knowing who won the first time to make a decision on the second vote.
If that is the will of the board, that's what we will do.
Madam County Attorney, just a quick question. When we nominate someone, are we just nominating the name, or are we stating, or giving input on the
You can
name
do it.
individual?
Nominations first, debate comes later.
Okay.
So, hearing the will of the board, we will break it down, and we will have 2 separate votes, but in each one, you only get 1 vote now. Okay. So, at this
Commissioners,
time,
You want to yell out who's on the board for you?
well, hold on,
Okay, on this.
because we're just calling for nominations.
Okay.
So at this time, I will call for nominations for the first seat. We will call it seat number 1.
Madam Attorney, I'd like to nominate Richard Bedford.
How'd you get yourself first on the list?
Well, she said she wasn't going to, I said.
I can't even see the board.
I said I could monitor the board for her, and she said, we're not going to do that.
There's a board.
No, there's,
Oh, here we go. They
Okay.
fixed mine.
Okay,
Yeah.
all right.
They,
Mr. Sadiq,
They've
I was following
fixed
her
it.
lead. She said, go ahead.
It's all right.
okay.
Cool.
Here we go. We'll start over.
Madam County Attorney, I'd like to nominate Alyssa Gay for that position.
All right, Ms. Gay has been nominated by Commissioner Sadiq. Any other nominations will go to Commissioner Ron.
I nominate Richard Bedford.
Commissioner Ron. Commissioner Ron has nominated Mr. Bedford. Commissioner Ballard.
You can remove me from the list. I was going to nominate Alyssa Gay.
Okay. Commissioner Cruz? Any no- Commissioner
Oh,
Cruz?
sorry, my thing was closed. I'm nominating Matt Bauer.
Commissioner Cruz has nominated Mr. Bauer. Commissioner McCann.
I'm going to nominate Bruce Stam.
I'm sorry, can you repeat the name?
Bruce Stam,
Thank you, sir.
S-T-A-M.
Thank you, sir. Mr. McCann has nominated Mr. Stamp. Commissioner Bearden.
I'm going to nominate Trent Wyman.
Wayman?
Wayman, I'm sorry.
That's okay, sir. Commissioner Bearden has nominated Mr. Wayman. Commissioner Phelps.
Glenn Gibolina.
Commissioner Phelps has nominated Mr. Gibolina. So I'll call for any other nominations. Seeing none, I will close nominations. At this time, the commissioners can engage in debate. Why don't we clear the board and
All right.
Deathmatch.
Can you clear the board?
I don't have control.
I
don't
know, but
think.
I'm asking them if they can.
Okay.
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 And log back in.
I noticed Mike didn't clear the board, he just left himself on the top.
I'm asking those guys to clear the board, man.
Okay. First on, all right. First on the board is Commissioner Ballard.
So I think that Alyssa Gay would be an excellent addition to our Planning Commission. She's a local business owner. She's a Manatee County native. She's a District 1 resident. She has lived in Manatee County her entire life. She's a multi-generational Manatee County resident. She was named to the 35 Under 35 by SRQ Magazine, 40 Under 40 by Business Observer Magazine. She was a candidate for House District 72. During that candidacy, she prioritized environmental issues, conservation issues. She is whip smart. She's dedicated. I know that she would do an excellent job on our Planning Commission.
Commissioner Cruz.
Yeah, I mean, this was tough. There's 26 people on this list. I know a good portion of them. I know every single person who's been nominated, and honestly, I like every single person that's been nominated. So this is tough for us with this many people on an important board. But And I like, and I like Richard as a person, but I'm going to guess based on the will of the board, there's a chance he's not going to make it, which was Chairman Ron's nomination. And then what we're going to have here is a planning commission with very little experience. No offense to the planning commission people. I love the planning commission people, but Paul wasn't nominated, and Richard may not get through. We're going to have a very new planning commission, much like we have a new board up here. We need some direction on that planning commission. I've heard from one of the sitting planning commissioners, they were concerned there would be some institutional knowledge loss due to how new they are. I think with Matt Bauer, we have a unique situation where we have somebody who has a similar mindset on development, not anti-developer by any stretch, but considerate, common sense development that this board is looking for, while having also served on a planning commission. He comes with experience and skill sets on a planning commission that's in some cases lacking on that current board, especially if the two sitting commissioners right now are not reselected. So it's a unique opportunity. We all know Matt. I think he did a great job, and he almost did too great of a job, and this very same people that try to get some of us off of this board were the people who took him off the board last time because he considered their developments based upon the will of the people. I think Matt's a great option, and I know two people nominated Alyssa, and I'll tell you, if those two people voted for Matt, I would vote for Alyssa. I'm just going to throw that out there.
Commissioner Siddiq.
Appreciate it. I'll cover a few things Commissioner Ballard did not. First of all, I've gotten to know the vast majority of the candidates that applied, and I really appreciate everyone, if you're listening, watching later, putting in the effort to answer these questions. I think as someone that has had news reports written about my attempts to apply to boards, I really appreciate the effort people put into those, because it's a great way to get involved in government and just get to know how things work. Planning Commission is a very important one. I just want to highlight that we need to have very effective boards. Planning Commission, as our lively debate this morning showed, is a gateway to a lot of the issues we see here. And as Matt Bauer said earlier, change is good. I nominated Alyssa Gay for a few other reasons. One, I will echo Commissioner Ballard on this. She's born and raised here in native Manatee County. She's our age, and I'd love to see a new generation of people on all boards. Frankly, that was a promise that I'd made on my campaign trail. I made that promise 2 days ago, and I intend to fulfill that promise here and in other ways as well throughout the county. But some other things I really enjoyed. She was a Leadership Manatee grad, so am I. The importance of that that is important because that gives you a great perspective on the entirety of Manatee County. Commissioner Cruz is also a graduate. He can tell you as well. You get to learn about everything in the community, from agriculture to industry, county jail to the education system to how the hospital system works. So it's a heck of a great perspective to have on that board. I will counter what Commissioner Cruz said earlier. I do think, as someone new on the board and as someone that's come from the tech industry, the exact opposite of government, the exact opposite of land use and planning, I think I've been able to spar pretty well with my new colleagues. And so you can get up to speed pretty quickly. I think she'll do a great job of that. And I'm looking forward to seeing some great folks be a part of the next round of nominations. So that's all I got to say.
Madam Attorney.
Sorry. Commissioner Ron.
Thank you, Madam Attorney. Where I'm coming from on this is that the Planning Commission is a big job, and you need to have experienced people on there. Past Commissioner Bauer does have that experience too, but we need, the current commission has, the chairman has applied again. He has a wealth of knowledge, not just institutional knowledge. He has institutional knowledge on how the comprehensive plan works, how land development codes work, and that's what we do. 75% of what we do up here is land use. So you need to have a person on there that can lead. He does lead very well, interacts with staff really well. He knows the processes very well. He knows how to understand how the land development code, the comprehensive plan move us forward. He's been in the business a long time. He's been a part of this community a long time. In fact, he chairs the Chamber of Commerce's Transportation Committee. So he understands transportation, he understands the land development codes, understands the comprehensive plan, understands the needs of Manatee County. And I would like for him to remain on there. Speaking with the other commissioners there, they like him, they support him, and they elected him chair. So I would hope that we would cast a vote for Commissioner Bedford to stay on the Planning Commission. Thank you, Madam Attorney.
Commissioner McCann.
Well, it was definitely time for a new board. So now it's time for a new planning commission. The planning commission, I looked at each one of the planning commission's recommendations on everything we had here today. It was 5-0, 5-0, 5-0, no public comment. I would like to see some new blood on the board too. And, I think Bruce Dam is ideal for this. He has 12 years of service on zoning and hearing boards in Pennsylvania. He's very well known in the community here. He helped a lot of people here get elected. He is now the president of the Lakewood Ranch Republican Club. Since he's moved down here, he's been very active in Republican politics, and he has a master's degree in business administration. He knows the issues. He's worked for many of the commissioners that are sitting on his board right now, and I think that, he would make a fine addition there because he understands exactly what was going on with the Building and Zoning Committee. He understands the land, and he understood the need for change, and he's one of the reasons that I'm here right now. So again, to keep the status quo on the Building Committee would be a major mistake.
Commissioner Bearden.
Thank you, Madam Attorney. I think that we see kind of what's kind of going on here. Here in the conversations, I don't feel as if Trent is going to get the votes. So what I'm going to do is I'm going to also support Bruce in this measure because I just don't feel that I'm going to have the votes to be able to get Trent in. So, and I don't know if we'll have the votes to get Glenn in as well. So I want to go ahead and just say, I think Bruce would make a great addition. One thing that I'm tired of seeing, like everybody else on this board, is I'm tired of seeing a 5-0 vote from the Planning Commission because it doesn't necessarily give me details on why somebody would oppose a vote, right? And I think that information is so important for me to help me make decisions moving forward because I do look and how the Planning Commission is voting on every item. So, so that's all I have. Thank you, Madam Attorney.
Commissioner Feltz.
I think that we have an outstanding and a large amount of people who've applied for the Planning Commission. I'm especially thrilled with all the people from District 1 that applied. That kind of tells you something about where we're at in District 1, and that we have people in District 1 that want to take a much more productive step in being part of their community's planning. If it was up to me, I'd probably change a lot more about the Planning Commission than just the 2 seats that we have, so that they were more reflective of the new commission that has been elected. I hope that our Planning Commission takes into account a more vital interest in planning for the future than just going through the motions on that. And we've had some good people on the board. We've got some good people on there now. I realize Mr. Gimbolino is well-known, and I figured we'd put him to work. But we've also got some good candidates, and it was a tough choice for me with the number of candidates in District 1 that I appreciate coming out and trying to speak up. But we've got some good candidates, and hopefully we will continue to have a planning commission that reflects the direction that the board is also taking at this time.
Commissioner Bearden.
Thank you very much, Madam Attorney. I'd also make a deal. I mean, if we could support Bruce on this, I think that we'd have 2 votes over here to support Matt to get on the Planning Commission as well. How do you feel about that, Commissioner Cruz?
Look, I Texas Hold'em, man.
I'll be entirely honest. I went through everybody, and like I said, I know a lot of these people. A lot of these people are qualified. There's so many of these people that will come on this board and do a great job. But in all fairness to everybody, I walked in here and my best case scenario was Matt and Alyssa. Those were the two I literally walked in with that I was hoping for. So I like Bruce. If Bruce gets the votes, I will be more than happy. I'll be the first one to call him and congratulate him on being in there, and I'm looking forward to seeing him on the planning commission. But I walked in here with those two. If one of them doesn't win, then I hope Bruce does, but I'm sticking with that just because that was my gut when I walked in this morning.
No one else is on the board? Okay, seeing no further debate, we will proceed to voting at this time. The rules for voting will be each commissioner gets one vote, and we shall vote in the order that nominations were made. All in favor of nominee Ms. Alyssa Gay, please raise your hand. We have Commissioner Feltz, Commissioner Cruz, Commissioner Siddiq, and Commissioner Ballard. 4 votes. All in favor of Commissioner I'm sorry.
Are you thinking someone's going to get 5 votes?
We have to go through the procedure. We have to go through the procedure. All in favor of nominee Richard Bedford, please raise your hand. Did a hand go up or no? Oh, okay. Chairman Ron, cast 1 vote for Mr. Bedford. All in favor of nominee Matthew Bauer, please raise your hand. Oh, we've got 5. We've got 5. We've got 5 votes. We still need 2 people to vote.
Yeah, but it's already done.
I know, but okay.
It's a 4-0 vote. It's over with.
Okay. If you want to skip it, we can, but technically, we're supposed to see where those votes fall because we're going to go through another nomination process. So, any votes for nominee Matthew Bauer? Raise your hand. Seeing none. Cast your votes for Mr. Bruce Stam. Raise your hand. Okay. We don't need to vote for the other 2 because all votes are exhausted. So the nominee is, and the congratulations go to Alyssa Gay. Now we will move on to the second seat, and we call for nominations for the second seat.
I thought we said we were doing nominations.
Same
And then we were just voting the whole thing.
We were doing nominations 2 times.
See, I was right.
Okay.
2 separate sets of nominations.
I'll get the hang of it. I've only been here
Sorry.
for 4 years. I've never had 26 applicants.
If we did it all that way, we would have just had you vote all at once, top 2. But second set of nominations.
I nominate Matt Bauer.
Commissioner Cruz nominates Mr. Bauer.
I nominate Bruce Stam.
Commissioner McCann nominates Mr. Stam.
I'll nominate Bedford.
Commissioner Ron nominates Mr. Bedford. Any other nominations for the second seat? Seeing none, we will close nominations. Does any of the board wish to engage in debate?
I think we got that.
Just checking, just checking. All right, at this time, we will call for the vote. And we'll go in the same order. Each commissioner gets 1 vote. All in favor of nominee, Mr. Matthew Bauer, please raise your hand. Commissioner Feltz, Commissioner Ballard, Commissioner Siddiq, and Commissioner Cruz, 4 votes for Mr. Bauer. All those in favor of nominee Bruce Stam, please raise your hand. Commissioner McCann, Commissioner Bearden, 2 votes for Mr. Stam. All those in favor of Mr. Bedford, 1 vote. Commissioner Ron.
It was over at Bauer.
So congratulations to Mr. Matt Bauer.
There you
You
go.
have your 2 nominees.
Congratulations, Matt. You're back on it.
Is there anything else we need to do?
We have
Historic
another.
Preservation Board.
I will tell
I
you,
meant for this item.
I will
Yeah.
tell you, though,
Thank
Matt and I served on the planning commission together. He'll be a great planning commissioner. We had a lot of debate back and forth when we both were on it, but I always respect his opinion. He's a smart guy, and he'll do a good job while he's up there, so welcome aboard.
Okay. So that concludes item number 28. We can move on to item,
You got something. I don't like tech people that can manipulate.
He's got AI
No,
going on.
I put my name on this board before we started the planning commission thing after I realized what you
He's
guys
got
do with
AI
planning
on
commission.
going
He still
on.
ended up ahead of me.
Oh, we're gonna have some fun.
All right. Madam Attorney, you're up again.
well, this is
Item number 29 is Historical Preservation Board appointment, and we have 2 open seats, and only one of those commissioners is seeking to be reelected, which is Craig Fisher. And there's about 10 applicants.
All right, Tal, since you manipulated it, why don't you tell us who you want?
Changed? I don't have this. All right, is it the pleasure of the board to proceed with voting in the same fashion, or would you like to modify it?
We're just
Same.
winging this.
Okay. All right.
Same way as well.
Same way. All right. So we will open up the floor to nominations.
Madam County Attorney, I'd like to nominate Kathy Slusser for Historic Board.
All right, nominee Kathy Slusser has been nominated by Commissioner Siddiq. Any other nominations?
I have the exact same nomination.
I have a nomination.
Commissioner Ballard?
I'd nominate Phil Travis.
Okay. Mr. Philip Travis has been nominated by Commissioner Ballard. Any other nominations for the first seat? Seeing none, we will close nominations. Would the commissioners would like to engage in any debate?
I mean, honestly, if there's only 2 nominations, I can just change him to the second seat.
Okay. If
Yep.
if it's the pleasure of the board to have nominations for both seats all at once and vote for both seats all at once, we can do that.
Might have a procedural issue.
I don't know, Phil, I was gonna say Craig as well, but Kathy's my first choice, so I didn't want to muddy the waters in the first round, but let me hear the debate first. Why don't you tell me why you picked your person, and if I like what you say, then I'll just say, okay.
Sure. So Dr. Travis is a professor at SCF. He has a PhD, longstanding history professor and author, came highly recommended to me by Tommy Gregory, president of SCF.
Okay, I'm okay with these 2.
So is it the pleasure of the board to have one set of nominations for both seats?
We only have 2 names, and I think Craig has done an admirable job on this board. I mean, that sounds like Amanda did more homework than I did. Sorry, Commissioner Ballard.
I'm
did more homework.
here. Okay, hearing no objection from the board, we will have nominations for both seats at the same time. Any other nominations? Hearing none, we will close nominations. If the board wants to engage in any debate, we should do so now. Commissioner Feltz, are you on the board?
No, never mind.
I'm sorry.
Again, do we have discussion after, or I had my hand up to speak, but I wasn't.
Go ahead.
Please,
May I?
please.
May I? Can anybody tell me when the last time the Historic Preservation Board had a meeting and what they did and the agenda on that and what they do?
They have 4 meetings a month, or 4 meetings a year. They're required to be a certified local government. Their last meeting was December 3rd.
Bobby, can you talk to your
December
mic, please?
2nd.
Can you talk to the microphone?
ma'am.
We can't hear you. Pull-
And their last meeting was December 2nd.
Let me just make it this quick because we've accomplished what we needed to do here. As you're aware, we've talked probably about a year ago. We talked about our citizens advisory committees. We've had some discussion on that, and Commissioner Cruz and I had talked when I was Citizen Carol, but we have our county administrators around somewhere. I believe at last count, we were at 19
Correct.
citizens advisory committees.
That's correct.
And the reason I've asked, we actually have 2 historic preservation committees, kind of on the same thing. But I'd like to know, have any of you who are we have some great candidates, great nominees for this. But one of the things we've talked about is actually utilizing these citizens advisory committees as part of our policy and procedure. When I was asking for an appointment on the LMAC, I went through and did kind of my own audit on all of our citizens advisory committees. And I don't think any of us really know or have been involved with what they do and who is on this committee. This particular board, I would like to see, would anybody like to tell me what they do, what they've done in the last year? their last meeting, and remember, when we do these meetings, and it's something that Mr. Bishop and I have had some conversations on, if we're going to take the time, our time up here, to make these nominations to these committees. Now, the Planning Commission is a little bit different, but we're taking up space, time, meeting minutes, agendas being discussed, and I want to ask you, as we've made our nominations to this committee, have you ever attended an Historic Preservation Board meeting?
Point of
Can
order,
you
Mr.
tell
Chair.
me-
Madam Commissioner Phelps,
I understand.
I don't
But I'm
know if
making
that's
a point
germane
that
to.
these are not positions that we're just awarding people to.
Asking the board if
We
we've
need to
attended
be
the
a
meeting,
little
no, it's
bit more
not
serious
germane.
about what our citizens' tax dollars are paying for, and not just
These
throw
are,
out
they're not paying for anything, these are
titles
volunteers.
for anything.
But.
We are
this is-
taking up space
ma'am-
and
Ma'am,
county
this
staff
is not
in
germane
minutes.
to an appointment right now. If you would like
Want to throw me
to,
out since I'm not being germane?
this is not, we're looking to appoint, you're asking
You made a
all of
point,
us.
but you're just appointing people, and you can't even tell me what this committee does or what they have done, but you're appointing people to it.
you know,
Thank you.
So, if you'd like to have a discussion on this
No, no,
after,
no,
after we
I'm
move
done.
this board
I'm
forward,
done.
I have no
made my
problem with
point.
that.
I made
But
my
right now, we
point.
want to get through the
I'm done.
nominations, so thank you very
Done.
much.
Just to calm things down, just to clarify, in Robert's Rules of Order, when a motion's been made, you need to have the discussion based upon the motion.
Yep.
While these are nominations, not formal motions, the nominations themselves effectively constitute motions on the floor, and the discussion should be about the nominations being made. We have commissioner comments after this meeting, and people can, you yourself and every commissioner can bring up any topic you wish to bring up, as well as on January 7th, which is a strategy session, which would be an excellent time
Thank
to
you.
discuss better utilization of our advisory committees.
Excellent.
Madam Attorney, can you get back to the?
Is there any
Yeah.
further debate on the nominees?
No debate on the nominees, but back to Robert's Rules of Order. Since she's the chairman, nobody else should be speaking without her permission.
She's not the chairman. I'm still the chair, sir. I've assigned her to run the nominations. That was it. I'm still the chair. Thank you, sir.
Mr. Chair, at this time, I would recommend that we move to public comment on this issue. If anyone from the public wishes to come forward to be heard on this matter. Ma'am, please state your name, and you have 3 minutes.
I'm Kathy Slusser, and I'm a resident of Manatee County. I just wanted to say I appreciate the nomination. I am retired from the Clerk of Circuit Court's office for 36 years. I was the Director of Historical Resources and also an alumni of Leadership Manatee. But I'm hopeful that you will select me to serve on this Historic Preservation Board. I was instrumental in helping to get the board started, to write the ordinance for the Historic Preservation Ordinance, and I'm excited about the opportunity now as a civilian, now that I'm no longer employed, to help to continue to preserve Manatee County's history. So thank you.
Anyone else in the public who wishes to come forward to speak on the nominations? Seeing no one, let's go to the phones.
No hands raised, Madam Attorney.
At this time, we will close public comment, and now we will call for the vote. Each commissioner gets 2 votes, since we are filling 2 seats. There are 2 options. All those in favor of candidate Kathy Slusser, please raise your hand. Commissioner McCann, are you voting, sir?
No, I'm going to abstain.
Sir, by law, you are required to vote if you are present at a meeting, unless you have a voting conflict that you can register lawfully. All the vote is 7.
It's a hand up. It's a hand up. It's whatever they say.
The vote is
That's fine.
7-0. Thank you. I'll recite it.
What if you recognize the utility of like?
If someone is absent, they are not expected to vote. So the vote is 7-0, unanimous, in favor of Ms. Slusser. Congratulations, Ms. Slusser. At this time, we'd see how many, cast your votes for candidate Philip Travis. Thank you very much. The vote is 7-0, unanimous, in favor of Philip Travis. Thank you very much.
All right, Madam Attorney, thank you very much for guiding us through that, both those processes. We appreciate it. Congratulations to all the folks that got appointed to the various boards. I know they'll do great jobs for us. Right now, County Attorney, you have any other comments?
No, Your Honor. Oh, no, sorry. Sorry, I feel like I'm in court.
I know you do, I know you do. You're doing a great job. Ms. Knapp, you have any,
No, Mr. Chair.
you have any? Okay, there's no commissioner agenda items.
I have a comment.
You want a commissioner agenda item or just comment?
It's both. Remember, I said in the email, because this is the last meeting where we can speak under sunshine, I had Mary Ann print up the world's smallest font list of what I said. Here, we just pass
You
it
got
down.
mine, right?
Yeah.
George, you got mine.
You will. I sent out the finals.
Okay. Oh,
Like last night, because you guys, look, we do, just to let everybody know in the public, we as a board are required to sit on approximately 20 to 25 seats. We have to fill them by state statute or by, just to have a voice for Manatee County. So every year, the chair selects who sits where. This year, I want to make sure it wasn't politicized, so everyone had an opportunity to respond with their preferences based on their skill sets, and last night I put them together. These usually happen in January, but I figured you guys were so prompt at getting back to me, I wanted to be equally prompt with you. Usually just the chair says, here's where you are and here's where you are for the year, but because it was done so quickly and we had this meeting today, I at least wanted to give people the opportunity in sunshine to, if somebody, like for instance, if Amanda wants to be on Career Source and Tal doesn't care, then I don't care if you guys flip. There's no pride of authorship on this thing. I'm not going to flip the whole thing around, but if there's somebody who really, really wanted something and wants to ask somebody to flip, I'm okay with it. Since we're in the sunshine, we can have that conversation. Once we leave here today, I'm going to go tell all of your aides, these are the finals, send the emails out to the respective boards and put them on your calendars. But I think I caught everybody's skill sets, try to get everyone's priorities that you presented to me. So I think this is a pretty good list. I tried to do it in a fair and equitable way. I kind of even took myself off of my #1 board because I thought it was the right thing to do for the good of the citizens of Manatee County, and I think we should be doing everything up here what's in the best interest of the citizens of Manatee County, and less so what's in the best interest of us individually. So I do think this is a good list, but if you have any comments about it, I'll happily listen.
I think it's a great list, but thanks, George, for putting that together. Appreciate it.
Yeah.
Yep, much appreciated. I think it's a great list.
All right, perfect.
Yeah, appreciate that.
Thank you all. Honestly, I told you guys by like next Friday, and when Dana told me they all came in yesterday, I jumped on it last night. I appreciate you all.
All right, is there other, does anybody else have any other comments? All right, what I'd like to do under commissioner comments, being that this is my last official board meeting, I would just like to thank this board for allowing me to serve as the chair this year. It's been an honor to serve the citizens of Manatee County. I think we have a good solid board going into 2025 and going out for the next several years. I look forward to Commissioner Cruz and serving with him and lending him any assistance I can. And I'm going to do that right now. Here's the cheat sheet for the quasi-judicial during the meetings. So if you need this cheat sheet, it's all yours now.
To be fair, I've been here long enough that when I first got here, we had one of those in front of every single person on the dais, so we all knew what was going on.
So-
Which is actually something I intend to do next year, because when I got here, every single one of us had a laminated thing, so you saw the order of land use, so you knew what order. we were
I
going.
had one when
And
I was on the
gonna put them.
planning
I was gonna
commission,
put them back
I
next year. So
appreciate
it's
it,
funny
but-
you put that up.
George is going to do a great job as chair. I look forward to him being in this position, and I think we're going to do a lot of great things in the next several years. So, and I appreciate everybody's support, and thank you very much. And I'm going to the port. And y'all are the Port Authority too, so be ready for that. And the Port Authority's coming up here very shortly, and there'll be a luncheon and everything afterwards, so.
Yeah, let me say, as the third vice chair of the Port Authority, I will improbably be chairing the meeting on the 19th. Can you believe it?
Wait, what?
Yeah.
I'm the, I don't think so
I'm not
either.
So
sure
you're
yet.
not here next?
So yeah, as the third vice chair, I will be chairing that meeting, and I get to like.
Are we gonna have quorum though?
Yeah.
I think we should.
Who's all going? I mean,
I'm going.
So it was.
I'm going.
It
Al's
was.
going.
They have the best fried seafood.
And
there.
that's the other thing. I get to make some of the
It's all
comments at the
seafood.
luncheon and everything.
So, all right. If there's nothing else for the good of the order?
Oh, didn't Commissioner Siddiq have comments?
I'll be brief. Kathy would know this, but there's just to address your comments, Commissioner Phelps, I did my research on the Historic Preservation Board and the Historic Commission Board, because I care a lot about local history, and this is a plug for the Carnegie Library, check it out. Literally held the first meeting notes of the very first county commission from 1856. It's pretty awesome, check it out. But the distinction is that one of them, so the Historic Preservation Board is focused on, preservation of artifacts, buildings, documents, et cetera, throughout Manatee County. I don't know the exact history of it, but the other commission, the Historical Commission, which I believe is chaired by the clerk, no, it's not. Well, maybe the website should be updated. But I know the clerk is involved in that one, and that one is specifically focused on Manatee Historic Village, so there's a bit of a distinction there. I did have the same thought about why do we have two different historical commissions, but like you said in the very first meeting, for every simple question, there's a very complex answer behind the scenes for it. So I don't want to go about chopping up our boards, but you did have a great comment. I just wanted to address it.
I just appreciate that, and I think we all want to make better use of our citizens advisory committees and give them a role in part of our policies and procedures here instead of just a title. And we have a lot of things that they can help us with and they can do. And we want that to, I'm not. But thank you.
It was on, it was too high up.
Thank you, Tal. I appreciate that.
I think that's a really great point, and maybe we should have some of our boards, our advisory boards make semi-regular presentations to our board.
Just to let you, there's a lot of things in fact, I have lots of meetings next week with Pam and Charlie and Bobby. I'm making a number of changes to how the agenda is structured to create more voice for the people in terms of public comment, whatever. One of the things I'm doing is with advisory boards. We can go into more detail later, but the two.
I've talked to you about since I was
But two of the things I'm doing is all of the cover sheets for all of our agendas, for all the items, are gonna have an applicable advisory board section on it, and if anything that is being brought to us is applicable to an advisory board, like affordable housing or animals, the question is going to be, did you discuss this with or present this to the advisory board first? Second, towards the beginning with commissioner comments, I was going to put a block on the agenda for advisory board representatives, and so any advisory board could email in and say, we would like 5 minutes, and they can each have a spokesman to come in and present whatever they've been talking about to the board on a public meeting. That's going to start in January as
Great
part
idea.
of some of the changes.
Excellent idea.
Great idea. And I think they do it in Sarasota, don't they?
Well, they have a lot more boards than we do.
37. All right, is there any other thing else good for the order? All right, we stand adjourned. Thank you all.